Whoops. Oh, God. Oh, God. Oh, God. We're off to a great start. We're off to a great start. For some reason, you guys, I always forget to put my headphones in before this stream starts. Like it never fails me. So we clearly have it together. And with that now done, hello. Welcome. My name is Lacey Jane. This is Criminally Confident. And today is Wednesday, January 7th. And we are there, baby. We have reached the end. It's like we have been climbing, trekking the Appalachian Trail. And we've finally made it to the cars. And I'm so thrilled that you guys are here. It's probably going to bring in a bunch of like hiking people. I love that you guys are here. I love for that a lot of you guys have been here this entire time. I so greatly appreciate you. And if you could, I would love it so much if you could please make sure to hit the thumbs up button by giving me a like, and make sure to hit the subscribe button, because we have almost we hit over 500,000 views in 28 days, and we almost have 1,000 more subs in 28 days. And that's just like, that's wild, man. It's wild. So with that being said, I want to go ahead before we start and thank my mods. Hello, mods. I think Maybe's in here. She's in and out. But thank you guys for your assistance. Let's get this together. All right. So, what's going on? How do we feel about things and stuff? It's a crazy world today, per usual. Oh, I actually wrote down the streams. And I would like to start off with a really special one. So let's go ahead.
Federal regulation. Does Gentiva, in the regular course of business, compile data such as
email? 5, not a 7. Okay. Not the unaliving letter that I believe that is. Okay. You guys are gonna.
That would be all the testimony that's available to us today.
Let me get this out of the way.
We'll have probably tomorrow morning, and then we anticipate being done. Okay. Thank
you. Ladies and gentlemen of the jury, this concludes the presentation of evidence for the day. Let me give you an update as best as I can tell you where we are. At sometime tomorrow, we will conclude, hopefully, which I think we will, all of the presentation of evidence in this matter. And it is my hope on Saturday morning, you will hear the final summation by the state of Florida and the defense in this case. And sometime on Saturday afternoon, I will instruct you on the law. And then you will begin your deliberations.
Instruct you on the law.
As we recess for the day, I remind you of all of the previous admonitions that I've given to you. Please have a restful evening.
Get out of there. Go. Bye. Scram. Oh, God. I forgot to tell you guys
about you may be
the dentist thing.
The attorneys will be excused shortly. There's a matter that we need to take care of. You have the photograph.
What possible matter could be going on?
As soon as it is convenient to bring him forth. Okay. Yes, you may. We'll be at ease. Okay, sir, would you state your name and age?
My name is Matthew Bartlett, and I'm 28 years old.
Mr. Bartlett, I'm going to have the
Solid gold.
court deputy show you these 3 pictures, which will be court's composite exhibit 1. You recognize the individual contained therein on that photograph, sir?
Yes, I do.
Okay, and who is it?
This is me.
And what is that symbol that you are projecting with your fingers?
Using my middle finger, and I'm sorry.
Okay, and what does that mean, sir? When you extend one's middle finger,
The F word to someone.
what does it mean to you, sir? Not to some, but to you.
No, to use the F word to someone.
And who were you extending the finger to, sir?
Mr. Ashton.
And what was Mr. Ashton doing at that time, sir?
I don't even know.
Court was in session, was it not?
Yes, it was.
Now, you see this sign?
Yes, sir.
And does not this sign read any gestures, facial expressions, or audible comments showing approval or disapproval during a court proceeding is absolutely prohibited? That sign is posted on the door outside, is it not?
It is.
Okay. How far have you gone in school?
12th grade.
Can you read and write?
Yes, sir.
Did you not read this sign, sir?
I have read that.
And when you came in this morning, did the court deputy give you the benefit of reacquainting you with the ground rules in this proceeding about gestures, expressions?
Yes, sir.
What do you recall that court deputy saying?
There shall not be any gestures or facial expressions.
Was there anything about that that you did not understand, sir?
No, sir.
It's pretty clear cut, boy.
Yes. Sir, pursuant to Rule 3.830 of the Florida Rules of Criminal Procedure, could you tell this court why you should not be held in contempt of court for failing to comply with posted signage and directions that were given to you orally, which this court ordered posted and required that the court deputies advise you orally why you should not be held in contempt of court for gesturing by pointing your middle index finger, which you told us is the F word, to Mr. Jeffrey Ashton, who was at the podium at the time in open court while this court was present. Can you tell me any reason why you should not be held in contempt of court, sir?
I'm truly sorry for doing this. This is something stupid, and I'm not sure why I even did it. And I just apologize. I don't understand why I did it.
Well, there was a reason why you decided to extend Mr. Ashton the courtesy of flipping him your index finger. Was he saying something that you disapproved of, or did you think that highly or lowly of Mr. Ashton?
I don't think lowly of Mr. Ashton.
Well, what did he do to deserve the middle finger?
This is just some stupid thing that I did, and I do apologize.
You recall, sir, whether or not the jury was in here when you decided to extend that courtesy to Mr. Ashton?
Yes, they were.
You know what would have happened, sir, if some of the members of the jury had seen you extending your middle finger of affection to Mr. Ashton?
No, I don't know.
Sir, would you care to present any evidence of excuse or mitigating circumstances at this time before this court imposes sentence?
He sounds like he's gonna get his head cut
Can you
off.
repeat the question?
Would you care to present any evidence of excuse or mitigating circumstances that you would like this court to take in consideration prior to the court imposing sentence in this case, sir?
I just apologize for doing something like this.
I'm so
This is
sorry.
just some stupid thing that I did.
Sir, have you ever been convicted of a felony or a misdemeanor? involving dishonesty or moral turpitude?
No.
Moral turpitude.
Are you employed?
Yes, sir. Yes, sir.
And where do you work?
At TGI Fridays.
And which Fridays is that?
That's at Millennia.
He doesn't have a job anymore after this. It's not funny.
And what do you do there?
I'm a server.
Laugh.
Okay. Anything you would like to say before this court imposes sentence?
I apologize for doing this.
Young man, do you realize that the taxpayers of the state of Florida has expended a great deal of money in putting on this trial, and that your actions may have jeopardized or could have jeopardized all of the work that the attorneys have done in this particular case?
Blame it on the kid.
Yes, sir.
And one of the reasons I had those signs posted and why the deputies give those remarks every day is I don't want to assume people know or should know what the proper decorum is in a courtroom. Where do you live, sir? You don't need to give me the address, but do you live alone or do you live with your parents?
I live alone.
I live alone.
At this time, I will adjudge you to be guilty of the crime of direct criminal contempt.
Boys being boys.
I will sentence you to 6 days in Orange County Jail, impose a fine of $400 along with the applicable statutory court costs. Sir, how much time will you need to pay the fine?
How much is the fine?
It'd be $400 fine, and Madam Clerk, what would be the approximate court cost? Misdemeanor. Be $223.
He ain't gonna felonize him.
I could pay it immediately.
Okay, I will give you 6 months to have it paid. You can pay it all at once.
Okay.
Madam Clerk, divide that total up in 6 months, starting August the 1st, in equal installments for a period of 6 payments. Sir, they will get some additional information from you, such as your address and date of birth, because I'm going to need all of that to put in the order.
Okay.
Sir, you have a right to appeal the judgment and sentence I've just rendered in your case here today, provided you file a written notice of appeal within 30 days of the date with the clerk of the court.
Can't do that.
If you cannot afford the services of an attorney to assist you with the appeal in this matter, the court will appoint one to represent you. Bearing those rights in mind, sir, do you wish to appeal?
Yes.
For purposes of appeal, sir, raise your, well, you can't raise your right hand right now. You solemnly swear that testimony you're about to give in this cause will be the whole truth and nothing but the truth, self you God.
Yes, sir.
Where is it? There it is.
What is your annual income, sir?
My God.
Around 15,000 a year.
Okay.
Oof.
How much are your average monthly expenses?
They are around 1,500.
Okay. How much money do you have in any savings or checking account?
I've got $160 in checking and about $12 in savings.
Okay. Sir, do you have any personal property, stocks, bonds, or anything else, or real property that has a value in excess of $4,000?
No.
Okay, for purposes of appeal, I will appoint the office of the public defender to represent you for purposes of appeal. He will be remanded to the custody of the Orange County Sheriff's Department for transportation to the Orange County Jail. You're going to need to hold him here for about 45 minutes to an hour so I can prepare the necessary order. He will be remanded. You want to take him? Okay, are there any other matters that we need to, where are the photographs? Okay. Photographs will be an exhibit along with, make a photocopy of the sign. After that, you can return the sign to the court deputies that have it posted back on the door. Okay, are there any matters that we need to take up? I think y'all have some additional work to do. Okay, well, I will
Okay.
be here for a while.
I only watched like the first couple minutes of that. I thought he was just gonna get like a stern talkings to. I really didn't realize that he had to do time. And did he even do time? Did he appeal it? Did he get out on bond? I'm assuming that's what happened, but that that is a good enough reason not to, I'm just going to say it, fuck around and find out. You don't want to know if he's kidding or not, in my honest opinion. So yesterday we did a little bit of Roy Kronk. Thank you. He was the guy that found the baby's head and used a walking stick to pick it up by the eye socket, which is just absolutely horrific. With that being said, I didn't find him to be very interesting, I think is the word I'm looking for, to listen to. So I would like to do the dude's coworkers just to give you an idea of what happened, because I think that's important for context.
It would be this one right here.
Okay. And were you
And-
meeting?
yeah.
Were you reading meters that day?
Yes, sir.
Did there come an occasion when, on the 11th, when you stopped off of Suburban Drive with some coworkers?
Yes, sir.
Who was there?
Please
One of my
make sure to
coworkers that I
like
was training,
stream
and Roy Crump.
and subscribe. Thank you.
And why were you there?
I was asked to go help Roy out and assist him, and then we stopped there just to rest before we headed back into the office.
And was actually, I'd like to show you a map.
He flipped off the camera, and you can't do that in the courtroom. Freedom of speech or not, it's a
I'd like to show
private
you,
place, public.
Defense 57. May I approach?
You might.
Actually, can you step down to show us where you park?
And I'm a freedom of speech absolutist, like to my core. You just can't do it. It was a stupid kid doing something stupid. You know, that's what it boils down to. So this guy is one of the meter readers that was working with the
Can you
weirdo.
step over here because you're
You're
kind of so
welcome.
the jury can see. Do you see this location?
Yes, sir.
Can you identify
girl.
Suburban Drive?
It would be this one right here.
Wow.
Okay. And can you identify Hope Spring Drive?
It would be this one right here.
Where did you guys park?
You're here,
We
Peggy.
parked
Hi.
right in about this location right here. Yeah, about in this location right here.
Okay. And how many trucks were there?
There was two.
Okay. Whose truck was where, if you can?
Okay, my truck was pointed this way, and Roy's truck was pointed that way.
Nabbit.
And how many of there were you?
There were three of us.
Okay. And what happened that day?
This is the sloppy.
Well, we went to assist Roy, and he had a couple meters left, so we went down here to the master meter for the school and the lift station across from it. And then afterwards, I said, let's go down here and park under the shade over here before we go back in. So about 35 minutes before we have to head back in. We haven't taken our break yet. So we headed down there just to hang out in the shade a little bit.
And what was going on down here?
Drink some orange juice.
I guess that's where the Anthonys live, and that's where all the media was and everything, I guess.
Now, while you guys were parked here, you were aware of all of the media activity here?
Oh, yes, sir.
Okay. And what did you guys say about that stuff?
Sustained.
I'll rephrase the question. Did you discuss the media?
We didn't discuss the media, no.
Did you at any time say to Roy anything about this area here?
Hey, buddy, want to go looking for
Yes.
illicit
At the time,
in the woods?
when we pulled up there, I told him that I felt that the little girl's body may be in this swamp here somewhere.
Okay. And what happened after that?
Well, Roy, we were talking, and then he went into the
Yep,
swamp to use the
buffalo.
restroom.
You are right.
And then what happened next?
When he came up, we were standing there in the back of my truck, and then he walked along the line of the bushes and everything, looking down inside of it and everything.
Did he advise you that he saw anything?
Yes, he said he'd seen a skull down in there.
And then what did you guys do?
Well, I said a skull. I said, well, got to go look at it and check and see if he's seeing something correctly.
And then did you go look at it?
Well, I was heading that way before I almost stepped on a big rattlesnake.
Okay.
Everything.
And was the snake alive or dead?
No, it was dead.
Okay.
Everything.
And did you find the snake more interesting than the skull?
At that time, yes, I did.
Okay. Did Mr. Kronk try to draw your attention more over towards the skull and away from the snake?
No. After I picked the snake up and put it in the back of the truck, he left and came back over to the truck. And that's when I figured that maybe he was just joking with us. He wasn't serious about it. Because if you're serious about it, you would keep telling us to come over.
And this skull ultimately turned out to be that of Kaylee's. I'll withdraw the question. I'll withdraw the question.
I'll withdraw. I'll withdraw.
Was it common conversation at your office where Roy worked about this case?
Oh, yes, sir.
Oh.
Did you discuss this case?
Rephrase your question.
Yes, sir. Did you discuss this case at the office?
Yes, sir.
Was it on the news every day as far as you could see?
Yes, sir.
I love my
And,
beach waiver.
This was the most high-profile missing person in the country at the time.
Sustained.
As far as
Rephrase your
you-
question.
As far as you know, sir, were there any other?
Sustained.
Way to
and
go, maybe.
Let's talk about, okay, so after he's done seeing the skull, he doesn't say a single word to you, does he?
No. Everything turned on to the snake afterwards.
And he doesn't try to get your attention to come over at any time.
No, sir.
Nor does he say anything to Chris, hey, come on over here and look at this.
No.
He wants to be
Does he
rich.
mention anything about coming and getting the media to let them know
No.
about the skull?
None.
When you get back to the office, what happens there?
Well, we pull into the parking area, and then people gather around. I showed this one guy, I said, come here and look, and he seen a snake, and a whole bunch of other people came around and started taking pictures of it, and I'm holding it up and everything, and that's about it.
Did the topic of the skull come up
So
again?
dumb.
No, not to my knowledge.
And the next day,
It's Florida.
did you see
man.
Roy at work again the next day?
Yes, sir.
Did he tell you he called 911 about the skull?
No, he didn't.
The day after that, did he tell you he called 911 the third time about the skull?
No, he didn't.
The day after that, did he tell you he called 911 4 times?
No,
Did he tell you called Crime Line?
no,
In the month of September, did he ever tell you he called the police 4 times about the skull that he had
Wait,
mentioned on
he
Suburban Drive?
did?
no, not to my knowledge. No,
The month of October, did he talk about ever calling 4 times?
no,
Did he ever tell you that he met a deputy out in this area?
Oh
no,
my, what?
Did he tell you that the deputy came out and looked in that area and didn't find anything?
I'm going to object to the eliciting hearsay, and he's leading the witness.
Sustained.
Did Roy Kronk ever mention anything up until December 11th for the entire 4 months that he had called or seen anything off of Suburban Drive?
Objection, hearsay, asked and answered.
Sustained is asked and answered.
Were you made aware of anything involving Roy and the skull that happened, anything within those 4 months?
no, it wasn't.
Is the next time you heard anything about the skull on December 11th, 2008?
Yes, sir.
And did,
You have any more questions about that diagram?
no, sorry, we're fine.
Okay.
Go ahead.
Sir, you can resume your seat.
Is this when
Can I
the
get it to somebody?
dog was brought in?
We'll get it from you.
Beach waiver? Beach
Now,
waiver?
Mr. Dean, on December 11th, you heard a call come over the radio, right?
Yes, sir.
And on this call, you heard Mr. Kronk mention that he found a skull.
Exception.
Say.
I would say excited utterance, Judge.
Oh, well.
Improper foundation.
Sustained.
Did you recall a radio transmission on that day from Mr. Kronk?
Yes, sir.
And did Mr. Kronk, it was in the morning of December 11th, right?
Yes, sir.
And did Mr. Kronk sound pretty excited or emotional?
Objection leading.
Sustained. Rephrase your question.
Can you describe Mr. Kronk's demeanor on this call, this radio call?
Well, without seeing his, emotions or anything, I guess he was, excited.
An excited utterance.
Came over and, explained what he had found.
And it was quite a startling event, wouldn't you say?
Calls for an opinion.
Sustained. Rephrase your question.
Would you describe what he was describing as a startling event?
Yes, I would.
Objection. Move to strike, Your Honor.
Sustained.
What did Roy say to you?
She's not even sitting back down.
Hearsay.
I think the witnesses testified as to the statement and the demeanor of the declarant.
Clarence?
Sustained.
As far as you know, was the call over the radio at or near the time when he found the skull?
Yes, as far as I know, yes.
Just may I proceed?
So was he like waiting for his next call to the area to what? I'm confused.
I think all three prongs of the excited utterance are met. The excited state at or near the time of the event, describing a startling event.
The witness said that he spoke at a normal voice.
That's not
and
what
was
he said.
not describing any startling event. And the witness has no personal knowledge of any startling event.
I would ask that the court reporter read back his exact statement because he did not say that.
Sir,
Sir.
when the call went over the radio from Mr. Kronk, describe his state of voice. Was he shouting? Was he talking in a normal tone or just what, sir?
I would say he was talking in a normal tone.
I would ask that the court reporter read back his original answer before the leading
Well,
speaking
that's-
objection by the
That's the
prosecutor.
answer he just gave. Objection sustained.
What did you say to Mr. Kronk when that call came in?
I said, I told you she was in there.
Okay. And that, in fact, was what you had told him back on August 11th, correct?
And that's correct.
And that's what you were referring to.
Yes.
Wavy talk.
You did not see a skull on August 11th, did you?
No, I didn't.
Nor did anyone else other than Roy.
Objection leading.
Sustained. Rephrase your question.
Did anyone else say they saw a skull other than Roy on that day?
No one else.
Hearsay.
Sustained.
Did anyone else, as far as what you can see the skull?
No.
If I can have just a moment, Judge.
Please make sure to hit the like button and make sure that you are subscribed to my channel. That helps out the algorithm quite a bit. Thank you.
That snake that you confiscated or took from the suburban drive, did you keep that snake?
Yes, I had it for a while.
What
And did you put it in your freezer?
Yes, I did.
And did the police come and take it from you?
Yes, they did.
You know if they gave it an autopsy?
That was what they said.
Oh my God.
And how far into the woods did Roy go that day on August 11th?
I'd say about maybe 25 feet into the woods.
25 feet into the woods. I have no further questions.
I can't.
Cross-examination.
I get in trouble.
Good afternoon, Mr. Dean.
How you doing?
Okay, you made two statements to the jury that you felt like
Thanks for commenting.
the little girl's body might be in there. That's something that you expressed to Roy Kronk on August 11th of 2008, correct?
Yes.
Okay, so what you're telling us is it was your idea to have Roy Kronk look in the woods, or what you said led
Yeah.
Roy to have a look in the woods. Is that correct?
That's correct.
And on December 11th, when you made the statement, I told you she was in there, that's not because you had anything to do with this, is it?
Oh, no, ma'am.
You just thought that would be a good place for a body to be hidden?
Yes, plus what Casey had said to her mother at one time.
Are you talking about the close to home comments?
Yes, ma'am.
Okay. That area where you thought Kaylee's body might be, you've described as a swampy area. Is that
Yeah.
correct?
Yes, ma'am.
Okay. So have you had, or did you have the opportunity in August of 2008 to see what the condition was of the woods there?
It's pretty dense to see inside there, but what I saw, it was dry in areas and everything. The late August rain hadn't hit yet.
Okay.
And,
So you were referring to it though as a swamp.
yes, it usually is a swamp. A lot of cypress in there. And
So you're familiar with Suburban Drive from your work?
yes, ma'am.
Okay. And would it be fair to say that there are times of the year where it's full of water and other times where there are parts that are dry?
Correct.
Overruled.
You can
Yes,
be
I
whatever
would
you
say
want to
that.
be, Peggy.
And were you familiar with the fact that shortly after this August 11th incident, that a tropical storm hit the area, hit
Yes,
Orlando, Tropical
Yes, ma'am.
Storm Faye?
Yes.
All right. Thank you, Mr. Dean. I have nothing.
This is David
Redirect.
Dean.
You might.
He is the meter reader that was with the other guy who picked up the skull with his pole through the eye.
Mr. Dean, these woods were dry enough for Mr. Kronk to go into the woods 25 feet, weren't they?
At where he was at, yes, they were.
In fact, when here this is a swampy area, there are areas that are wet and areas that are dry, are there not?
At that time, yes, I would say so.
So if you go in there, you can walk all over the place, come to an area that's wet, walk around and find other areas that are dry as well as wet.
Sustained. Rephrase the question.
Are there spotted areas that are wet, spotted areas that are dry?
Yes.
And it was dry at that time.
Where Roy was, it was dry.
And if you went further down, you would find wet areas.
I don't know. It was so dense in that area. I mean, you can't see in there.
I'm used to
And
it.
you talked about Casey's statement. That was something you recalled, right?
Yes, I recall.
Okay. Did you recall George Anthony's statement that she was close to home?
No, I didn't.
And that's because nobody was ever looking at George Anthony, was it?
Speculation, Your Honor.
Sustained.
Strike.
Any recross?
Oh, man.
Okay, sir, you may the witness be excused?
Yes, sir.
Thank you, sir. You may be excused.
Your Honor.
I hate when it does that.
Alex Roberts. ALEXROBERTS.
You may proceed.
Thank you, Your Honor. Good afternoon, Mr. Roberts.
Yeah, no.
How are you employed, sir?
I'm employed by Orange County.
And what do you do for Orange County?
I'm the senior meter reader.
And in August
He's not
through
happy.
December of 2008, did you work as a supervisor in the Orange County meter reader department?
Yes, I did.
Did you supervise Mr. Roy Kronk?
Yes.
I'd like to draw your attention to the date of December 11th, 2008. Were you supervising Mr. Kronk on that day?
Yes.
And were you aware of his actions on that day, of where he was supposed to be and so on and so forth?
Yes.
And the day of August 11th, did he read any meters in the Anthony family neighborhood on that day?
Yes.
Do you recall giving a deposition on April 3rd of 2009?
Yes.
It was a long time ago.
Excuse me.
It was a long time ago.
Yes.
Okay. And on that date, you were under oath,
Yes.
and I was there.
Yes.
Ms. Jane Burdick was there.
Yes.
And do you recall page 36, lines 3 through 8?
Watch this for maturity, Tina.
Let me rephrase that. December 11th, 2008, sir.
Yes.
It might have been my mistake.
Yes. It sounds
Did-
more familiar.
December 11th, the day Kaylee's remains were found by Mr. Kronk. Did he read any meters in that neighborhood that day?
She gone.
No.
So as far as you knew, he went straight to the woods.
Sustain unless you establish a foundation for his knowledge.
Yes, sir. You later found him near the woods off Suburban Drive, correct?
Yes.
And Mr. Kronk, after his discovery, could no longer work that day.
No,
And you needed to have somebody else go and read that route that day.
that's true.
And you did
Maybe
that.
no
I
one
did.
outranks you, I promise.
And when you arrived and you saw Mr. Kronk, what was he doing?
He was, I think he was smoking a cigarette and leaning against the county's truck.
So as he was smoking a cigarette and leaning against the truck, what, if anything, did he say to you in reference to a reward? Goes to
Exception.
impeachment, Your Honor. This was based on Mr. Kronk's testimony.
Based on Mr. Kronk's testimony.
Approach.
Yes.
You may continue.
What was Mr. Kronk's demeanor when you saw him leaning against the truck smoking a cigarette?
He was just smoking nervously, just leaning against the truck, waiting for me, I guess.
Nervously?
Okay. Do you recall on August 11th, 2008, when the workers came back with a snake?
Yes.
Okay. Subsequent to that day, did Roy ever tell you he had called 911 4 times?
No.
Sustained.
I have no
Wow.
further questions.
Okay.
Cross-examination? Thank you, sir. May the witness be excused. Thank you, Mr. Roberts.
Thank you.
Okay. So we are going to jump to a very interesting part right now. And then what number is that? I definitely didn't have the number right on that. It says 102. Oh, yes, I did.
I am Sally Carriott. Sally is Sally. Carriott is Kariouth.
May I please the court?
You may proceed.
Thank you. Dr. Carriott, can you give us the benefit of your education, please?
I'm very old. I've been at Florida State for 40 years, and I started out with a degree in nursing and then went to the University of Wisconsin, hoping for a degree in musical theater, and then
Okay.
switched to medicine. And
Oh, honey.
by then, my husband had taken a job at Florida State. Because I do clinical counseling that doesn't involve medications, et cetera. If I have a patient that I think needs that, then I'll refer them out. But generally, the practice is independent. A great many of my patients come from physicians who refer them to me.
Okay, and are you a full professor at FSU?
Yes.
And can you tell me, please, the focus of the work that you do at Florida State?
Well, I'm the director of the Teaching Learning Excellence Part, which means as we get new kids in and new faculty, we teach them how to be efficient teachers. I teach 5
Do you guys want to hear Roy's testimony? Because look at this. I just figured that you wouldn't want to. But this is his testimony. We just listened to 25 minutes of his colleagues, but it's up to you if you want to listen to at least some of Roy's testimony, or if you want me to continue with the trauma doctor. Let me know in the comments. I'm just going to play until someone tells me.
different classes on grief and loss and trauma. Some of you may remember that recently at Florida State, one of our students got a Rhodes Scholarship.
Objection, not responsive to the question.
And
Sustained.
You gotta- we-
Doctor, listen carefully to the question and answer only the question that is posed. Next question.
Thank you. Specifically, the courses that you teach, could you tell us the names of those courses? And could you tell me, please, how many years you have been teaching those types of courses?
yes, my response was to this new course. I started with a class called death of the individual and the family, and that was in the early 70s. And I believe at that time may have been the first grief and loss course in the country. We added an additional course in the religion program. I had a clinical component to that original class, and HIPAA laws changed it a little bit because the students would have interacted with them in such a way that they could have been identified. I teach a class called Ethnic and Individual Variations in Grief, Loss, and Trauma. And in the summer, where I teach in London, I teach a class called Grief and Loss in British Culture, Death of the Individual and the Family, and complementary and holistic medicine as an adjunct to end-of-life palliative care issues.
How many years have you been teaching grief or grief-related issues?
40.
And do you hold any certifications?
I'm a certified traumatologist.
And can you tell me, please, what that means?
Traumatologist. So am I.
We became following the Oklahoma City bombing, it became clear that there was no one to help the people that were first on scene.
To the question of what that means.
If you could just explain more narrowly what a traumatologist is and what it means to become certified in traumatology.
Traumatology is the helping arm, often of FEMA, and we're part of Green Cross, that goes into places where there has been traumatic episodes, whether it be by weather or bombing, and our
Especially
work
with
is
weather.
to interact with
Grief and loss.
In the late
let's get
60s,
into
and early
the
70s, when I was at the University of Wisconsin, I read something that talked about, are we failing dying patients? And I did some research and found a woman from the University of Chicago area who was willing to come up to talk to med students in Wisconsin about her work. And she did. And she talked a lot about patients have the right to know their diagnosis. They have the right to refuse treatment.
Your Honor, could we approach an instruction to the witness?
I'll be glad to rephrase the question. I just need to.
Sustained. Doctor, listen carefully to the question and answer only the question that is being asked.
I need the name of the individual under which you trained.
I trained after that day with Dr. Elizabeth Kubler-Ross, who came up from the University of Chicago and worked with us at the med school in Wisconsin.
Can you tell me whether or not you've given any seminars in grief and trauma-related issues? And if so, how many approximately?
Well, I do maybe 50 a year, and 10 years ago I did 100 a year, and 15 years ago I maybe did 200 a year. So
Hundreds?
thousands probably, yeah.
And to whom are you speaking on grief and trauma?
Physicians groups, nursing groups, pharmacists, clergymen, firefighters, EMT people,
Well, God bless her.
police, dog trainers, interestingly enough, people that go into sites where there's a lot of angst involved. So helping groups, social work students.
Can you tell me, please, approximately how many hours over your career you have spent studying grief and trauma and related issues?
Well, that's a lifelong event. I probably read new research or go through new books that are coming out on grief and trauma, certainly 5 to 6 hours a week.
Wow.
Okay. And approximately how many hours, if you totaled up your time with regard to teaching, reading, giving lectures, working with individuals suffering from grief or trauma-related issues, what would be the approximate number of hours over your lifetime that you have focused on this topic?
I have made a decision. Class, I have made a decision. We are going to listen to some of Roy's.
Where you stop to relieve yourself.
Yes, sir.
Great way to start.
And do you remember on the day of August the 11th, who, if anyone, may have been with you when you were reading meters in that area?
Because White Buffalo brought
At the time, nobody, sir.
You went out there by yourself on August the 11th of 2008?
I started the route, yes, sir, by myself.
Did somebody join you out there on that day?
Late in the afternoon, 2 of my coworkers joined me, sir.
And who would they be?
I believe it was David Dean and Chris. I don't remember his last name.
Do you remember specifically that date, August the 11th, 2008?
Yes, sir.
Sorry.
What particularly about that date do you remember, sir?
Finding a dead rattlesnake, sir?
I'm asking you what you particularly remember about that date.
I know, Texas. I know.
Nothing really, sir.
Mr. Cronk, on August the 11th of 2008, did you stop your county vehicle on Suburban Drive?
Yes, sir.
Did you exit at that time and go into the wooded area in order to relieve yourself?
Yes, sir.
Is that something you customarily did?
Whenever we really didn't have bathroom facilities, sir, so you just
They
went wherever
wouldn't
you
let
knew
us
that was
in
private
at
to do what you had to
BP.
do, sir.
Do you know where the nearest gas station facility is to Suburban Drive?
I believe the shopping center at the end of the road, sir.
Oh, you're funny, dude.
Now, prior to that particular day, were you aware of the saga unfolding in the search for little Kaylee Marie Anthony?
Yes, sir.
Were you watching news reports on the subject matter frequently?
No, sir.
Did you have a roommate?
Yes, sir.
Did your roommate watch television and news reports about this search?
Yes, sir.
Did you discuss that situation with your roommate on a daily basis?
No, sir.
How often?
Not very often, sir.
When you went to Suburban Drive on August the 11th, sir, were you aware at that time where the Anthony residence was in relation to where you stopped to relieve yourself?
It was the first time I read the route, so not really, sir, no.
And on that particular day, sir, did you have anything unusual occur to you while you were relieving yourself?
No, sir.
Did you go into the woods?
Long enough to do what I had to do and come straight out.
Did you see or do anything else in the woods then besides just relieve yourself and walk straight out?
I looked around, sir.
Well, what, if anything, did you find when you looked around, sir?
I saw a object that appeared a little odd to me.
Sorry if you
Did
guys
you,
hear Pearl
On
snoring.
that date and time and place, sir, see a bag that appeared suspicious to you?
I really didn't see a bag per se, sir. No.
Did you lift a bag, sir?
No, sir.
He wants to be coy about it.
And on that particular date and time, sir, did you see a skull, a human skull, a small human skull?
I was never closer than 20 to 30 feet from the object, and I did see something that appeared to me to look like something of that nature. Yes, sir.
And sir, did you make any exclamation about what you saw and found? That is, did you say anything else to anybody?
No, sir. We found a dead rattlesnake, and that pretty much took up the rest of the afternoon.
Did you, when you went in to relieve yourself, sir, were you aware that Mr. Dean was there?
Yes, sir. I believe so.
And is it your testimony, sir, that when you went into the woods, that then and there you did not specifically see a skull?
No, sir.
Then is it also your testimony that you did not then and there say something to Mr. Dean that you had seen a skull?
Not at that time, no, sir.
And did he, that is, Mr. Dean, come to where you were, walk from the truck to where you were?
No, sir.
Did Mr. Dean step on a apparently deceased rattlesnake?
No, sir.
Did Mr. Dean have any occasion somehow to get the
He
shovel from
did.
his truck and pick up a rattlesnake?
Yes, sir.
Just wait, Peggy.
And that was there and then at that time on August 11th, 2008?
Yes, sir.
And did you have conversation with him during that process that you had just seen a skull?
Please do that.
I told him that I saw something that looked odd to me, but they were completely enthralled with the dead rattlesnake, sir.
Did you tell him, sir, that you saw a skull?
I told him I saw an object that looked like a skull. I never told him I saw one.
Okay.
These are grown men.
What did you and Mr. Dean do next, sir?
Went back to the office and showed everybody the dead rattlesnake.
Did everybody come out and take pictures of the dead rattlesnake?
I believe so.
Did you then just go home?
Yes, sir.
Did you call the sheriff's department or any other law enforcement agency to report that you had seen what might be a skull?
Yes, sir.
Did you speak to somebody?
I originally called Orange County and they told me that they were not handling those phone calls and I needed to call Crime Line, sir.
Did you call Crime Line?
Yes, sir.
Did anybody respond to you after you made the call about maybe finding a skull?
No, sir.
So did you tell them that you had maybe found this skull on Suburban Drive?
No, sir. I told him I saw an object that looked like that, sir.
And did you mention to anybody that it was in the vicinity of the Anthony residence?
No, sir.
So it's your testimony that despite the fact you called and you said you may have found a skull, there was no response except call Crime Line?
Yes, sir.
Did anybody from any law enforcement agency come and talk to you on that day?
Yes, sir. Look me in the eyes. What about me makes you think I would lie to you? I like to play with snakes, even if they're deceased. Then I put them in the freezer, drizzle them with a little olive oil.
Hey,
No, sir.
It looks like lurch.
did you work the next day, August the 12th of 2008?
Yes, sir.
Were you reading meters?
Yes, sir.
Where was your route on that day?
I don't remember, sir.
On the 12th of August of 2008, did you have occasion, sir, to call anybody from law enforcement again about the maybe skull?
No, sir.
What did you do on that day?
I read my route. I went home.
So you worked as usual. You may have seen a skull. You pick up a dead rattlesnake. You call law enforcement. The next day it's just back to work as usual.
Yes, sir.
And on the 13th of August, 2008, sir, did you call the sheriff's department again?
Yes, sir.
And did you report, in fact, that you had seen a skull there off Suburban Drive?
I was told to call and an officer would meet me out there.
Sir?
I was told to call and an officer would meet me out there, sir.
And on August the 13th of 2008, did an officer from the Orange County Sheriff's Department, in fact, meet you on Suburban Drive?
2 of them came out. Yes, sir.
You remember who they were?
I believe it was Officer Kane, and I don't believe I remember the woman's name that was out as well.
And did you take those officers into the woods to show them where you had seen this maybe skull?
Did you take those officers into the woods and show them your snake?
I never said it was a baby skull, sir. And no, sir, I did not take them into the woods.
Maybe.
Oh,
I'm
excuse
sorry.
me.
That's my fault.
Oh, sorry. No, I never took him into the woods, sir.
They didn't ask you, Mr. Kronk, show us where this skull is that the world is looking for?
No, sir.
And
He does.
what did you do then?
Great
I pointed,
observation.
we never went into the woods. We were standing out in front, and I just pointed in the area where I believed I had seen it, sir.
All right. Now let's go back over this and see if we can help you. On August 11th, 2008, sir, you did indeed call 911, did you?
No, I don't. No, I never called 911, sir.
Who's
Will it help
lying?
refresh your recollection, sir, if I was to show you a transcript of the call August 11th, 2008 to 911 by you?
I live in Osceola County, sir. I called Orange County, so I did not call 911. I called the dispatch in Orange County.
Counsel, Your Honor, may I approach the witness?
You may.
Counsel,
Dispatch is
base
911.
3144, August 11th, 2008. Counsel is helping me on this. So did you call a non-emergency line?
Yes, sir.
Okay. And did you tell that non-emergency line that you were a meter reader with Orange County?
Yes, sir.
Did you tell them that you had a route today that included the Anthony's home?
Yes, sir.
So then you did know that the route included the Anthony's home?
When I took the route in the morning, sir, I did not know that I had the Anthony's route.
And sir, did you tell the operator that you were down there by the school and then came back? And on the left-hand side coming back, I noticed something that looks white. And there was like a gray bag down in there. You remember telling them that?
Yes, sir.
You remember telling them your words, I don't know what it is. I'm not telling you it's, it's Kaylee or anything of that nature. You remember that discussion?
Yes, sir.
And did you describe the area that you were talking about? The area off Suburban Drive?
Really trying
Yes, sir. I told them the general area was, sir.
Did you tell them that there were two little in areas that you can go in, and there's a big long tree laying down.
Yes, sir.
And there's a lot of swamp back in there. Well, back behind one of the trees down there was a gray bag. And then a little bit further up that, I saw something white. Did you tell them that?
Yes, sir.
And when you told them that, sir, was that the truth?
Yes, sir.
So you had seen a fallen tree, a gray bag, and something right close to that white. Yes?
I was never any closer than 30 feet, sir. I told him, described as best I could what I had seen that day.
But you saw, you say, which you told the operator, a gray bag by a fallen tree in those woods with something white by it that you thought was a skull.
I said it appeared to be that, yes, sir.
That's something we would hear on Unsolved Mysteries, you know, like due west, 60 yards. Hi, welcome. Yeah, where's Tina now? She'd be pissed.
On the following day, you called again, as we said, right? On August the 12th?
Yes, sir.
You did call on that day.
Yes, sir.
That's the second day.
Yes, sir.
Maybe he's really trying to figure out her new device.
You told them, I went down, I had to take and I went down there, was behind one of the trees, was a gray vinyl-like bag, like a pool cover or something like that, and it looked rather suspicious. I didn't touch anything. You remember saying that?
Yes, sir.
And, sir, you were having more detail. You said there's a fallen tree that looks like someone had tried to cut on it at one point, but there was a white board hanging across the tree, and there's...
Mason, reading from a document, not in evidence.
I'm asking him if he said it.
Sustained.
Did you, sir, tell the operator that there was a tree that looked like somebody had cut on it?
Yes, sir.
Did you tell the operator there was a white board leaning against the tree?
He's doing the same thing. He's reading from a document that's not in evidence.
Answer the question, please, sir.
Yes, sir.
Did you tell them there was something round and white underneath it?
I don't remember, sir.
This fucking guy.
Just a second, Your Honor. There's so many of these things. On August the 10th of 2008, sir, well, that's coming here. Strike that. Did you draw a map for the law enforcement officers as to where you had been?
On what day, sir?
Forget that date, any date. Did you draw a map?
Yes, sir.
He's so distracting. I can't
did
hear the
you,
words.
When you drew that map, sir, draw in the privacy fence that extended from the last house on the corner of Suburban Drive and Hope Springs Road?
I don't remember, sir.
May I approach the witness, Your Honor?
You may.
Bait stamp page 3992.
No worries, popcorn.
Do you recognize that document, Mr. Crunk?
Yes, sir.
Did you draw it?
Yes, sir.
And is that a fair and accurate representation of what you remember at the time and that you drew 3 years ago?
Yes, sir.
Sorry, guys.
I'd like to offer what is now marked as Defense Exhibit FI in evidence.
We can identify when that was drawn. I would have no objection.
The more and more I watch this,
Yes, sir.
Is there a date below it?
Yes, sir.
What does it say?
12/17/08, sir.
12/17/08.
the more I think this is an Unsolved Mysteries episode.
Be received in evidence
Work.
is defense exhibit number
Number 66.
Your Honor,
You may.
if I can.
I do it.
Maybe it works better that way.
Oh, hey, please make sure to like the stream and subscribe if you haven't done so already, because it's free. Thank you.
Mr. Cronk, you see where you've labeled this fence here?
Yes, sir.
Is that a wooden privacy fence that comes from the last house?
I hate
believe so,
people
sir.
that draw maps.
And then you drew right off the end of that an area. Can you tell us what you're seeing there, please, sir?
Well,
Well,
the line represents the water. The line with the little thing sticking up represents the tree. And that was down. And then I believe where the X is about in the area where I saw where I was, sir. What I believe the way I saw, sir. Actually, no, because the bag is, I just looked at that. No, the X next to the board is where I saw what I saw, sir.
My fingers won't hurt us. Could you show me on there, sir, where the tree with the board is? Can you touch it?
Oh, no, sir, right there.
And the bag, sir, relative to the tree?
Where that X is. There you go.
And the white round object that you think was a skull, where was that?
It would have been where the X was, sir.
The jury been able to see all that?
how much do you think the defense was like sitting there when that guy got in trouble for flipping off?
Do you know, sir, or can you remember approximately how far from the edge of the road that find that you made was?
No, sir.
Can you see the edge of the road, sir, as you drew it?
Yes, sir.
Did you touch that also?
Welcome, West Virginia. My grandma lived in Charleston. How much do you think the defense was like, oh my God, thank
And on
God that
the
wasn't a guy?
13th of August 2008, neither of these two responding deputies went with you to that spot?
I never took him to that spot, sir.
Exactly. I gotta take my narcolepsy medicine.
When you were in that area on August the 11th and 13th, sir, did you smell anything peculiar?
No, sir.
Did you
No.
in any way lift a bag?
No, sir.
So literally opposite of everything we just heard before you.
When you went into that area, sir, had the thought crossed your mind that you might be looking for Haley?
Would you please clarify what date are we talking about? Are we talking
August.
about August or are we talking about December?
August the 11th, 2008, when
I
you
never-
first went in there.
Excuse me, I never went into the woods on August 11th, sir.
You didn't go in the woods to relieve yourself on August 11th?
We've already established that, but after that, no, sir, I never went back into the woods.
Bye, Aussie. Come back soon. Don't forget to like the stream and subscribe if you haven't done so already. Thanks. It's like mortifying.
Did you tell any of the, or either of the deputies that you had found a bag that you thought may have bones in it?
No, sir.
No. Just revisiting.
Specifically, sir, did you tell Deputy Richard Kane
Thank you so much.
that you think the bag has bones in it?
I told him I saw an object what appeared to me to look like a skull.
But did you tell him, sir, that the bag looked like it had bones in it?
No, sir.
And the bag you found was on dry land, was it? Not in water?
Once again, what date are you speaking about?
August the 11th,
I-
2008.
Sir, I never was any closer to that bag than 30 feet. I never went into the woods. I just saw it from the outside of the veil of the trees.
Yep.
What does Lurch do when he gets mad? Is he gonna throw the podium?
The area on August 11th that you went into the woods, was it dry or the ground? Was it dry or underwater?
Oh my God.
It was dry.
This is just like the Karen Reed trial. Talking about everyone going to the basketball game that night. What's 23 Celsius? Is that
At
like
the time that you were in those woods on that occasion, sir, were you aware of there being a reward offered for finding Kaylee?
I believe so.
Pardon?
I believe so.
Did you believe that reward to be $255,000?
Something like that, sir. Yes.
And on that date of August the 11th,
No.
that you described that you saw something and have described it as you have to this.
I was only off by 30 degrees. Don't worry, anyone. I'm not going into meteorology anytime soon. I am a certified storm chaser or storm spotter, but that was mortifying.
Were you aware that right around the corner on Hope Springs were a whole lot of media trucks
Yes, sir.
and people?
Yes, sir.
Did you go and tell anybody that you had found what looked like a skull and bag of bones?
No, sir.
What's sad is I was
Anything
so
like that to
confident.
anybody other than Mr. Dean?
I never said I found a bag of bones, sir. I
Okay.
never said that.
Did you tell anybody that, sir, you found what looked like a skull? Did you tell anybody other than Mr.
Believe
Dean?
him.
I never said I found that, sir. I said I saw something that appeared to look like that.
And did you go tell anybody else that you found something that appeared to look like that?
My roommate.
Your roommate. But none of all those media trucks that were there, or none of all the people in the area.
No, sir.
Oh,
And on that date, in fact, sir, did you describe to anyone what?
I'm sorry to do this, but I've been asked if I could demonstrate this. So what we have is one of my shadows, and I've reached almost the end of it. But if you take a pair of tweezers and you get the plastic part out of the top, like so, it allows for the applicator to go down further. So I'm able to get so much. That makes no sense, Lacey. so much more product than I had gotten before. Look at that. All right. Well, we can continue now.
You saw appeared to be white, looked like the top of a skull sticking out of a bag.
Yes, sir.
Yes, sir. I gotta put my screen in full mode.
And was, sir, the bag that you saw in August of 2008 the same plastic bag that you saw in December the 11th, 2008?
I wouldn't know, sir.
Do you believe it's the same bag?
I wouldn't know.
You recall, sir, having your deposition taken on July the 30th of 2010 at the state attorney's office in the adjoining building right down here, where Miss Linda Drain Burdick was present. Jose Baez was present. Michelle Medina was present. And I was present. And your lawyer, David Evans, was present. Do you remember that?
Yes, sir.
Counsel, court, I direct you to page 18. Question on line 19. The question to you, sir, at that time was, do you believe the bag you saw in August was ultimately the same plastic bag that you saw in December? Answer, yes, sir. Do you remember the question and answer?
Awkward.
Yes, sir.
Were you attempting to tell the truth at that time?
I was told that it was the same bag, so yes, sir. I never came to that conclusion on my own.
You were told it was the same bag?
Well, not really. That was a bad way. I shouldn't have said that. No, sir. I don't know. I don't remember. If I said yes, then yes, it is.
After you found that skull at that time and place, sir, did you try to get your coworkers to go with you to look at it?
What date are we speaking of?
August the 11th of 2008.
I tried to point it out to them, sir.
So you did talk to them about thinking you saw a skull.
I told them I saw a white object. They saw the dead snake, and everything from that point out became about the dead snake.
And on that same depositions we just identified, going to page 19.
Bye.
Question on line 19.
Thanks for joining us.
See if you remember this. So what did you do upon seeing the skull?
You remember.
Answer, I tried to get the two guys that were with me to look at it, but they were too busy playing with the dead snake. You remember that question and answer?
Yes, sir.
It is a good place to stop, Mr. Mason.
Yes, sir.
Okay, ladies and gentlemen of the jury, the time is now 12 o'clock. We're going to be in recess until 1:30.
Time for us to beat
I'm
our
going to
heads
ask that you not
against the
discuss
wall.
this case among yourselves nor with anyone else. And please remember all of my previous admonitions. We'll be in recess until 1:30. Any additional instructions on behalf of the state or the defense?
Why are you
We'll be in
yelling?
recess.
He was like screaming in my
Okay,
ears.
state recognized persons of the jury. Defense and members of the jury, did you heed all my previous admonitions during the
Kelly.
recess? Mr. Mason, you may continue, sir.
Thank you. Mr. Croft, we had, before we talked briefly about
Crap.
the calls that you made to the authorities on August the 11th, 12th, and 13th. You remember those questions, sir?
Yes, sir.
All right.
Okay.
Now, in fact, sir, did you advise the operator on the 12th that you had been in the woods and you had looked down and saw a skull?
No, sir.
You did not. Your Honor, we have stipulations before the court.
You may.
And based on the stipulation, we will now offer into evidence
This was the same color
Defense
I used in
Exhibit
my eyes.
FJ, which is August 11th, and FK, which is August the 12th, and FL, which is August the 13th.
What about a few?
Okay, you want me to read all three? Or just two of them? I got one for August 11th, 12th, and 13th.
Reruns.
You offered two tapes, right?
That was perfect.
Three, okay. You're gonna publish them all now, you?
Yes.
Ladies and gentlemen of the jury, let me read you the following stipulation between the state of Florida and the defendant. On August 11th, 2008, Roy Crunk made a recorded call to 911 that was received by the Orange County Sheriff's Office at 16:28 hours. The recording is a true and accurate representation of the call. The parties have agreed to this fact, and it shall be considered as true in your deliberations, bearing the signatures of Linda Drain Burdick, Jose Baez, and Ms. Casey Anthony. Second stipulation. On August 12th, 2008, Roy Crunk made a recorded call to 911 that was received by the Orange County Sheriff's Office at 21:03 hours. The recording is a true and accurate representation of the call. The parties have agreed to this fact, and it should be considered as true in your deliberations, bearing the signatures of Linda Drain Burdick, Jose Baez, and Casey Marie Anthony. Last stipulation. On August 13th, 2008, Roy Crunk made a recorded call to 911 that was received by the Orange County Sheriff's Office at 15:14 hours. The recording is a true and accurate representation of the call. The parties have agreed to this fact, and it should be considered as true in your deliberations, bearing the signatures of Linda Drain Burdick, Jose Baez, and Casey Marie Anthony. Madam Clerk, would you announce the exhibit numbers, please?
FJ will become defense exhibit number 67, FK will become defense exhibit number 68, and FL will become defense exhibit number 69.
We'd like to publish those at this time. I believe they're ready to go.
I saw my makeup swipe from late last night. Or we can do this or one other color.
I don't have it. I called a non-emergency line.
How can I help you, sir?
I'm a meter reader with Orange County, and I had the route today that included the Anthony's home. Okay, and I went down to the school and came back, and when I was coming back, I stopped between the two swamp areas there. I don't know if you know what I'm talking about or not.
No, but go ahead.
But there's a stretch of road there that goes from where the start of the road is down to a school, and in between it on either side there's a swamp. And if you're heading back out towards the main road on the left-hand side, in an area, I noticed something that looked white, and there was a gray bag down in there. I don't know what it is. I'm not telling you it's Taylor or anything of that nature. But I just
do you know what street Anthony Home is on?
Yeah, it's on Good Hope, isn't it?
Okay, Good Homes, and what's the nearest intersecting street?
It's the one that comes off of, isn't that? It's like Suburban or something like that?
Hold on, I just want to bring up the map. Hold on.
Because I just read that. That's the one I have today to read the meters on.
Hold on.
And this could be nothing.
I don't find Good Homes intersecting with Suburban anywhere.
What does it intersect with?
Oh my God, all kinds.
No, it should only be like 3 words it intersects with.
Good
Oh
Homes.
my God,
Yeah.
ma'am.
Anthony live off of the second, that little subdivision.
We sincerely apologize for calling you and asking for your assistance. Jeez Louise, lady. Customer service, my ass.
There's like a elementary school or something back there?
You don't know what the name of it is?
Oh, God, no. It's in my GPS, though. Might be able to pull it up. Hold on. Do you see a, something else? Oh, let me go pull my GPS up.
The lady's like, oh, he's a singer. That's cute.
Coming up now.
I'm looking at the phone book.
I see what you did there, babe.
3 or 2.
Is it Anthony House on Holly Street in Zowood?
No, it should Suburban Drive. It's like the school is 8701 Suburban Drive, but it's actually at the end of the road, not at the beginning of the road. And that's where and their road comes off of Suburban Drive. And I work over at the Curry Ford, at the headquarters there, Curry Ford, and we were there reading that today. And,
okay, I have the map now, okay?
Yeah.
8701 Suburban is in Chickasaw Oak subdivision.
Yeah, that's
the nearest intersecting street is Chickasaw and Lumberton.
Right. If you go down that road, that's where the school's at. In between from where you can get onto their road at and down, there's a swamp area. If you're heading towards the school on the right and left, if you're heading towards the school, it'd be on your right-hand side. And there's like a big swamp area there, and we found a dead 4-foot eastern diamond rail back there, but that's not really the thing. There's like 2 little in areas you can go, and there's a big long tree laying down and there's a lot of swamp back in there. Well, back behind one of the trees down there was a gray bag, and then a little bit further up than that, I saw something white. But after I saw that 4-foot eastern diamond rattlesnake, I'm not going in that crap.
Okay, so if you're going on Suburban,
you're heading down towards the school.
okay, and it's after Chickasaw on the right-hand side?
Yeah, there's the road kind of stops, and then there's like this, you go down, and there's a 6-foot tall fence on the left-hand side, and then the right-hand side open heading towards the school, and it's all swamp area on both sides. And it would be on the right-hand side that I saw what I saw.
Okay, I'll let him know.
I appreciate you, and once again, I had no idea what it was, so and I don't want to waste any more of the county's money, but I'm just telling you I saw something.
Not a problem.
Thank you, ma'am.
Thanks, bye-bye.
Bye-bye.
Not a problem. I do it every day. Bye. Dispatchers should be nicer, just period.
Sheriff's Office. Yeah, hi. My name is Roy Crunk. I'm a meter reader with Orange County. Yesterday, I read the Anthony's route. We got done, and I got done, and I went down here to the school down there at the bottom of Suburban.
Mm-hmm.
I called this in yesterday. I don't know if this is what y'all looked at today or not, but on the way back up, I stopped in the middle there where there's a swamp. If you're coming out, there would be a fence on the right-hand side and just open, swamp area on the left-hand side. I went down, I had to take it. I went down, and there behind one of the trees was a gray vinyl bag, like a pool cover or something like that. And it looked rather suspicious. I didn't touch anything. And then a little bit further up, you can tell where someone ran across with a mower, but the weeds are still real high in that area. There's a fallen tree that looks like someone had tried to cut on it at one point. But there was a white board hanging across the tree, and there was something round and white underneath of it. And I don't know what it is, but it just didn't look like something that should be there.
Right?
Can I have some cross streets, please?
There is no cross street.
Got it.
If you turn on Suburban, go down past, the first street, go down past the second street, where the road turns and it goes to their home. If you go all the way down to the end of Suburban, there's a school down there.
Okay, Suburban and where, sir?
So, off of Chickasaw. Yeah, it's right by their house, though. You go in off of Chickasaw, you go down Suburban, you'll pass, Lamberton?
Let me go ahead and drop a link in the chat for 10% off your order if you do like this color. I wore it for my wedding, actually.
Mm-hmm. The first one, and then the second one is Hope Springs, and then if you go all the way down, there's a school there. As you're going down to the school, you're going to hit a wood area. If you're going towards school on your left-hand side...
What's the name of the school, sir?
It's just the elementary school there. I don't know. I just read the meter at it yesterday. I don't know. I just, look at my meter number. I really don't pay attention to that, the rest of it. But if you go down there, there's a swamp on the left-hand side, and there's a fence, about a 6-foot high fence there. On the other side of the road, there is another swamp right there, and that's where the gray bag is, a little bit down more towards the school, and then the area is all right in there. That's also where we found a dead 4-foot eastern diamondback rattlesnake, and that's why I didn't go any further into the swamp.
Okay, Roy, what's your phone number?
My cell number is 321-987-6542. I work for Orange County Utilities.
Okay, sir. I'm going to send this call up. I'm going to take a look for the bag. I also have another phone number that I need you to dial. It's a phone number set up for anything doing with the Kaylee investigation.
Oh, what, the twist line?
Yes, sir.
I really rather would not, being a county employee and all that. That's why I'm talking to you all.
You can still do it, regardless if you're a county employee. You can remain anonymous.
Not if they find a freaking body.
Yeah, so you can still remain anonymous if they do find a corpse.
Okay.
Because we definitely need you to contact that number because all information is compiled there. And if anything does come up out of it, we'll see who else has also called about it and put it all together.
Okay.
Please do that. Do you have the phone number?
What is it? Go ahead.
1-800-423.
Hold on a second. 423.
Tips.
Tips. All right, boss.
Thank you, Joy. I really appreciate it.
No problem.
Please tap on this and let me know if the coupon shows up. Thank you.
Sheriff's Office, how can I help you?
Yeah, it's Hidden Oaks Elementary School.
Okay.
Yeah, my name is Roy Clark. I'm a meter reader with Orange County. I had the Kaylee's routes Monday, and there's an area in between where Suburban ends down at Hidden Oaks Elementary. There's a swamp area that I saw something that I called in a tip the other day, and they said they would dispatch an officer out to me when I got there. And I'm here.
Your name?
My name is Roy. Last name is Cronk. K-R-O-N-K.
Let me have your phone number.
321-987-6542.
And exactly where are they going to meet you on Suburban and what?
I'm in between. I'm not near any of the roads. I'm just in a swampy area that's between where the Anthony's Road starts and and Hidden Oaks. There's no streets here. It's just swamp on either side of the road.
Okay, can you go back to the intersection of Suburban and Hope Spring and wait for them there? Is that the nearest intersecting street to where you are?
Yeah, if they come around the corner, they can see me sitting here.
Okay, so you're right past Hope Springs.
Right, yeah. I'm sitting facing the road in the opposite direction, and I'm in a blue four-door Cavalier.
All right. I'll have somebody out there as soon as I can.
All right, thank you.
You have a good day, sir.
You too. Bye.
Bye-bye.
See you never. Bye.
Mr. Cronk, do you remember those calls, sir?
Yes, sir.
No. Now, after you made the call on the 11th, what did you do?
That was the second day, sir?
That was the first day.
Okay.
What did you do
Nothing.
after you made the call?
Nothing.
Well, did you go home and lay out by the pool and relax or what?
The call wasn't made until about 9:30 at night, sir.
What did you do after you made the call?
Nothing,
Oh
sir.
my God.
Nothing.
Yes,
Went
sir.
home
I was already at home, sir.
and went to bed? That's it?
Probably watched a little television and then went to bed, sir.
Okay. And on the next day, the 12th, when you called, you just heard that again.
Yes, sir.
And after you made that call, what did you do?
Watched a little television and went to bed. That call was also made after 9 p.m.
All right, sir. After any of those calls were made, do you recall making a statement on January the 6th under oath to Corporal Uri Melich?
No.
You remember January the 6th, 2009,
My
sir,
God.
giving a recorded statement to Corporal Uri Melich when your counsel, Mr. David Evans behind us was there, and Eric Edwards. You remember doing that?
I don't mean to be rude, sir, but you're being a little vague. You're saying a recorded statement. I went with Mr. Evans to the police office and we sat down and we had a conversation with Mr. Mellish. I do remember that.
On January the 6th, 2009 at 15:30 hours, that's 3:30 in the afternoon,
Yes, sir.
you and your attorney went and gave a statement to Uri Melich under oath, did you not?
I believe so, yes.
And do you remember being asked specifically about your crime line calls?
Yes, sir.
And do you remember being asked whether you had been on the street before?
Yes, sir.
Did you just hear your calls saying that you had read the meters on the Anthony's house street?
Yes, sir.
So you knew where the Anthony house was, didn't you?
At the end of the day, yes, sir. At the beginning of the day, no, sir.
On the 11th of August, sir, the first day you called, did you have any conversation with your coworkers about the area and that being a suspicious place, maybe to hide a body, any kind of conversation like that at all?
We were all discussing that. Yes, sir.
You all were discussing whether that would be a place to go and look.
Mr. Dean said something to that effect. Yes, sir.
And so you did.
No, I had already thought that before he ever said anything.
You thought it first.
Yes, sir.
You're so smart.
Did you and Mr. Dean ever have an argument about whose idea it was first?
Yeah, he said it was his, but I didn't agree with him.
He said it was his idea to search those woods first, and you said, no, it was mine, Roy's idea.
I had already thought of it before he verbalized it. I don't verbalize things of that nature,
All right.
sir.
And you told us earlier, sir, that I think your words were it may have been a skull or looked like a skull that you saw on that day.
Yes, sir.
And did you tell Corporal Melich, page 6, bait stamp 5615, starting at line 9,
Riley?
that you were 99.999% sure it was a skull?
Yes, sir. But I also stated that I did not know what it was made of. It could have been a prop. It could have been something ceramic bought at a flea market. I also stated I had no idea what it was. But yes, sir, it did look like a human skull to me.
Did you tell him at that point in time, I carry on here at page, line 11, and honestly, it was a hot day. I just wanted to go home. I wanted to take a shower. I wanted to, drink a soda, relax, and get in the pool.
Yes, sir.
Wow, just an all-American dude.
And on the next day, you called again, as we heard.
Yes, sir.
Did you work on that day as well?
Yes, sir.
Same route?
No, sir.
Let's get a little fancy.
On the 13th, when deputies responded, you remember who you talked to?
I believe it's Officer Kane, I believe.
Anybody else besides Kane?
I told you this morning that there was a female there, but I never got her name.
Okay. And sir, did you tell them
That was on purpose.
that you had looked down to see the skull?
When I meant down, I was as far from here to that corner there. I was at a height above what the object was. So I was looking down at it from a distance.
Did you point out to Deputy Kane where you were looking down at?
Hey guys, if you're enjoying this content, please make sure to give us a like on the stream and subscribe to the channel. It's free to do and it helps my algorithm so we can reach out to more people. Thanks so much.
at the skull?
I pointed in the general area where it was. Yes, sir.
And did you get within 6 to 8 feet of it and point down to him?
No, sir.
You remember that same statement to Melich and Company?
Yes, sir.
And in that statement, did you tell anybody that you got within 6 to 8 feet of this skull?
No, sir.
Did you watch Deputy Kane go into the woods to look?
Yes, sir. Sorry.
Did you see?
If we can get to 50 likes, by the way, I will gift 5 memberships.
Him get close to where you had seen the skull?
Crazy.
Am I allowed to say this? Am I allowed to say what happened?
Did you see Deputy Kane get close to where you
Deputy
said?
Kane went down to the water line, did this, walked back up the bank, slipped on the mud, and then chewed me out for half an hour. Is exactly what happened.
Did he get within 6 to 8 feet, sir, of the area you said you saw the skull?
No, sir.
Peggy.
Oh, same sworn statement, page 8, page 5617. You were asked by Corporal Melich, how close did he get to this object that you pointed out? Your answer was, well, I'm sorry, if I was, for the sake of argument, 8 feet away from that, he might have been 6 feet away from it.
Well, that's what I said, and that's what it was.
So you were 8 feet away and he was 6 feet away?
That was 3 years ago, sir. From what you said, if that's what I said, that's what it was.
Well, you pointed to the corner of this room back over here. That's a good deal more than 6 or 8 feet, isn't it?
Once again, on the first day, the 10th, I was from here to that corner to where the object was. I did not go back to that area until the 11th. No, on the 12th, excuse me. Whatever the day that Officer Kane came out was the day that was the first time that I had been back to that area since the first day.
And later on in that conversation about where things were, so were you asked and did you discuss now how sure you were that there was a skull that you saw?
I don't recall that, but it's possible.
On page 12, page 5621, Corporal Edwards asked you. So on a scale of 1 to 10, let's even.
Why do these people not have attorneys to prepare
I
them?
need to see it.
Sorry, I didn't hear you.
I do not have the document which you're talking about, so I need to see it before I can rule.
Shut up. I'm kidding.
Approach along with the court reporter. You may.
Well, you can look at this statement, last identified, sir. See if that refreshes your recollection as to how sure you were about it being a skull.
Yes, sir. But as I stated, I did not know what it was made of.
Did you tell the authorities under oath on that date, time, and place that you were 100% certain that it was a skull?
No, sir. I believe I said 99.99.
Oh my God.
Okay. Highlighted area. Okay.
This.
Did you tell those authorities at that time and place under oath that you were 100% certain it was a skull? Yes or no?
Yes.
I'm gonna start crying. Why did I pull up a tab? I wanted to show you guys something.
Now, Mr. Cronk, after the 13th, and you're meeting the detectives out there, did you go back or do anything with the authorities prior to December of 2008, after
No,
the
sir.
body was found?
No, sir.
Were you involved in any capacity with this investigation?
No, sir.
Did you go on Good Morning America show?
Yes, sir.
When did you do that?
It was in January, but I don't remember the exact date, sir.
And did you get paid for doing that?
Bad kitty.
I was paid for a licensed picture of a snake, but I knew that there would probably be an interview involved, so.
Were you paid $15,000 for doing that, sir?
I was paid $15,000 for a licensed picture of the snake, sir.
Did you collect money from Crime Line?
Yes, sir.
$5,000?
Yes, sir.
Did Orange County pay for your lawyer? Still doing so today?
No, sir.
Orange County did not pay for your lawyer?
My Orange County paid for my attorney until I was terminated, and then they stopped paying him, sir.
Mr. Evans sitting here?
Sustain.
Now, after these initial involvements, sir, have you been questioned about your conversations with others such as Mr. Dean and other officers?
Yes, sir, I believe so.
Maybe I'm trying to find Bad Kitty on X to see.
Let's just take the stack in which I found him. Do you have a son named Brandon Sparks?
Yes, sir.
Do you remember calling him around Thanksgiving of 2008?
No, sir, that phone call never happened.
Pardon?
That phone call never happened, sir.
Well, you know what phone call I'm talking about?
I never called my son on that date, sir.
Did you call your son anytime in November and tell him that you were soon to be famous?
No, sir.
Words to that effect.
Sorry, excuse me. No, sir.
You did
That's
not do
who
that.
we
No, sir.
heard from yesterday. I gotta
When,
hold on.
well, I'll strike that. Between
I just want to
August
see how this
13th
ends at this
and
point.
December the 11th, did you ever go back out to Suburban Drive in that time frame?
Only when I had that route, sir, but I never stopped at that area ever again.
Did you have occasions to drive by the Anthony residence?
No, sir.
Did you get out of the car again and have any curiosity about the area where you had seen the skull?
No, sir.
After Deputy Kane met you there on the 13th, and you say he chewed you out,
Yes, sir.
did any law enforcement officer thereafter ask to look into or inspect your vehicle in any way?
No, sir.
Was a cadaver dog ever taken to inspect, nose around, whatever, your vehicle?
No, sir.
Were you ever asked to submit any samples of DNA?
No, sir.
To your knowledge, was there any other investigation about you by the detectives?
I really don't know, sir.
Do you know whether or not they subpoenaed your phone records, sir?
He has no knowledge of any investigation done on him.
Overall, can answer the question.
I remember allowing Mr. Mellish to take a photograph, if you will, of my phone when Mr. Evans and I were in his office, but other than that, no, sir.
You did not know your phone records had been subpoenaed by the law enforcement?
No, sir.
Were you ever questioned by them about your phone records? Who you called, who you got calls from?
No, sir.
Did you have no contact whatsoever with any of these people between August the 13th and December the 11th?
What people are,
What people?
Sustain, rephrase the question.
Detective Melich, Detective Allen, Edwards, FBI Savage, FBI McLeay, any of the law enforcement people that you met?
between what dates again, sir?
August the 13th and December the 11th, 2008.
No, sir.
Okay, well, let's move ahead then and talk about December the 11th. Were you on this same route again?
Yes, sir.
Reading meters?
Yes, sir.
Read Anthony's meter on Hope Spring?
I did not get that far, sir.
Go back to the site on Suburban Drive where you said that you had seen a skull on August the 11th.
Yes, sir. I guess so.
Did you go by yourself?
Yes, sir.
Did you go into the woods?
Yes, sir.
Were you searching again when you went in the woods?
No, sir.
On December the 11th of 2008, sir, did you find what turned out to be the remains of Kaylee Marie Anthony?
Yes, sir.
And did you find those remains same place you had last seen them, or were they somewhere else?
I had never been to where that bag was, so I would have no idea, sir.
Well, now, you've told us about seeing a bag and seeing the skull, and then you drew a map, which we have presented.
Yes, sir.
When you went on December the 11th, were the remains, including the skull, the same place that you had seen them in August, or had they been moved?
I cannot answer that question, sir. It was in August, it was flooded. December, it wasn't. It was much more grown up in August. It was much less in December. I have no idea.
Did you ever, after August the 13th and prior to December the 11th, renew contact with law enforcement to ask what's going on with finding the skull that I found in August.
No, sir.
You just let it go.
Yes, sir.
And when you went in on August the 11th, sir, you said to us you saw the bag and the skull. We went through that. When you went back on December the 11th, you see the same bag,
No, sir.
same skull.
I would have no idea, sir.
And when you went back in there on December the 11th, sir, and you saw this skull, did you do anything with your reader stick?
Yes, sir. I was standing behind it. So I was looking at it from behind and I still didn't think it was real. So I very gently took it and put it into the right eye socket and I gently pivoted it up and I
There
looked
we
down
go.
and I realized what it was and I set it down as gently as I could and went up and called my area supervisor.
For the record, your reader stick, would you describe what it is, please, sir?
It's just a piece of metal about 4.5, 5 feet long with a curved end. And then we tape it up on the end of ourselves to make it more comfortable to carry.
For lifting lids of meters to the ground?
Yes, sir.
And it's your testimony that you put that stick in the eye socket of the skull and lifted it up to be sure what it was?
Yes, sir. I apologize for doing so. But like I said, I did not know what it was.
And then you put it back.
Yes, sir.
There's no question in your mind that you lifted it up with the stick to look at it.
I gently pivoted it up. I never took it off of the ground, sir.
It wasn't stuck in the mud, was it?
No, sir.
Wasn't stuck in anything, was it?
After finding what I found, the shock of it, I just really can't tell you. I mean, that was a very horrific thing for me to find, obviously.
And after you did that, sir, did you call your boss or 911?
I called my area supervisor.
You didn't call crime line?
No, sir.
You didn't call 911?
No, sir.
You went back to your vehicle?
Yes, sir.
You called your supervisor and said what?
I told him that I needed him there immediately, that I had found a human skull.
And did you say where you were?
Hey guys, if you could just do me a quick favor and make sure to like this stream, subscribe to my channel. We're going to be giving away 5 memberships as long as we get to 50 likes today. The last thing I wanted to mention is the website and the promo code that I added earlier in the chat. You have to add a product. Once you click on the website, it'll take you, you can look at products, add a product, then you put the promo code in and it should take off 10%. So sorry for the confusion. Thank you so much.
Alex had been with me on the first, that route is actually a 3-section route. And Alex had been with me right up into the end of the first section. And so I can't remember if I told him where I was or not.
Who was that supervisor that you spoke to?
Alex.
Your last name?
I'm horrible with names, sir.
Did you then hear discussions on the utilities radio about what was going on without telling us what they were?
I pretty much tuned all that out.
Did Deputy Sheriff show up pretty quickly?
I believe so.
You remember who you talked to first from the Sheriff's Department?
No, sir.
Did you ask one of the deputies live if you were still entitled to the $225 or $55,000 reward?
No, sir.
Do you have any discussions about that entitlement to reward at all?
I really don't remember, to be honest with you.
You remember one of the deputy sheriff's name was Pamela Porter?
No, sir. I don't remember any names from that day. Well, other than Detective Mellish, but other than that, no, sir.
Did you ask that female deputy if you were still being entitled to reward if that's the baby and she's dead?
I might have. I honestly don't remember.
Did you also tell Deputy Porter that you wanted to keep it quiet so your ex-wife wouldn't find out about the money?
Oh my
I might have said that
God.
jokingly.
What a piece of shit.
Did you talk with Pamela Porter about why the Sheriff's Department had not done anything when you had called before in August?
I probably did because I was still upset about that time.
You were upset still in December about them not doing anything in August?
I just simply tried to do the right thing. And for my efforts to try and help and be a good citizen, I basically got chewed out for half an hour and was just called horrendous things. And yeah, I was still pretty pissed off by that.
You were angry with the Sheriff's Department?
No, I'll never be angry with the Sheriff's Department. It wasn't their responsibility. One person doesn't do, make a whole department, sir.
You were just in general anger because nobody believed you about finding the skull in August.
Asking for speculation as to what another person did or didn't.
Were you angry, sir, that you apparently were not believed?
No, sir.
You remember talking to, in fact, your supervisor, Alex Roberts, on
Yes,
that
sir.
day?
Excuse me. Yes, sir.
Did you talk to him about the fact you were going to get a reward?
I think we were jokingly talking about it, but it wasn't serious at that time.
Did the joke include talking about having won the lotto?
I can't remember if that was said or if it was said that I should play the lotto that day.
And did you also tell him that you didn't want your ex-wife to find out about the money?
Alex was aware of the problems that I was having with my ex-wife, and so, yeah, probably.
And on that particular day, by the way, you had not read any meters in the neighborhood?
In that neighborhood, no, sir.
You just went straight to the site where the remains were found?
No, I went into the woods to relieve myself.
Ooh, it's Slinky. Would you really like to play with me?
Do you remember talking also to the detectives about the issue of the reward that you were looking for?
We were discussing the crime line tip, sir. We weren't talking about the other one, sir.
Okay. You were joking, you say, with Alex Roberts and the others about finding this body?
No, we were joking about the money, sir. I never joked about finding the body, sir. That's not what I said.
And is that after the discovery, the time that you and Mr. Dean or others were arguing about whose idea it was first?
Once again, sir, you've completely lost me. Are we discussing August or are we discussing December?
No, I'm talking now about after the body's been found. Did you have any "I told you so" conversations?
No, sir.
Okay. And since you
Oh,
did you ever have a conversation with any of the law enforcement people in connection with this case, in which you were instructed, told, or otherwise suggested to not talk about your earlier reports in August?
To the police?
Yes.
No, sir.
And were you remember a conversation about you, as we said earlier, keeping a low profile and keeping out of the public?
Yes, sir.
And at that time, sir, did you have any conversation about not telling the world?
Sustain.
Okay. I have just a minute, Your Honor.
You may.
Mr. Clark, you have a computer?
Yes, sir.
Did you have a computer in the relevant times in summer of 2008?
Yes, sir.
Were any of your computer records requested by law enforcement?
No, sir.
Any searches for ever made on your computer?
Not that I know of, sir.
Now,
thank
one other
you.
thing I want to talk to you about. On December the 11th, after you found these remains, had you been working the day before?
No, sir.
You have a day off, in fact?
Yes, sir.
And was there a special purpose why you had the day off?
Yes, sir.
What was it?
Clutch went out of my vehicle.
You had to have car repairs?
Yes, sir.
And sir, did you have a need for some money on that day, the 10th of December?
Yes, sir.
Oh, we're at 33
Over
lights.
$1,000 you needed for truck repairs?
Yes, sir.
And on that date, do you recall saying specifically on that date anything to your son or anybody else about needing money?
I might have mentioned it to him, but I don't remember specifically, sir.
And it's the very next day, December the 11th, if you go back to Suburban and you make this find.
Yes, sir.
I will show you what has been marked for identification as Defense Exhibit FN. Ask you if you recognize it, sir.
This is the bill for my car to be repaired, sir.
Is that a true and accurate copy of the bill you got for your repairs on your truck on December the 10th? Yes, sir.
Talking online.
Off of this next exhibit and evidence, Your Honor.
What says the state floor?
No objection.
You received an evidence as defense exhibit numbered.
All the questions I have at this time, Your Honor. Thank you very much.
Cross-examination?
Good afternoon, Mr. Kronk.
Good afternoon, ma'am.
Do you know Casey Anthony?
No, ma'am.
Do you know Lee Anthony?
No, ma'am.
George Anthony?
No, ma'am.
Cindy Anthony?
No, ma'am.
How about some investigators by the name of Dominic Casey or Jim Hoover?
No, ma'am.
Know those guys?
No, ma'am.
Okay. As a matter of fact, you're not even from Orlando, except for recently, correct?
Yes, ma'am.
Okay. And you don't even live in Orange County. You live in St. Cloud, which is in Osceola County near Kissimmee.
Yes, ma'am.
Okay. When did you move to Florida?
Like August. No, it was August 1st or 2nd of 7.
2007?
Yes, ma'am.
And you testified already that you got this job working for Orange County Utilities at the end of May of 2008.
Yes, ma'am.
You underwent a period of training with Orange County.
Yes, ma'am.
As far as neighborhoods in Orange County, since you weren't from here and didn't live here, how did you even become familiar with these places where you needed to be?
I had a GPS, ma'am.
Okay. So when you got your assignments on a daily basis to go read meters in someone's neighborhood, you had to put the coordinates or whatever into a GPS so you knew where to go.
Yes, ma'am.
Finally, after a period of training, you were allowed to go out and about in Orange County and read the meters on people's houses.
Yes, ma'am.
And it wasn't until August 11th of 2008 that you ended up being assigned a route that included the Anthony's house on Hope Spring Drive.
Okay.
Yes, ma'am.
I don't think we
You
need
read their meter that day?
Yes, ma'am.
Would that have been the first time you were ever even in their neighborhood?
One time before, when I was training with David Dean, we happened to be in that area and he drove me by the house. So that was actually the first time I was ever there. So.
Okay. And aside from that and reading their meter on August 11th, the only other time you said you were responsible for reading meters in that neighborhood in November.
Yes, ma'am.
And then December 11th of 2008, they would have been on your route.
Yes, ma'am.
As far as August 11th goes, and I want to make sure we have this chronology down correctly. So if I say something wrong, correct me.
Yes, ma'am.
August 11th, you finish your route. And then in the afternoon, coworkers of yours meet with you on Suburban Drive before you all head back to the office on Curry Ford Road,
Yes,
correct?
ma'am. What happened was that, like I said before, that's like a 3 neighborhood route. And the last part of that route is like right, if you're heading, I guess, southerly, there's like a little neighborhood that goes down and it's just like a little street that elbows out and comes back up. I was almost finished with, the second part of the route when David with a new trainee, Chris, came by and said, what have you got left? And I said, well, I've got this. And they said, okay, well, just finish what you've got. We'll go do that for you. And then there's a shady area down between, before you get to the school and just meet us there. And then of course they just give me the numbers. I just punch them in my handheld.
All right.
So,
Because of course, in August in Orlando, it's hot as blazes.
yes, ma'am.
What maybe just said, I'm just going to pull it up right here. Go ahead and comment with the number that you are in terms of likes. If you just want to be eligible, throw your hat in the ring. So that would help. Thanks.
Right. So you guys kind of help each other out, finish each other's routes so that you all can be done for the day because you start at 7:30 in the morning.
Yes, ma'am. We got in at 6:30. We were out by 7. And obviously when you're doing an area, you have easy routes and hard routes. And whoever gets done first will always go find the people that are still out there because it's just brutal this time of year to be out there and doing that kind of work. So.
And you're walking the neighborhoods all day long in that heat.
Yes, ma'am.
So at the end of, or close to the end of what would be a normal shift on August 11th, you and these other guys are stopped on Suburban.
Yes, ma'am.
This is when you have to relieve yourself in the woods.
Yes, ma'am.
And when you are in there, you look around and
Yes, ma'am.
see something as you've described to the 911 operator ultimately, or the non-emergency line individual that you thought was suspicious.
Yes, ma'am.
You come back out of the woods, correct?
Yes, ma'am.
After you relieved yourself, made this observation. The other guys who work for Orange County Utilities are there, and you make some reference to the fact that you saw something suspicious in the woods to Mr. Dean, correct?
Yes, ma'am. They were still at their truck and I was walking towards that area and I had stopped and all of a sudden both of them started screaming, excuse my expression, like little girls. And I'm like, what?
About the snake.
And I looked down and there was a dead rattlesnake next to my foot.
Okay. So then, as you've already told us, everyone gets all excited about the snake, loads it up in the car, and
yes, ma'am.
goes off and acts silly about it.
It's because
So that's your last discussion with those guys out there about what you saw or thought you saw at that point in time in the woods off of Suburban.
Yes, ma'am.
Correct? Okay. That day, you described to the 911 operator that on both sides of Suburban, it's a swamp. Is that because it's all or was all wet in through there?
Yes, ma'am.
You also indicated at some point that you were looking down on something. Is that because the street level of Suburban goes out for a bit and then drops off into like a bowl?
Yes, when you're coming,
there?
excuse me for interrupting, I'm sorry. There's a grassy area and then there's like this veil of vines and all that at that time. And then it immediately slopes down into a lower area. And that's where all the water was collected and the debris and everything else.
All right. So where it slopes and then is lower than street level, was that full water?
Yes, ma'am.
Okay, on August 11th.
Yes, ma'am.
You eventually go home that evening. You indicated that you had a discussion about the observation that you had with your roommate after 9 o'clock. That night is when you make that first call that we heard, correct?
Yes, ma'am. I was not allowed to interrupt her while she was watching television, so I had to wait until 9.
Okay. So you're at your residence in St. Cloud, which is in Osceola County, correct?
Yes, ma'am.
So you find a number for Orange County non-emergency?
Yes, ma'am.
Okay. And somehow in that process, you get transferred over to what sounds like a 911 line. They ask you what your emergency is, don't they?
Yes, ma'am.
Okay. And then, of course, what you said to them has been recorded and we heard. Did they ask you at 9 o'clock at night to go meet them somewhere that's not on this recording?
No, ma'am.
Did you have some expectation that you were going to leave your house in St. Cloud that night in the dark and go try to explain where this was and what you saw?
No, ma'am.
All right. So you gave them that information, and then what they did with it was up to them.
Yes, ma'am.
The next day, you call again with the same information.
Yes, ma'am.
Is that correct? And this is also after 9 o'clock.
Yes, ma'am.
And at that point in time, did you have some expectation that you were going to leave your house? Were you in your house in St. Cloud?
Yes, ma'am.
Did you have some expectation that you were going to leave your house and travel to Suburban Drive after 9 o'clock at night in the dark and meet with a deputy and explain exactly where along Suburban you were talking about?
No, ma'am.
Okay. So you call Crime Line, excuse me, you call Crime Line that same night,
Yes, ma'am.
second day, give them information. And then on the 13th, after work, while it's still light out,
Yes, ma'am.
you call from the location wanting a deputy to meet you there so you can tell him or her, whoever arrives, what you saw and where it was.
Yes, ma'am.
So you can be specific.
Yes, ma'am.
Okay. And this is the event that you've already described for the jury, where a deputy from the Orange County Sheriff's Office, a male deputy with a female, meet with you.
Yes, ma'am.
It's the male that goes down that slope that you talked about.
Yes, ma'am.
Okay. And you said that he just did a cursory sort of looking around, didn't do much of anything.
Yes, ma'am.
And then proceeded to either argue with you or berate you about why you were wasting his time or the county's time.
Yes, he was berating me.
The female stayed up on the road,
Yes,
didn't she? Did you stay up on the, I guess for lack of a better word, the berm, or did you go down into that lower area where this deputy went?
I stayed on the grassy area, ma'am.
Up higher?
Yes, ma'am.
Okay. So what you could see at that point was that he spent next to no time looking around, came out, slipped, fell, got annoyed.
Yes, ma'am.
And you didn't like that.
No, ma'am.
So he says there's nothing there, you leave.
Yes, ma'am.
And because of how you were treated, you let the matter go.
Yes, ma'am.
Aside from your work responsibilities, had you ever been at the Anthony house?
No, ma'am.
Let me ask you this first. Mr. Mason talked about you're needing money on December 10th
Yes,
because
ma'am.
you had a clutch go out in your car.
Yes, ma'am.
Would you have needed money in June or
That's
July
why.
or August, September, October, November 2008 for other reasons?
Yes, ma'am.
So aside from your work responsibilities, you've never even been near their home, correct?
Yes, ma'am.
You've never had any access to Casey Anthony's Pontiac Sunfire, I take it.
No, ma'am.
You've never had any access to the garage of the Anthony family residence, I take it.
Overruled.
Have
No.
you ever had access to the home of the Anthony family?
Other than the meter in the front yard, no, ma'am.
Okay.
And when you read their meter on
No, I
August
get it.
11th of 2008, well, there were a bunch of people around, weren't there?
Directly across the street, there was tons of media there.
That's why they've been harping about this.
You've never had access to the inside of their home, I take it.
No, ma'am.
You've never had access to their backyard.
No, ma'am.
You've never had any access to their computer.
Overruled.
You've never had any access to the computer in the Anthony family residence, I take it.
No, ma'am.
You've never had access to any of Kaylee Anthony's clothing, I take it.
No, ma'am.
You've never had any access to Kaylee Anthony's diapers or pull-ups or underwear, anything like that.
No, ma'am.
You've never had access to any of the laundry bags that may be in the Anthony home or were at one time,
He
correct?
understood the
Yes, ma'am.
assignment.
Never had access to any of the garbage bags in the Anthony home, correct?
Yes, ma'am.
Never had access to any of Kaylee Anthony's blankets, correct?
Yes, ma'am.
And never had access to any of the duct tape in the Anthony family home, right?
Yes, ma'am.
Thank you, Your Honor.
Got it.
Redirect.
He's like, hell
Then
no.
witness
I
be
never
excused.
want to talk to this man again in my life, sir.
Witness is excused, subject to recall. You will be contacted, sir. Thank you very much.
Thank you very much.
Okay. We are going to go with
You may proceed.
Thank you, Your Honor.
this.
Good afternoon, sir.
How you doing?
What is your name?
David Dean.
And
Up your time with regard to teaching, reading, giving lectures, working with individuals suffering from grief or trauma related issues, what would be the approximate number of hours over your lifetime that you have focused on this topic?
Well, if I work 20 hours a week and there's, let's say 48 weeks in a year, times 40, what's that? Somewhere around 38,000 hours.
Huh.
And what books, if any, have you authored with regard to grief?
I wrote Coping with Death and Dying. And if you want to know if you're dying, ask the cleaning lady. And I have been a contributor to the series of Chicken Soup books. And
The series of Chicken Soup?
And I did a piece not too long ago that Parents Magazine put out about explaining war and terrorism to children that they're using in foreign countries where there's a lot of terror and a lot of trauma.
Can we back up to Chicken Soup because it sounds like a cookbook? What do you mean when you say Chicken Soup?
The Chicken Soup books that started maybe 15 or 20 years ago occasionally ask.
Objection to the relevance to her qualifications.
Could I just identify?
I actually agree.
Go ahead.
When those came out, they were really seen as a help book for everyday folks. And what they did is come to several people that they knew did different kinds of things and ask if we would tell one of our stories in the book about how people do get better. People can be dignified and can manage things. And so those little vignettes seemed to really ring a bell with folks that were struggling through some of the very same issues. And so that's what those books are. They're a set of short stories that are biographical for the most part.
Okay. My objection to the relevance of Chicken Soup books to her qualifications.
And what's the name of the Chicken Soup book that you participated in?
Oh, there it is.
Well, I see it out in lots of them. The original one was Chicken Soup for the Surviving Soul.
Okay. And have you authored any chapters in any books having to do with grief?
Yes, I'm on the editorial board for one of the trauma journals, and I edit other folk stuff that comes in. And
Objection, Your Honor, not responsive. The question was, has she authored any chapters, not edited?
Your Honor, I'm objecting to the speaking objections.
Objection overruled.
I've authored chapters that often have to be edited to fit in the space that they're supposed to be in.
How many chapters, approximately?
Half a dozen more. I do more editing of other people's work to go into books.
Okay. And what is Compassionate Friends? And what is your relationship with that organization, very briefly?
Compassionate Friends is a now international class in a normal college curriculum.
And did you have involvement in actually setting up some of the curriculums?
Oh, half a dozen.
And on what subjects?
Compassion fatigue, compassion energy, end of life issues for children and how parents choose to dispose of their belongings, gay women with AIDS and their treatment in hospice situations.
And what are the peer-reviewed journals in which these were published?
Southeast Research Journal. After Katrina, we wrote a grant for.
Objection, Your Honor, not responsive. I just asked for the journals.
Well, I was going to tell you they were online journals, and the online journals.
Okay, I'm sorry. Hold on a second. Southeast something journal. Say that again.
Research
Journal. And
We're done with court here.
Oh, the Journal of Traumatic Events. Several of the journals that come out of Charles Figley's work at LSU.
Yep, we're good.
I look a lot at the instruments that are going to be used in other journals as one of the things that a doctoral student, for example, may use as a tool in her original research about grief and loss. I do a lot of that. Work with the IRB board, which is the part of any university that decides whether the research that the students are going to do is valid. And
okay, that's a good sampling.
Okay, thank you.
Doctor, can you tell me please whether or not everyone suffers grief the same way?
No, they don't. No, it's not that I can't tell you, but no, they don't suffer it the same way. If I were to poll the room, we would find that each of you do it differently. What I find in my own patients is just a plethora of differences in how they handle terrible news.
Can you describe some of those differences?
I work a lot with parents that lose children, and
let me object to questions in general that don't involve the facts of this case as not relevant.
Let's approach the sideline for just a minute. You may proceed.
Thank you. Dr. Carey, I'd like to give you a hypothetical, and then I'm going to ask you a question about that hypothetical. I would like for you to assume that a 22-year-old mother of a young child, almost 3 years old, who has a loving bond with that child and is an amazing mother to that child, loses that child. That child dies. Could you please describe for me the demeanors that would be consistent with grief given that hypothetical?
Objection. Pursuant to, pardon me, Harrison versus Byrd, 256, 7 second, 50. It is
Let me see the case.
Sure. May we approach?
Yeah. You may continue.
Thank you. All right, I'm going to ask the question again. I'd like you to assume a hypothetical in which a young mother, a 22-year-old mother of a young child, almost 3, who has an amazing and loving relationship with that child, a special bond, assume that that child dies. Can you please tell me what the demeanor or reactions one could expect, which would be consistent with grief, given that hypothetical?
Well, again, since everybody does it differently, and I think that that's imperative because it's one of the ways that we decide how other people are doing in relation to how we would do ourselves. I certainly have seen mothers who have lost children that they had loving and wonderful bonds with go face down in the bed and stay there for months sometimes and not be able to get from the bed. They don't wash their clothes. They keep the sheets on the bed. That the way they deal with that event is to keep everything close. Conversely, I have seen parents, mothers whose child died, coming home, and we all know no one promises us tomorrow, so they don't make it home. They clean out the room, they give away the clothes and the toys, and all pieces of that little one in the house are put away in a box or given away to Goodwill, and he's not spoken of. And often the parents will say, it was just too painful to have all of these memories. Well, another parent will say, it's the memories that are getting me through. And some people go to the cemetery every day, and some people say, it is way too difficult for me to go to the cemetery every day because I don't think he's at the cemetery every day. In younger adults, certainly among college-age kids, they have a tendency, they're reluctant grievers. They have a tendency to buy into the grief issue, and they often manifest very risky behavior. I mean, if they had a friend died who was drinking and driving, they might do the same thing.
Objection to testimony about types of grieving unrelated to mother and child. No, in this case.
Your Honor, may I respond and object to the speaking objections? This individual.
Objection overruled. Continue to answer the question, ma'am.
Well, if a mother's in a car with a baby and there's an accident and the mother had been drinking, for example, it is I have certainly seen this in more than one occasion where instead of stopping the drinking, they may continue the drinking and have risky behavior. We sometimes call it survivor guilt, especially if the mother were to live and the baby were to die. But what I have found is that I've never had a single patient do it exactly like another single patient. And that is often unsettling for folks that look at other people's behavior and say, I would never act that way.
Objection to commentary about how other people view grieving individuals, not responsible.
Sustained.
All right, let me add to that hypothetical. Let's assume the mother who lost the child comes from a family who copes with stress and trauma by engaging in denial and non-communication.
Objection assumes a fact, not evidence.
Your Honor, I can go through the list of.
Don't do that. Come to the side.
She is calm, cool, and collected.
Rephrase the question.
All right, thank you. I'd like to add to that hypothetical some additional information I would like you to presume and add to. Assume that the mother is tiny in stature and weight, and assume that she becomes pregnant and her pregnancy is visible. Assume that the father explains the visible pregnancy as a result of her athletic pursuits. Assume that the mother explains the visible pregnancy almost 8 months as a result of the opposite sedentary job.
Objection assumes fact, not evidence.
Overruled.
Assume that the mother's brother, the mother of the young child, the mother's brother knew that she was pregnant and approached the young girl's mother about it and was told to stay out of it. Assume that the girl's mother is a nurse and was not taken for a pelvic or OBGYN visit until she was 19 and already pregnant. Assume that the daughter tells her mother at the 11th hour, almost 8 months, with regard to her pregnancy. Assume that the family does not inquire as to who the father is until the birth of the child.
I can provide information on the Columbus dentist because that's really close to where I am, but that trial won't be for forever. So yeah, we'll cover it. But if it even goes to trial and it doesn't plea out.
Although the daughter is unwed and living under their roof. Assume that the young girl's father is summoned to pick up a car that she has driven to an area in which it has been moved, and states that there is a smell of decomposition but in the car, but does not alert the police and does not contact his daughter, even though the statement is made that his daughter is missing. Assume that a family member, even though that family member knows that the remains of this particular child have been identified, still makes the statement that he believes that she might still be alive. Assume that the brother of the young woman is angry because he feels left out when the parents began to go and make efforts to look for the child, at one point being the remains, and not discussing with him. Assume that the brother of the young girl is angry because he is not involved and there are not discussions with regard to the obvious pregnancy. Assume that the young girl's father tells law enforcement that he was concerned about his daughter, so he followed her, when in fact information having to do with the vehicle and the sun pass indicate that she was not followed. Assume,
Judge, objection, that.
I believe that,
Go ahead,
I
finish.
believe Detective Melich did.
No, go ahead and finish your question.
Okay. Giving all those types of behavior, can you tell me, please, what that type of family environment, if any, what effect that can have on grief of the loss of a child?
Well, that was very complex. There are certainly two groups, if you'll give me a little leeway, two groups of ways that people grieve. Healthy folks with lots of family support and good coping mechanisms usually haven't lost, have great grace and dignity, make the journey in a what I would call a healthy way and come out on the other side. I don't think we ever resolve a great grief, but I do think we reconcile to a life where someone we love isn't in. And when we deal with families where there's a conspiracy of silence, as it were, where the kind of the rules of the family might be don't talk, don't feel, don't share, translated, we don't air our linen for other people to see. And in those situations, it's very likely that the response to a traumatic episode would often leave other people difficult to understand what has happened.
Objection to comments on how other people would view. It's not responsible.
And this person
Yeah.
would do.
Just a second, doctor.
Witness not.
Just a second, doctor. Wait till he finishes his objection before you continue. Have you finished?
I have.
Okay. Sustain as the other people, doctor. Just deal with the people that you've been instructed to talk about.
Hypothetical.
Yes, sir.
Yes.
Yes, ma'am. Thank
Yes,
you.
sir. That in hypothetical situations, we can see
Kook.
that denial is a great helper. The story that may have happened can be changed a little bit. It's in many of these situations like you describe, and the one that you've described right here, I could see that it would not be atypical for there to be no discussion or discussions that may not look unusual or aberrant, and certainly difficult to understand.
All right, let's add to that hypothetical some additional information. Let's add to that hypothetical that during the 31 days after that child is gone, the young mother leaves home, goes out, rents movies, goes shopping, goes out to a bar, gets a tattoo that, when translated, indicates beautiful life.
Yeah, an important.
That kind of
thing.
behavior. Can you please describe for me the significance of any with regard to that type of behavior and grief reactions?
Well, there's more than in what you described. It would be important to look at the behavior of what everybody did in those 30 days. And what I often see in young adults, and in this situation, it seems very, very like other young adults, is they are reluctant grievers. Young adults are reluctant grievers, and they will often say nothing has happened. They will demonstrate risky behavior. They'll go out and do the very thing that their
Absolutely
friends died
disagree.
from. They will drink too much. They may drug too much. They may, retail therapy is a big event among young women. And I don't know about this particular case, but let's say in this particular case, the thought that if I can acquire enough things, I can make this go away. And partying sometimes to the point
We're
of
getting there,
right on the
Daniel.
edge of hysteria, which there's a real close bond between mad and sad. And they look very different, but they actually are both responses to a loss issue. And so when I look at young adults who have limited exposure with the world and appropriate kinds of behaviors, I see often risk-taking, repeating the things that happened to the person, looking like they're having such a great time, spending all kinds of money they don't have, getting into trouble. Might be minor, but it's called bereavement overload. And when,
I'm sorry, what?
Bereavement overload. And when someone has had loss after loss after loss, they'll then act out because they've decided that they don't want anyone to be near them because everyone that's near them leaves them. And so, and it doesn't, I know you all know that death isn't the only loss in the world. I mean, we walk such a fine line between our job and our children.
At this point to the narrative
Oh,
that's lost the
I think she's done.
How long, Dr. Carriot, can this type of behavior last? And when I say this type of behavior, I'm going to be real specific. This type of behavior appearing normal, appearing fine, no change.
Appearing fine.
Your Honor, the witnesses never testified that appearing normal with no change is an aspect of grief.
Your Honor, this is a question.
Overruled. She can explain.
Yeah, and we need to always distinguish between normal and healthy also. I certainly have seen there is a great difference between grief and trauma. We grieve by thinking what we lost, and at that point eventually get to a point where we're okay. With trauma, if we think about a trauma and it's so awful, we'll stop ourselves. And years later, if no work has been done, years later, if someone asked this person, for example, to tell the story would sound almost exactly the same, and the behavior would change very little because they got stuck on the trauma and weren't able to get that in a workable place and never got to doing grief work. Grief and trauma are two very different concepts. So I certainly have patients that have kept original grief responses for years and years and years.
And what do you mean when you say original grief responses?
They are just as, they may still be drinking, they may be self-medicating, they find themselves in a little nest, their world gets smaller after a while where they're most comfortable, where there's not a lot of people around. Their affect is often distorted, and then people around think, this person isn't feeling about this at all. And that kind of affective hysteria, if you will, is such that it's their response to grief when they've come from an environment where they never had healthy coping mechanisms, and at the same time may have been told to never talk about things that happen in a family.
Have you treated individuals who have lost a loved one who have appeared exactly the same according to, for example, friends and family members as part of your practice the day before and the day after the loss, and continue to appear that way for years afterwards?
Yes. I have seen people lose a child and make arrangements and then go to work the next day and the next day and the next day. I've seen children come back to Florida State who have lost a grandparent over the weekend and delve into sorority life and become a hotshot student or a very bad student, as though nothing has ever happened. Or if someone comes up and says something, I don't want to talk about that. Denial is a great tool for as long as you can make yourself believe what you're saying.
I think I've heard enough.
Said, they tell me my brother is dead, but that doesn't mean I have to believe it.
Are you guys ready for the craziest testimony? I think it's going to be our last before our closings. Or do you guys want to listen to the traumatologist?
Sustain.
So,
Ma'am, Your Honor, we have
let me know.
Next question.
That's all I have, Your Honor.
Cross-examination.
Thank you.
He
Is being very, very happy
her.
consistent with grief?
Can be.
Is being very, very sad consistent with grief?
Yep, there are three emotions: sad, happy, and mad are the three that we see most often.
Are there any variations on the continuum between happy and sad that are not consistent with grief?
Well, ask me that again.
Well, what I'm trying to figure out is every state of demeanor between very happy and very sad consistent with grief?
On the entire continuum. I think I would be remiss if I didn't say I have seen patients virtually at dock in at any one of those levels.
So there is nothing about the demeanor in that way that is either excludes or includes grief. It can be anything.
It could be.
Okay. How about,
That's okay, Daniel.
how do I say this? Interest in sex.
Yeah, it's.
Is there any?
There's research that shows when you don't have words to make things better, sometimes it's a method of feeling better.
So basically anything on the continuum from a complete lack of interest in sex to promiscuity, all of that is consistent with grief.
Scope of the direct.
Overruled.
Is that your testimony?
Well, I think promiscuity is maybe taking it too far. I think that in the death of some folks who were very, very close, find that they will do things that they hadn't done in the first 40 years, just for the comfort of it.
All right. So any reaction in terms of your sexual desire from promiscuity to frigidity is consistent with grief. Anything. Is that right?
There are not facts to support this, and I think it also exceeds the scope of the direct.
Overruled.
Is that correct?
I have certainly had.
That's what I was
patients
thinking.
Who found that in the beginning, sex seemed to help them with their grief, and as they began to
Are we going to see
become a
sexting?
little more aware of their environment and the things that they're doing, realize that that probably wasn't the thing that was going to make them feel better.
What I'm looking for is, can you give me anything that is inconsistent with grief?
I can give you things that are inconsistent with healthy grief.
No. No. The question is there, the import of your testimony is to interpret certain facts as consistent with grief. That's your understanding of why you were called, correct?
Yes.
So tell me anything that is inconsistent with grief. Any type of activity, any type of
Before
attitude, any type
maybe
of demeanor
leaves
that you would agree is
the
inconsistent
dinner.
with grief.
I'm going to grab a drink.
Well,
And
again, if you're not
we'll
going to
start
allow
the
me
big
to say that I
testimony.
think there are healthy grief responses, and I think that there are aberrant grief responses that need intervention,
Right. I mean, we're
and
not
I must put both piles together, then I would have to say anything could happen when someone has a great grief.
So no matter what hypothetical I would give you, you would say that could be consistent with grief.
I would probably say if it were something aberrant, that is consistent with inappropriate grief response.
Okay. But what I'm getting at is no matter what hypothetical counsel gave you, you would say it was consistent with grief because everything is consistent with grief in your opinion, correct?
Everything falls into a category somewhere along the line from pathological grief responses to healthy grief responses.
Now, can you, from a set of activities, draw the conclusion to a reasonable degree of expert certainty that a certain person is at that time grieving? See what I'm saying? Not assuming that there's a loss and interpreting it as grief, but can you do the opposite? Can you look at a set of actions, not knowing what came before them and say, yeah, this is grief, or no, this is not?
Well, I have a tool that's used in medical schools called the Carrieth Loss Inventory. And if someone came to my clinic and someone ran that loss inventory on them, and I looked at the symptoms that came up, and he had a bizarre set of symptoms. I'm losing my hair. My fingernails are falling out. I can't sleep at night. I've got the hiccups. Every Wednesday, I just don't seem to get out of bed. Plotted on the diagram of that. I may very well say, tell me about Wednesdays and who have you lost and what kinds of losses have you had in your past?
And did you attempt to apply that instrument to the facts of this case?
Well, I don't know the facts of this case.
And that's the next question I want to ask you. When were you first contacted about this case?
I got an email in, I will say, the end of May, beginning of June.
And are you aware that this trial started, the evidentiary portion started on May 23rd?
No, I didn't know there was a trial.
Now, so you got an email about testifying in this case, correct?
I got an email asking if I ever did expert witnessing about grief.
When you walked in that door for the first time this afternoon, what facts had you been given about this case?
None.
So when you walked in that door, you had no idea who Casey Anthony was, how old she was, or who died.
I said at the time that I got the email. Now, I was living in London at the time and it wasn't covered there. But when I got that, I didn't know who the name was at first. So I wrote and said, there's some people in Tallahassee that do this kind of work too. And then I didn't hear anything about that. And I got another note and I thought, well, I need to look up and see who that is. And then I went, oh yes, this is something from several years ago.
So did you look and research the facts of the case
No,
a bit?
I did none of that. London carried it not at all. It was in no newspapers, on no TV. It didn't appear anywhere. And I really thought it was just a general inquiry and didn't interact about it at all.
So my question was, when you walked through that door this afternoon, what did you know about the facts of this case? Tell me every fact that you knew about the facts of this case when you walked through that door earlier this afternoon.
That I was being asked to come and talk about general research associated with grief and loss and how it might affect individuals. And that this case seemed to be about a young girl who had lost a daughter.
Have you ever worked with women who murdered their children?
Yes.
In what context?
I worked the Susan Smith trial in Union, South Carolina.
And did you testify in a similar fashion or on a similar issue to what you're testifying here today?
I testified about how people who have an enormous amount of grief can often get confused and think that the people they love the most shouldn't have to suffer as much as they do, because they can't make the distinction between their own suffering and maybe the suffering of their children.
And that was in the context of helping people to understand why Susan Smith may have murdered her children.
Checking that exceeds the scope of the direct.
Overruled.
Is that correct?
Yes.
Sidebar, please.
Yes. You may proceed.
Thank you. I believe we finished the question about Susan Smith. You refer to something called denial as a reaction to the loss of a loved one, correct?
As one type of coping mechanism, yes.
Denial doesn't mean literally lying.
Oh my
God.
Well, it certainly can mean lying to yourself.
Right. You
Forever.
emotionally pretend as if the person is still around, or you refuse to emotionally accept the loss, correct?
Yes. I mean, that's a form of it, but folks who use denial a lot.
Okay, we are 9 people away from giving away memberships. So please make sure to like the stream, subscribe, and let us know. Comment below. All right, let's get to what I think was the wildest. I need to put my headphones on.
Okay, are there any other matters you need to take up prior to 9 a.m. when we resume?
Yes, there is. This morning I was just handed some information from the state of Florida having to deal with the work records of Mrs. Anthony, Cindy Anthony, that is, that have to deal with, it appears to be phone logs, some other type of computer generated report, which I cannot understand. And more, it looks like about 231 pages of printouts of something that I really can't understand. I can only assume that this information is to rebut the testimony of Mrs. Anthony as to the dates. She said she may have run the searches for chloroform. However, there's still a discovery violation. The state of Florida knew back in 2009 that Mrs. Anthony was going to testify to this information, and they're waiting till right about the end of the defense case to decide to turn over these items to us. And in the event that this becomes an issue, we may need to, I don't know if we take a continuance to depose the individuals, find out what this means, how it relates to this case. And then also, these are only the records for these days. I would like to also subpoena records for other days where we know Mrs. Anthony was not at work, so we could kind of see and compare the activity between when she's at work and when she's not at work. And I think that would give us a better estimation as to whether someone can use someone else's computer or whether there are strict computer access requirements at her workplace.
Well, we'll be stopping today at 5 o'clock. So if y'all need to take anybody's deposition, you have from 5 to midnight to take their depositions tonight. But let me ask you this question. I presume that when you put Ms. Anthony on the stand, you knew what answer she was going to give to the questions that you asked dealing with those computer searches being done by her, and the fact that I take it that they had previously provided you with time cards. And the state will reply, but I assume they provided you with the records that were introduced where it showed that she was at work. And then Ms. Anthony testified that, well, that doesn't necessarily mean that she was there. Okay, so.
All right, Judge.
And it's sort of logical that, well, we will see, we will conduct a Richardson inquiry at the appropriate time. But my suggestion is whatever witnesses you want to talk with, y'all can schedule them for deposition this afternoon at 5 o'clock at the conclusion of the proceedings, or have them on standby. So you can take them earlier if you want to see what they have to say. But it's sort of logical if someone testifies to A, somebody's going to try to see if B is not exactly true or false. So we'll do a Richardson inquiry and determine whether or not, one, this is a discovery violation, and two, what prejudice, if any, is suffered by
Crystal Holloway, KRYSTALHOLLOWAY.
You may proceed. You may proceed.
May I please the court, Mr. Ashton? Good morning, ladies and
Know who
gentlemen.
this is?
Good morning, Ms. Holloway.
Morning.
Are you known by any other names?
Yes,
What name?
River Cruz.
Why do you use that name?
Well, my father used to call me River, and my mother's maiden name was Cruz.
What?
Okay, better? Okay,
Your father used to call you River, and your mother's maiden name is Cruz.
right.
Are there any other reasons why you use that name?
No,
Okay.
Where are the jokes?
Do you know George Anthony?
yes.
How do you know him?
I met him at a tent when his granddaughter was missing.
When?
I believe it was August, maybe.
August of what year?
08, yeah,
2008?
correct.
Okay. And how often did you go to the tent?
Every day,
Okay. And did you get to know Mr. Anthony a little better?
yes.
Did you develop a relationship with Mr. Anthony?
Yes, sir, I did.
And was this an intimate relationship?
Yes.
And did Mr. Anthony go to your home or your apartment?
It was my home, and yes, he did.
About how many times did he go to your house?
Maybe 12.
And did you ever loan or give Mr. Anthony any money? Direct impeachment.
May we approach that branch?
I had heard
Objection
rumors.
sustained. You may continue.
Ms. Holloway, did there ever come an occasion where you had a heart-to-heart conversation with George Anthony as to what happened to his granddaughter?
Yes.
Okay. Tell the ladies and gentlemen of the jury what you were doing and how that all transpired.
The particular night that you're referring to,
Yes.
he was sitting on my couch, and I was sitting on the floor, and he had said it was an accident that snowballed out of control, but I was in shock. And by the time I looked up, his eyes were filled with tears, and I didn't elaborate. I didn't ask him anything further.
Was this before Kaylee was found?
Yes, sir. It was around Thanksgiving time, I believe.
And were you prompting him? Were you asking him?
No, sir.
Okay, so the topic just came up and
Well, not exactly. We were talking about his daughter. And if I'm not mistaken, I did mention I didn't think that he can raise somebody.
well, don't give us your opinions. That's all right.
Your Honor, the witness is interrupted. The witness needs to allow to finish her version of what she said to Mr. Anthony before you make a statement.
What?
That's fine. If that's, go ahead.
Go ahead. Sure. Answer.
I didn't think that he could raise somebody that was capable of harming her child. And that's when he said it was an accident that snowballed out of control. But I was caught off guard with it. And by the time I looked up, he had tears in his eyes. And I didn't say anything after that.
And how,
What's the issue?
when did your relationship end with Mr. Anthony?
I believe it was on the 4th birthday balloon release.
Okay. Would that have been, do you have a date, a rough estimate of when?
Not offhand. Whenever they had the balloon release, I had attended.
When the Anthonys held their memorial for Kaylee Anthony, were you still in a relationship with George Anthony?
Yes.
Okay. I'd like to show you what has been marked Defense Exhibit FT. May I approach the witness?
You may.
Before we get into that, after the relationship ended, did you go to the media or tell anybody about your relationship with Mr. Anthony prior to being contacted by police?
No, I did not.
And how were you found by police?
From what I understand,
False for hearsay.
Sustained.
When did the police first contact you?
2 years later, after.
And they came to you, and did they present you with anything?
Yes, sir, they did.
What did they present you with?
One of the very first questions, if I knew George and if I had an affair with him.
And did they have any documentation in reference to your relationship with George?
Yes,
What did they have?
the text.
Okay. Was it just one text message or several? What was it?
Objection to discussions of items not in evidence.
He's not going into the contents yet.
How many text messages did they show you?
Several.
And did they ask you for any documentation?
Yes, sir.
And did you provide them with anything?
Yes, sir, I did.
What did you provide them with?
My phone.
What?
And the letters that he had written me.
Okay. Now, these letters that he had written you,
His wife is right next.
well, I'll strike that. The text message that you're looking at now, can you read? Oh, sorry, may I read that into the record, Judge?
It's not offered in the evidence. You can't read it if it's
No, I'd
not.
like to, the exhibit number, reference it.
Yes, I'm sorry. Go ahead.
You're currently looking at Defense Exhibit FT. Do you recognize that?
Yes, sir.
Is that a photograph of that text message?
Yes, sir.
Is it a fair and accurate representation of what that text message looked like?
Yes, sir.
At this time, we would move Exhibit Defense FT into evidence, Your Honor.
No objection.
It will be received in evidence as defense exhibit numbered.
Number 72.
Can you read the date of that text message to the ladies and gentlemen of the jury and then its contents?
Tuesday, December 16th.
What year?
It doesn't say.
Okay, go on.
From George Anthony. Just thinking about you. I need you in my life.
And do you recall when he sent you that text message?
Yes, sir.
Okay, why was he sending you that text message? Withdraw the question. How'd the relationship end?
He was supposed to, on the Memorial Day of when I showed up, he was supposed to come over and he didn't. And then for the next 2 days, he was texting me. And I didn't think it was appropriate seeing that I was sleeping with him. And I wasn't good enough for him to call me. And he texted me that he couldn't show up. And so when I went off crying, my sister in turn had texted him a rude message and I never heard from him again.
And did he attempt to go to your apartment complex or your condominium complex?
When?
Around that time, in December of 2008.
Basis, knowledge, hearsay. We refer to attempt, so.
Okay.
If she's aware.
Well,
She'll be aware of
wait a minute, gentlemen. Establish your foundation for a basis of knowledge. You
Yes,
may
sir.
continue.
Is there a guard gate, a guard post at your complex?
Yes, sir.
Okay. And did you have to instruct the guard at the gate not to let him in your complex anymore?
Objection. Relevance.
Overall, you can answer the question simply by yes or no.
Yes, sir.
Okay. Now, after the police had found you, did your name become exposed in the media?
Yes, sir.
Okay. And what happened?
I'm not sure what you're asking.
Were you beginning to be harassed by the media?
Yes, sir, I was.
Relevance.
Sustain.
And I'd like to a little leeway on this so I can tie it into something that I think.
Sustain.
May we approach so I can?
Yes, sir. You may. You may proceed.
When the police first asked you about the affair, did you deny it?
Yes, sir, I did.
Why did you do that?
Because I felt that he would get in trouble, and in the manner that it ended, I just assumed that the media would find out about it if I told the detectives. And so I initially lied because I was embarrassed.
Were you also in a relationship at the time?
Yes, sir, I am. That's correct.
Were you when you told that to the police?
Yes, sir.
And were you when you were seeing Mr. Anthony?
Yes, sir.
And did you eventually tell the police after the initial time that you did have a relationship with him?
Yes.
Hearsay.
Overall.
Go ahead, answer.
I'm sorry.
Did you eventually tell the police the truth?
I did tell them the truth.
And was that after being confronted with all of the other text messages and information?
Sustain.
When was that?
I'm sorry.
When did you finally tell them the truth?
I had no choice behind the texts.
Okay. When you say that, you mean you were confronted with it?
Correct.
Now, after this, prior to the police finding you, and subsequent to that, your name was released and all the information came out, did it not?
Yes.
And after that, did you then sell your story to a tabloid magazine?
No, I did not.
Okay. Did you give an interview?
I did
to
give
the
an
Inquirer?
interview.
Okay. What happened?
Well, the gentleman that did the interview offered me the chance to tell my story in full because the media, he said that the media would edit.
Hearsay.
Sustain.
Just tell us why you did it.
I felt that the media would edit certain things and make me look like trash. And he gave me the chance to tell my story in full.
Okay. And do you have a twin sister?
Yes, sir, I do.
And as part of that interview, you got compensation, or your sister got compensation?
Correct.
Are you here testifying truthfully?
Yes, sir, I am.
I have no further questions.
What?
Did you want to come here and testify today?
Yes, I did.
Why?
Because.
Why?
Sustain.
I have no further questions.
Cross-examination.
Ms. Cruz, at the time that you inserted yourselves into the Anthony's lives, they were already celebrities, weren't they?
I don't think they were celebrities.
Well, they'd been, go ahead, I'm sorry.
They were looking for their granddaughter.
They had been in the news.
Correct.
They had been on national news.
Yes, sir.
They were on the news almost every day.
Yes, sir, they were.
And then you sought them out. Correct? They didn't come to you. You sought them out.
That's correct.
Now, how much money did you or some member of your family get from the National Enquirer for selling your story?
$4,000.
$4,000. And that was just for talking to them.
Yes, sir.
Now, did other news organizations that don't pay for interviews request interviews from you?
As well as the ones that do.
And you chose the National Enquirer, which pays for interviews.
Yes, sir, but he had given me the chance to explain everything in detail, unlike the news media that edit things.
And you felt that the National Enquirer was the one news source that you could trust to tell your story and not sensationalize it. Is that your testimony?
Sir, I took what I could because I was being trashed in the media as it was.
And you felt that the National Enquirer was the one place where you that would tell
I
your story
agree with
in
him.
a fair, honest, and non-sensational way.
Well, he did.
Overall.
He did tell it.
He told it the way you wanted it told.
No, sir, I told it the way it happened.
And the story is much, much better if you're actually having an affair with George, right? It's much more sensational.
I did have an affair with George.
But you would agree that the story is much sexier if you're actually having an affair with George than if you're just a friend.
That's not true.
Judge, argumentative.
Overall.
So you do not agree that in your perception that this story is better if you're actually sleeping with George Anthony.
That's not true.
Now, you indicated that George also sent you letters.
Yes, sir.
If I may have it. Show you State's Exhibit RS. You recognize this as a letter that you referred to in correct definition, one of the letters you were sent.
Yes.
And that was sent within a couple of weeks of the text message that counsel just asked you about.
Yes.
Thank you. At this time, you've done it. Exhibit RS.
What says the defense? Let me see it, the basis of objection.
I'm sorry?
He said it was the defense's case. Objection sustained. You may proceed.
Thank you. Ms. Cruz, in early January 2008, you received a letter from Mr. Anthony, which referenced his attempts to leave messages.
Let me hear the question.
With his
Ms. Cruz, don't answer the question until I tell you to answer it.
Yes, sir.
All right. Go ahead and answer your question.
His attempt to leave messages for you through your daughter, through security, and also through your husband. That's the question.
Mr. Baez?
Objection to referencing an item that's not in evidence, Judge.
Overruled.
Isn't that true?
I'm not married, sir.
Did he send you a letter which referenced attempting to get messages to you through your daughter, security, and someone he referred to as your husband?
Yes, sir.
Were you in a relationship then?
Yes, sir.
Did Mr. Anthony believe that person to be your husband?
I don't believe so.
Did you reference this person as your husband?
I don't believe so, no.
Do you believe that Mr. Anthony thought he was, I'm sorry, I withdraw. I withdraw.
Sustain.
Did you ever do anything that would lead Mr. Anthony to believe that you were in a relationship with this other person, which was similar to a husband-wife relationship?
Yes, sir. He knew
What
I
did
was.
what did you tell him?
He knew I was in a relationship with someone else.
Now, did he also in that same letter reference your friendship with him and his wife as being very personal to them?
Yes, sir, he did.
And in fact, did he sign the letter from?
Referring to an item and its contents that are not in evidence.
The question is phrased to be sustained.
Did he send you a letter with reference as being from both himself and his wife?
Judge.
Overruled.
Yes, sir, he did.
The time that that text message that counsel pointed you out was sent 5 days after George Anthony learned that the remains of a small child had been found approximately a quarter mile from his house.
Yes, sir.
Now, you will acknowledge that you recall giving a statement to law enforcement on February 17th of 2010.
Yes.
And in that statement, you were placed under oath. Is that correct?
Yes, sir.
And you swore that the information you give today was going to be true.
Yes, sir.
And you were asked in that statement, let me have just a moment, if you were in a romantic relationship with George.
Proper impeachment.
Overruled. You got a page number?
I will get that for counsel. Just a moment. Page 11, line 2 through 7. You were asked the following questions. Question. Were you, please excuse the question, please forgive me rather, did you and George become romantically involved? You answered, no, we didn't. The question was no, and you affirmed no.
That's correct.
That is a statement you gave under oath.
Yes, sir.
When is the first time that you claim you altered that statement? In other words, that you told someone either in the media or in law enforcement that that was not true?
In February, when I told the detectives.
Well, this statement was given
I don't like the whole.
on February the 17th, 2010.
That's correct.
And did you then change that?
My sister had went to the media with it, and
Unresponsible.
when it started coming out, I spoke to the detectives, and then I told them the truth.
When?
Within a couple of days that they had first initially came to my house.
After your family went to the media?
No, sir.
I'm sorry, I thought you just said that your sister went to the media.
She did.
Well, isn't she your family?
Yes.
Okay. So after your family goes to the media with this story, then you call the police and change it to,
No, sir.
do I have the chronology wrong?
Yeah.
Go ahead.
I spoke to the detectives, and I told them the truth, that I had been sleeping with George.
When?
Within a couple of days when they first found me.
Okay. Well, they found you on February the 17th. And you said, I'm sorry, yes, February the 17th. You said the next day your sister went to the media.
No, I think it was by the end of that week.
Okay. You recall what day of the week the 17th was?
I'm sorry?
You recall what day the 17th was?
No.
Right. So your sister goes to the media with this story. When does the National Enquirer first contact you or any member of your family?
I don't remember.
It was very quickly after that, wasn't it? Not for the date, Judge.
I don't know the date.
Overruled.
Well, tell us how the contact from the National Enquirer or other media sources, how that related to your changing your story about the romantic relationship.
I had no choice but to tell the truth because my name had already came out.
Well, I mean, you had no choice but to tell the truth on the 17th because you swore you would, but you lied.
Yes, sir, I did lie.
So what we're trying to figure out now is when this change in the story took place and how.
Within that same week when I first initially spoke to the detectives.
And that was about the same time you were talking to the media and selling your story to the National Enquirer.
No, I did not. And no, I did not speak to the media. I wanted no part of it.
When did you first discuss giving media interviews to the National Enquirer?
Possibly the end of the week, sir.
Now, let's get to the statements that you claim that George made. What you were talking to him about his daughter and how you couldn't believe that he could raise a daughter that would deliberately kill her child.
That's correct.
And what he said to you is, I really believe it was an accident that just went wrong. Isn't that true?
That misstates her statement.
It does not.
It does, Judge.
Well,
That's
gentlemen,
not what she
approach the
testified.
sidebar and bring me the statement.
Thank you.
Objection withdrawn. You may proceed.
What he said was, I really believe that it was an accident and it just went wrong and she tried to cover it up. That's what he said.
No, he did not.
Do you recall, again, in your statement to law enforcement on that same date we have discussed where you took an oath to tell the truth, for counsel's benefit, page 16, line 25 through page 17, line 1. May I approach the witness?
You may.
Someone tell maybe how you are,
To the jury,
how you
what
like
you said at page
the stream on
16,
your
line 1,
phones.
and then completed on page 17. Read out loud.
He just said that I really believe that it was an accident and it went wrong and she tried to cover it up.
Thank you. Is that in fact what he said?
Yes, but he also said that.
Ma'am, there's no question before you.
Witness be allowed to finish her answer.
She is not finishing the answer. She's adding additional information.
Ma'am, finish your answer.
You didn't read what was above that was highlighted? He also said it was an accident that snowballed out of control.
Now, did he also tell you, I'm sorry, he didn't tell you that he was present when this occurred, did he?
I'm sorry?
He didn't tell you that he was present when this occurred, did he?
When what occurred?
When this accident occurred.
No.
In fact, he never told you that he knew it himself, that he knew that to be the case.
I just told you that's what he said. I never elaborated to anything else. I never said that he said anything else other than what he said.
Other than he believed it was an accident that snowballed out of control and she tried to cover it up. That's all he said.
That's not what he said. He said it was an accident that snowballed out of control.
But he didn't claim that he actually was there or knew that.
You're right. I agree with you. He didn't.
He said he believed it.
No, he did not say he believed it.
Now, he didn't say that he knew it, and he never said that Casey said it.
No, sir, you're right.
He also told you on another occasion about an incident involving, just a moment if I may.
I am going to talk.
Was there another incident he relayed to you where he had talked about attempting to get information about the death of Kaylee?
I don't know exactly what you're referring to.
What did he relate to you an incident where he, quote, threw his daughter Casey up against a wall, choked her?
It goes beyond the scope.
Your Honor, under 90.806, it is an inconsistent statement.
That's not true.
Sustain.
Your Honor, could we approach?
You may.
We're very chill.
Objection
here.
sustained.
No further questions. I'll return.
Redirect.
She is just going to get fried.
Ms. Holloway, the statement that Mr. Ashton read to you about you saying he believed when the statement in reference to Mr. Anthony believing that it was an accident. Do you remember that line of questioning?
Yes.
Okay. And before that, well, let me rephrase that. You had actually, that statement was taken out of context, was it not?
Yes.
Okay. And in fact, before in that line of questioning, you had said, may I approach the witness?
You may.
Oops.
Before you had said what?
That he said it was an accident that snowballed out of control.
So we're clear on that point. That's a statement you made first, and then you followed it up with the statement that Mr. Ashton tried to have you read without expressing that.
Comments on counsel.
Sustain. Let's just ask the questions.
Yes, sir. Now, this was also a statement he made when he was still out making media appearances asking for help to find his granddaughter.
Yes, sir.
And he told you basically that she was dead.
Objection to her interpretation of what Mr. Anthony said.
Sustain.
he told you, while he was telling the world that she was missing, he told you it was an accident that snowballed out of control.
That's correct.
And he was also having this, the text message that we referred that Mr. Ashton pointed out was, I guess, 5 days after his granddaughter was found. You were still having a relationship with him while this was going on, was it? Were you not? Okay. And for 2 years, you did not go to the media or tell anyone that you had a relationship with George Anthony.
Objection, leading.
Sustain, rephrase the question.
How long was it that you kept quiet about your relationship with Mr. Anthony?
Objection assumes the fact, not in evidence, that she kept quiet about anything.
Overruled.
Oh, she's like, oh, whoop. Disregard. How do I?
Exposed.
Yes, sir.
And it came out in the media.
Yes, sir.
And your actions afterwards was for what? Why did you go to the Inquirer?
Because I didn't want it to be edited. I was told that if I went and did an interview with the media, it would be edited. And he gave me the chance to tell my story in full.
And was the media telling your story in full at that time?
No, sir.
Were they saying all kinds of negative things about you?
Yes. That I have a criminal background. I do not.
Okay.
And I believe they know that.
I wanted to show maybe
Now,
something.
you have had issues where you had a failure to sign a citation.
Objection, relevance.
Ooh.
Sustain.
She don't like the
No further
poem.
questions.
Okay, let's do a drawing really quick.
Recroft.
Yes, sir. For context, may I approach the witness?
All right, have you liked the stream? Look at what I'm doing right now. Look at me. Look at my pointer, my mouse. I just liked Wilhelma Media and their stream. So let's go ahead and do this. I'm going to press play and I'll let you know when I...
To read to the jury.
Is she fake
The portion that I
crying?
had you read before and then the following
Dear, she
question
is.
and answer. So start right here and read to the end of line 9 of page 17. So the jury has the context. Read the whole thing, starting here all the way through.
Do I read everybody else's remarks?
Maybe
Just a
you
second.
should
What
like
is she
chat
reading?
GPT
This is
this.
her statement, referred by counsel.
Give me
Page
1
16, line
second.
25 through page 17, line 9.
And what is the date? What is the date of the statement?
I'm sorry, Your Honor.
What am I doing?
Yes, February 17th.
And Mr. Baez, your objection, sir.
It's a document that's not in evidence.
Overruled.
Okay,
Okay, so start with the part I had you read before and then read.
here are the 5 free memberships I'm giving away. May the luck forever be in your favor.
The next few questions and answers.
Do I read everybody else's remarks?
Yes.
Okay.
Read the whole thing. So the jury can hear you. Let me pull this over to the jury. Go ahead.
He said, I really believe that it was an accident and it just went wrong. And then she tried to cover it up. Casey, no verbal response.
Let's see.
Pardon?
That's not putting it in context.
Take a look.
It's not being read in the context, Your Honor. In fact, the first statement that was referred to is on the chart.
Let me see.
Okay, if you would start at the top of
Just a
this.
second. You may proceed.
Start at the top of this page, read every question and answer until you get to page 17, line 9. And just read it out loud.
Did he tell you what he thought happened to the child? Yeah. What'd he say? Upset. Crystal, it's okay. We have to know the truth about that. It's important. He said that, sorry, it's all right. Take your time. He said that it was an accident that went wrong and it snowballed. I'm sorry, and it just snowballed. And he said, you know, how you tell a small lie, and he just tried to cover it up, and it just got really real. It got really big, and it just went out of control. Did he explain to you? Did he give you more than that? No. What type of an accident? Because he was sitting on a couch in my house. And I was sitting on the floor, and I understood that because I've done and said so many things in my life that I was ashamed of, but I never thought I would escalate to something so big. When did that conversation occur? Remember? I don't remember exactly. I think it was the last time he was at my house. And that would be on the gate that would have the information at the gate. But he didn't give you specifics. He just said that. I really believe that it was an accident, and it just went wrong, and she tried to cover it up. Casey, no verbal response. Did he say to you that Casey had told him that this was an accident or this was something that you had just believed? He didn't say that. He said, like he knew it was inaudible. I don't remember him saying like Casey said it. He just said it was an accident that went wrong.
So they specifically asked you whether he said he was told about it or it was something that you believed.
And answered.
Overruled.
And you told them he didn't say that. He said like he knew. So George made it clear to you that he did not have any firsthand knowledge of what happened to his granddaughter. And that was the context of what he said, wasn't it?
Just that statement reads for itself, speaks for itself.
Overruled.
Thank you. No further questions.
Redirect.
Ms. Holloway, you made the statement in here that he didn't say Casey told him. He made it sound like he knew that it was an accident that snowballed out of control, correct?
Objection, pleading.
Rephrase your question.
Did he say Casey told him? Is that what you wrote? Is that what you said here?
Yes.
Okay. You didn't say Casey told him.
Right.
Okay. And what you conveyed to the police is that he knew that it was an accident that snowballed out of control.
Objection, leading.
Sustained. Rephrase your question.
Did you tell the police that he knew it was an accident that snowballed out of control?
Leading.
It's not a leading question.
She can answer the question.
I'm sorry.
Did you tell the police that he knew that it was an accident that snowballed out of control?
That's correct.
And after he left your house that day, he made further appearances asking for people to look for his live granddaughter.
Of cross.
Sustained.
No further questions.
Stay in the back. Ms. Holloway, I'm quite frankly confused. You
Sustained. Ask your question, Ms. Ashton.
Sure. In the statement, you said he didn't say that like he said, like he knew. That is what you said.
Yes, that's exactly what I said.
And that is what you intended to say.
Yes.
Thank you.
May the witness be excused.
Yes, sir.
You may.
Judge, could we approach appears to be a different statement?
You may.
This is what the
Why don't we do this? Members of the jury, I'm going to let you go for your recess, short or special. Okay. We will be in recess to 10:30. Thank you. Y'all can stay where we are.
You're not interrupting. Go ahead.
Ma'am, you can stand down to 10:30 and take a recess. Huh?
What happens now?
Okay, gentlemen. You don't get both. So if y'all want to clear this up, jurors coming back in at 10:30, so talk as long as you want to talk. But let's clear this up now. So then you can go take a recess whatever time you have left.
Yeah, I was going to go grab some out of the room there.
Okay, go ahead. Okay, have y'all straightened out your differences with the statements?
I haven't received a copy of it yet. It's my understanding it's from a different date, and I didn't have a chance to.
Judge, I'm not gonna ask the question. I have no further questions, so I think she'll be done.
Okay, Mr. Ashton, you had a requested instruction?
Yes, I provided it to the council table. Request that this instruction be read to the jury now that the witness testimony is over. It reads as follows. The alleged statements of George Anthony testified to by this witness may be considered by you only as they might impeach the credibility of the other testimony of Mr. Anthony and for no other purpose. These statements may not be used as any proof of the manner in which the victim in this case died. I believe that is in accord with the authority I've indicated in the attached to the instruction, that since this alleged statements were not under oath, then they can be used only for impeachment and for no other purpose.
Mr. Baez?
Mr. Baez?
You need to be at a microphone if you want it on
Yes,
the
sir.
record.
We would object. I think that we're pulling some cases actually right now to be able to argue this point, but as presented, I think that goes a little farther than what the proper instruction should be, if the court feels that one is necessary.
Well, are you familiar with the case of Pierce versus State, a 2004 decision of the Florida Supreme Court, found at 887 second page 561, which gives a pretty good dissertation on prior inconsistent statements, even quotes the Bible on Evidence, Professor Earhart's book. I think the statement that she gave was a statement to law enforcement. Is that not correct?
Yes, I don't have a copy. If I can see it.
You can look at mine, but I put one on the table there.
See what they just.
Let me go with that.
I know.
In the
Judge.
case that
I'm about as
I
annoyed
think
as you are.
the statement should end after no other purpose,
Okay.
because the rest is just argument at that point.
The reason I put that in, Judge, is because in the particular context of this case, that is the single and only piece of evidence that this jury has heard to suggest that this child died as a result of an accident. So it may be fine to tell them that, but in this particular case, it needs to be emphasized to them that it cannot be used for that purpose. A general instruction they might not understand. Sure, I could argue it at the time of the closing argument, but they need to know right now that that statement is, and it is a correct statement of the law. That statement is no proof of how this child died. So I would ask the court to give a more case-specific instruction of some sort.
That is, it's argument. It's additional surplus verbiage that is unnecessary, especially after saying for no other purpose. In addition to that, just because Mr. Ashton says that that's the only piece of evidence that's been admitted as to an accident doesn't make it so. I think that there has been numerous other points made on that topic, but that's irrelevant to the issue other than Mr. Ashton deciding to argue. And that's what this is, just more blah, 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 blah.
Oh, whew.
Have you read the case that Mr. Ashton cited, the Dudley case by the Supreme Court of Florida on this particular issue where, memory serves me correctly, with the Dudley case, the state got a conviction in a first-degree murder case, and the defendant was sentenced to die. And it was reversed because the state used the inconsistent statement as substantive evidence.
Well, I think if the court's going to grant this instruction, that would preclude that.
What would preclude what?
This being used as substantive evidence. It is here to.
Thank you.
You're not alleging that it is, are you?
I am what? I don't understand.
So you're not saying that the statement that Mr. Anthony, that she said Mr. Anthony said about this being an accident, you're not saying that's substantive evidence, are you?
No, Judge. What I'm saying is it is to impeach him. So there it is. The very first sentence is what it covers. The alleged statements of George Anthony testified to by this witness may be considered by you only as they might impeach the credibility and other testimony of Mr. Anthony and for no other purpose. What do we got to say? 3 times? Said twice there.
The difficulty in the context of this case is that the significance of this statement isn't really to impeach George Anthony. And we all know that this statement was put before the jury not to impeach George Anthony. George Anthony has been impeached a lot and more than adequately on many different topics. This statement is put before the jury in hopes that they will take it for more than it's supposed to be. And that is why, with all respect, Your Honor, I would submit that there needs to be a more directed, case-specific instruction by the court to make sure that there's no possibility that this jury will use this piece of information in an improper way.
The court, when you say for no other purpose, is being very clear. And some of these instructions are phrased in a way that might let the jury believe that somehow this court, when reading instructions, feels one way or another. And I think that every instruction needs to be fashioned in a way that is presented to outline the law as this jury is to follow it. But to go on and allow the prosecution to make argument and add that on, which is all this is its argument. And at what point do you stop? You're saying it twice. This is a third time. Why not a fourth or a fifth? It's surplusage. It's certainly too much. And for no other purpose ends it right there, Judge. It's to impeach this person. The line of cases under Pierce all are that the court should give an instruction sufficient to be able to explain to the jury what is the purpose of this witness's testimony.
Okay.
That's what it is.
All right.
And
That's
the story.
all.
You don't get
We're
the
good.
prosecutor doesn't get to throw in a
Let's
jab
go.
there while they're at it.
Let's start
And that's our purpose. That's our point.
It is quite evident that an instruction needs to. Mr. Bias?
A clarification on the court's last ruling. Is the court precluding me from mentioning the items that were the issues? Well, let me rephrase that. The evidence that was admitted in trial.
I'm not telling you can't argue. You can't argue to utilize it to say that Mr. Anthony or Mr. Lee Anthony sexually abused Miss Anthony.
Just want to clarify that because there are other arguments that could be made that don't relate to abuse, and I want to make sure I could still do that, such as family dysfunction and things like that. I just want to make sure.
As long as you don't jump out and use that to support the argument that she was sexually abused by her father and her brother.
Okay. I just wanted to make sure.
Yes, sir. All right, both sides ready to proceed. Let's return to jury. State recognized presence of jury.
Yes, sir.
Defense.
Yes, sir, we do.
Good morning, ladies and gentlemen of the jury. Did you heed all of my previous admonitions?
What are you
Ladies and
referring
gentlemen of the jury, Dr. William Rodriguez was called as a witness by the defense. Through no fault of the defense or the state of Florida, Dr. Rodriguez was not able to complete his testimony. Therefore, you are to disregard his testimony and not consider it in your deliberations. Ladies and gentlemen of the jury, both the state and the defense have now rested their case. Their attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. The state may proceed.
Thank you, sir. Good morning. I want to be the first, and I know I will not be the last, to thank you for the time that you've given us in this case. We've taken you away from your families, from your lives for the last 6 weeks, and all of us appreciate the sacrifice that you've made.
Yeah.
I am happy to say that we came in on the low end of our estimate. We said 6 to 8, and it's been 6. And our job here is virtually done, and your work is about to start.
I believe they got opening or closing statements on a Saturday.
It's easy to be a parent sometimes. It's easy to be a parent when you're playing with your children. It's easy to be a parent when children are a joy and when children are fun. But we all know that being a parent is so much more than just playing with your children. Being a parent is about sacrifice. Being a parent is about sacrificing your time, about sacrificing your love, and about sacrificing your dreams and sacrificing your life when you have a child, that child becomes your life. This case is about the clash between that responsibility and the expectations that go with it and the life that Casey Anthony wanted to have. When Kaylee was born, Casey was saddled with expectations and responsibilities. Those expectations came not only from society, but from her parents. The expectation is that she would care for her daughter with the support of her parents, that she would work hard and help support her daughter. Her response to those new responsibilities, as the evidence has shown in this case, was the lie. The first expectation of her parents shortly after Kaylee's birth was that she would work, that she would help support her daughter along with the generous contributions of her parents. For whatever reason, her solution was to lie. She told her parents initially that she went back to the same job that she'd had before Kaylee was born, working at Universal Studios for a subsidiary company, taking photographs, a daytime job. And her parents accepted that. They believed that. They both worked during the day, and it appeared that that's what she was doing. The significance of what I'm about to tell you isn't simply that Casey Anthony lies. It's the pattern and the reason that she lies that is important in this case. Because what you'll see in what I'm going to tell you and what you've heard in this case is that when Casey is faced with a problem, her solution is to change her lie, to modify it. Casey is very bright. You can't take any of that away from her. She's very smart, and her lies are very detailed. But what you find throughout this case is this persistent pattern. When Casey wants to do what Casey wants to do, Casey finds a way. So at first she tells her parents, I'm working. I'm working during the day at Universal Studios. That sounds fine. It sounds very plausible. But the problem is that when you're working and you have a child, someone has to take care of the child.
Dude, are you sick?
So the obvious question is, who's taking care of Kaylee? Yeah. The solution? To make up a lie. So Casey makes up Zanny. So for almost 2 years, Casey Anthony pretends to have a job and pretends to have a nanny to take care of Kaylee while she's at work. And everything seems fine. But that creates a problem. The problem is that Casey's with Kaylee 24/7. She's with Kaylee every day and every night. Because when her parents think she's at work, she's not. She's with Kaylee. And what kind of life is that? So Casey solves the problem.
Oh my God.
The solution is a new job. A job as an event coordinator, a job with flexible hours, a job where sometimes she has to work at night. Perfect solution. If she wants to go out at night, if she wants to hang out with her friends, if she wants to see her boyfriend, she simply says, I have to work, and drops Kaylee off with her mother. And her mother is happy to help, happy to watch Kaylee. And that works for a while. Works well for a while. Everything is good. Casey can do what she wants, have the life that she wants, have the support of her parents, have Kaylee when it's fun, and when it's not, she can leave Kaylee with her mom. Everything works great. But then she meets Ricardo Morales, somebody that she feels she may actually have a relationship with, who accepts Kaylee as part of that relationship. But that creates a problem. How do you include Kaylee in the relationship without letting mom know that the whole thing is a lie? So you create a new solution. Oh, Zanny will take her overnight. We spend the night there. So in the spring of 2008, 3 or 4 nights a week, Casey and Kaylee stay at Zanny's. Another creation in this case. When in fact, they're staying at Ricardo's house. And it works perfectly. It's great. Mom and dad think that I'm working late, and so Kaylee is with Zanny. It makes perfect sense for me to spend the night, and I can spend the night instead with my boyfriend. It works perfectly. It's great. But Ricardo decides that he really doesn't want a serious relationship. So this playing house isn't working anymore. Then we get into April and May of 2008, and this is where the problem starts, because The solutions of the lies are no longer giving Casey what she wants. It's not giving her the freedom that she wants. Remember from the testimony of Amy Huizenga, her friend, the friend of Ricardo and friend of hers, that friend through that period of April, May, and June of 2008, that Cindy is resisting. The excuse isn't working anymore. Cindy isn't allowing Casey to go out and do what she wants and babysit Kaylee. There's a tension there. The freedom that Casey wants just isn't there anymore, and she can't come up with a story to make it happen. But that's what she wants. Her parents are getting suspicious. Remember the story from Mr. Anthony about the sports authority job? That's in early 2008. George is getting suspicious. And George is trying to find out what's really going on. But George is being told to stay out of it. If you'll read George's suicide letter, it actually says in there, at one point, I think on the 3rd page, he says, I've tried for months, in fact, over a year, and I was told to stop being negative. George is trying to get beneath the layer of lies, at least as to the sports authority issue, but he's being told to stay out of it. Stop being negative. And Casey's lies continue. But there's a problem. The only way Casey's lies work is if Kaylee isn't talking. Kaylee's 2.5, almost 3. She's starting to become verbal. She's starting to talk. Kaylee is not going to cooperate. She can't. She doesn't know enough to lie. At some point, Kaylee is going to say something. Someone's going to ask her about Zanny, and she's going to say, who? Someone to ask her, did you have a good time at Zanny's? And she's going to say, no, Tony. It just can't keep going. Casey meets Tony. Tony has this life. He's free. He's a club promoter. He's out there at night with the loud music and dancing, and it's a great free life. With Tony, she can do whatever she wants. I believe the testimony was on June the 6th and on June the 13th, they have the nightclub fusion, and it's fantastic. Shot girls, music, dancing, young people doing what young people are supposed to do. And I want to say that clearly.
Yeah.
There's nothing wrong with young people being young people. There's nothing with young people drinking and dancing and having fun.
100%.
There's nothing wrong with that. But that's not the life that Casey has, because Casey is a mom.
Yep.
And that gives her responsibility, whether she likes it or not. But that life is so much what she wants. During the week of June 2nd through June 9th, in fact, Casey has a chance to truly embrace that life because Cindy was on vacation that whole week and spent most of it with Kaylee. Remember, she talked about how wonderful it was spending that week with her granddaughter. So that whole week, Casey is essentially free. She has a taste of that freedom. She doesn't have to lie to get around it. She's free. And it is fantastic. So she has a choice. A life tethered to a child, or a life free to be 22. You might ask yourself, well, why not just leave Kaylee with Cindy? Why not just give Cindy custody and walk away? Because based on the evidence you've heard in this case, Cindy would never permit Casey to walk away from Kaylee. Cindy wanted her daughter to be a mom and to act like a mom. And there is no way that Cindy Anthony would have ever permitted Casey to walk away. So those were Casey's choices. The life that she wanted or the life that she had. And as hard as it is for anyone to imagine, she had to choose between sacrificing two things. The first was her dreams and the life she wanted. And the second was her child. And we submit to you the evidence in this case shows that the choice she made was her child. On June the 16th of 2008, Casey left the house, pretended to leave the house with Kaylee and used the tried and true Ricardo excuse. I got to work late. We're both going to spend the night at Zanny's. An excuse she hadn't used based on the evidence since she was with Ricardo. Sounded plausible. It's something they've done before. Didn't seem strange. She used that excuse both to her father when she left and also to her mother, I believe in a phone call later that day, or perhaps even the night before. What this tells us about her plan is this. She wasn't going to stay at Tony's with Kaylee because that was not their relationship. So on that morning, Casey knew that she would not be staying at that house, and that neither would Kaylee, because she knew that that night she would be in the arms of her boyfriend and that Kaylee would be dead.
Thank you, Willa. You.
So for June 16th,
Fruit.
it was the same old excuse, the tried and true. I'm staying at Zanny's. I got to work late. Made perfect sense.
You can send Jules, by
She
the
actually
way,
spent the night at Tony's.
if you're watching on your phone.
June 17th, well, they'd done it a couple of days before, so she knew her mom would accept one more day of this spending the night at Zanny's problem. So she said, 17th, we're spending the night at Zanny's again. And Cindy accepted that. But by June 18th, Casey knew that Cindy would no longer accept that excuse. It didn't make sense that they would be staying at Zanny's 3 nights in a row. They never had done it before. It wouldn't make any sense. So Casey had to change the lie, had to add an element to explain the continued absence. So on June 18th, Casey adds the conference in Tampa wrinkle. Says, I've got this conference at this hotel in Tampa, so I'm going to take Kaylee with me, along with Zanny, the babysitter, to this conference in Tampa. But it's not just that. She adds another element, an element that would appeal to Cindy, which is, oh, by the way, there's going to be another mother there with a child the same age. What a great time Kaylee will have. You see, every time you add to the lie for a reason. Casey's very smart. Casey knows how her mother thinks. She knows she needs to add. So she adds the element of an out-of-town trip to a fun place and another child to play with. A great story. Mom will absolutely buy it. It'll keep mom off my back for at least a couple more days. While in fact, Casey is staying with her boyfriend, Tony. And sadly, Kaylee is in all likelihood in the trunk, dead and decomposing. Put out of Casey's mind as easily as she puts out the truth. Remember, on the 17th, the 18th is the day. On 17th, Casey's car is seen back in to the driveway of the Anthony home when no one is home. I believe it's that day or the next day, the evidence showed, Casey goes to the next door neighbor and borrows a shovel. And I would submit to you that the reason to borrow a shovel under those circumstances is because she thought briefly about burying Kaylee in the backyard, just like they buried their pets. Apparently that was too much work for her, so she decided instead to just throw in a swamp. Anyway, so the story on the 18th is pretty good. It buys her a couple more days. So through the 18th and the 19th, she continues to tell her mother, we're having a wonderful time. We're at this conference over in Tampa. She, on the 20th, actually extends it to add Busch Gardens. It's going to be great. We're going to have fun. Kaylee's going to go to Busch Gardens with these other children. They're going to have a wonderful time. And Zanny's going to watch them while I'm at my conference. So it satisfies everything. Cindy's sad that her grandchild is not with her, but she's happy that Kaylee's having such a wonderful time at the theme parks. Tells Cindy that they'll be back on Saturday, the 21st. 21st, she tells Cindy again that the conference is still going on, that they're still at Busch Gardens in Tampa with Zanny, Juliette Lewis, and Annabelle, the fictional people. Now, counsel in questioning has suggested that these
Casey would have been
People
an
are
excellent
somehow imaginary
book
in the
writer.
sense of being not a deliberate fabrication.
All the
I would submit to you that
characters.
the fact that they are deliberate fabrication is established by the fact that while Casey is telling Cindy that she and Kaylee and everybody else are at Busch Gardens, she tells another witness, Maria Kish, who you heard from, that Kaylee is with the nanny at the beach. Because obviously the friend doesn't need to have the story, and she can't very well tell the friend, by the way, I'm in Tampa, because she's standing in front of her. Again, Casey's lies fit the audience and the necessities of that audience. By Sunday the 22nd, clearly they should be back from this conference by now. But on the 22nd, Cindy is told, oh, well, the conference ran late the day before. They were going to plan on coming back, but they figured they would just stay and go to the park at Busch Gardens on Sunday and have fun. And Cindy is placated by that. But they're supposed to be back on the 23rd. Casey, of course, is still at Tony's. And by this point, ladies and gentlemen, based upon the evidence you've heard, Kaylee was already in her resting place off Suburban Drive in the process of decomposition. On the 23rd, when they're supposed to be home, Casey needs to come up with some other reason for them not to be there. At this point, Casey comes up with the story of the accident. Zanny, this imaginary person, has been involved in an imaginary automobile accident in an imaginary place and is now in an imaginary hospital. And of course, they couldn't possibly leave without her. And since Juliette Lewis is there and Annabelle is there and Kaylee is having such a wonderful time, we're going to stay a few more days. So that excuse extends the stay a little bit longer. Casey continues to update her mother about the progress of Zanny's imaginary injury and extends the stay even longer. On the 24th, however, she has a problem. 24th is when she comes home and runs into her father. This is the gas can incident. So on the 24th, she's got to come up with something for why Kaylee isn't with her. So she tells her mother that she came home to Orlando to get insurance papers for Zanny for the accident. Casey is smart. Casey is quick. It is absolutely amazing how nimble Casey Anthony's mind is in the ability to come up with an appropriate and believable lie in an instant. She's impressive. But again, it allows her to extend this absence. Well, she is, in fact, again, hanging out with Tony. June 25th, still in the hospital, staying there to be supportive of Zanny. June 26th, Zanny is finally released late. Amazing how that's a theme. Everything seems to be late. Zanny's released late. So they decided to stay at the hotel, not try to come back that night. They're going to spend one more night at the hotel. So finally, Cindy thinks Kaylee's going to be home. Finally, it's been more than a week, longer, 10 days, longer than she's ever been away from her precious granddaughter. But finally, they're going to be home. The next day. The next day comes, Friday, June 27th. Well, we're back in town, but we met up with Jeff Hopkins. Jeff Hopkins is the imaginary connection to Zanny that she came up with years before. She's actually got an amazing memory. I mean, imagine being able to remember the lies you told a year ago and incorporate that into a new lie. It's really quite impressive. So now Jeff Hopkins in his town, and they're staying at the Hard Rock Hotel with him, a fun place.
Ooh.
Again, mom will be placated by that. But of course, she tells Amy that Kaylee is at the beach with a nanny. So again, we're getting contradictory lies depending on the audience. June 28th, having a great time, still at the hotel, Jeff Hopkins, Zanny, the other children, everybody's really just having a wonderful time, Mom, so we can't come home. June 29th, gee, Mom, we're just having so much fun, we can't come home at the Hard Rock Hotel with Jeff Hopkins. So Jeff Hopkins becomes an interesting part of Casey's long-term strategy in this case. June 30th, she tells Cindy that Jennifer and Kaylee are going to Universal Studios. They're going to have a wonderful time at Universal Studios. On July 1st, she makes a mistake. July 1st, Cindy is actually on vacation.
Yeah.
She makes the mistake of telling Cindy that Casey and someone named Jennifer Rosa are at Universal.
Maybe.
Cindy actually goes to Universal, calls Casey on the phone because she wants to see her granddaughter. I'm sorry, that's July 3rd. July 3rd, we're at a character breakfast. Great thing for Kaylee. She's having a wonderful time. Cindy actually tries to go and see her. She arrives at Universal Studios, calls Casey and says, I'm here. I'm ready to see my granddaughter. Oh, no, we're in Jacksonville.
Hey, girl.
We're with Jeff Hopkins in Jacksonville. Now, remember, Jeff Hopkins, the backstory of Jeff Hopkins is that he's a wealthy friend of hers that she has some romantic interest in, who conveniently lives out of town. Oh, we were going to be at the character breakfast, but now we are in Jacksonville with Jeff Hopkins. This is the beginning, I would submit to you, of Casey's long-term strategy for how to deal with Cindy, because she has to have one. Remember Timer 55? Timer 55 is the password that Casey created for her MySpace and Facebook accounts. And there were two references by Casey to Timer 55. The first was in one of the tape-recorded conversations with Lee Anthony you saw in jail, where she says that Timer 55 is related to Kaylee. And then later, Lee testified that his recollection had to be refreshed, as he frequently did, but admitted that Casey had told him that Timer 55 reflected the 55 days between June 16th and Kaylee's birthday. Now, she told him the story that was some reflection of when she thought that Zanny would bring Kaylee back. But we know now that's not true. We know now Zanny is a fiction. So what did it mean? What did Timer 55 actually mean? Timer 55 meant that she knew that she could only stall her mother till Kaylee's birthday. Timer, 55 days. The most she could do was 55 days. And then her mother would insist on seeing Kaylee. What I submit to you, the Jeff Hopkins Jacksonville story is a long-term strategy. Remember, on July 3rd and 4th is when there was the big blow up. Cindy created a MySpace page, and she and Casey finally had a heart-to-heart. And what does Casey tell her? Casey tells her, I'm in Jacksonville with Jeff Hopkins, this man with whom I think I could have an actual relationship, a wealthy boyfriend who has a child the same age as Kaylee, with whom I think I can have a long-term relationship. Mom, you've got to get used to the fact that I won't always be with you. Now, this is all made up. So she's now got herself, mother convinced, that she's in a potentially long-term relationship with a wealthy man who lives out of town.
Are they from Minnesota?
Timer 55. She's coming up with a long-term strategy because maybe she'll marry Jeff Hopkins. Maybe they'll elope to Europe. She could extend that 55 days for months. She never had the chance. July 5th, she tells Cindy that her car is being fixed in Jacksonville, that she'll return on the 12th, that she's staying with Jeff Hopkins and his mother. July 13th, she tells Cindy that Jeff Hopkins' mother's getting married, a miraculous and fictional marriage, and they're going to stay to finish that. Well, in fact, she's just hanging out with her friends. Now, the July 3rd conversation did back Cindy off. Cindy was largely leaving her alone after that until July 15th.
She and I were on a show
On July
Vice
15th,
TV.
all hell breaks loose because they got the car. I would submit to you, had they not gotten this car, I would submit to you, based on the evidence, that Casey would have continued this story at least to Kaylee's birthday and probably beyond, for as long as she could. But the car made that impossible. July 15th, the car is discovered. Cindy is on a mission.
Sorry.
Cindy is on a mission. Cindy is going to find and see her granddaughter, and she will not be denied. And that's it. Tracks down Amy Huizenga, tracks down Casey, grabs Casey, says, you will take me to my granddaughter now. She tries to rely on the old saw. She's at Zanny's. I don't want to wake her up. She's at Zanny. She's at Zanny. She's at Zanny's. Despite everything that Cindy says, despite the threat of Cindy Anthony to call the police, sticks to the story. Same old saw. Zanny, 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 Zanny. Until finally, her brother, Lee Anthony, says to her, okay, let's play this out. I'm the police officer and you're you. Ms. Anthony, take me to your granddaughter. No, she's sleeping. Take me to your granddaughter, your daughter. And convinces her of the reality
All right, Mo.
that
good
this story
luck.
simply will not
soon.
stand, cannot survive. Your lie will not succeed. And in a pattern which you will see repeated in the face of a lie that simply cannot stand, she comes up with a new lie.
Before FaceTime.
Yes, there's a Zanny,
100%
but
before
Zanny
FaceTime.
kidnapped Kaylee. Kidnapped Kaylee 31 days ago. It's interesting that though Casey got the date wrong, in other words, remember she told the police it was June 9th, it was actually the 16th. She got the
Let me make a correction. Or you guys tell me if this doesn't sound right, because I want to make sure that what I'm typing sounds correct. So the person that I know, her brother was unalived by Dahmer. That's what I meant to type. Let me know if that doesn't sound like what you guys are reading, because I'm reading some comments and I just want to make sure that we're all on the same page. I don't want to give the impression that of anything else. Okay, thanks.
number of days right. 31 days. 31 of the 55 were gone. I haven't seen my daughter in 31 days. I've been looking for her. I've been doing my own investigation, and tells this elaborate story of how she knows Zanny because she works at Universal, and Jeff Hopkins and his son Zach and Zanny and all the other children. And
I have to tell you, her brother's head was in his freezer.
tells the police this elaborate, consistent lie. And initially, the police treat her as if, in fact, she's a victim of a child kidnapping. But the more they investigate her story, the more it seems to fall apart. In what can only be described as, if it weren't true, you couldn't write it this good, is the incident at Universal Studios. But it's indicative of Casey Anthony and who she is and what she does. She maintains this story about the kidnapping, about working at Universal. She takes them to Universal. She walks with great confidence from the security gate to a building, enters the building with absolute confidence, walks to the end of a hallway, turns around, puts her hands in her pockets and says, okay, I don't work here. Casey Anthony maintains her lies until they absolutely cannot be maintained anymore. When she gets to the end of that hallway, or when she gets to the end of that conversation with her brother and realizes this lie has failed me, so I must abandon it and replace it with a new one. So
I don't know, Revis.
in that amazing conversation with Yuri Melich and with
Vice.
John Allen, she admits to lying about working at Universal for reasons which are not clear. But maintains the
Wait, I
Zanny
don't have
story.
Instagram on this laptop.
I'm lying to you about working here, but everything else I told you is true. And she maintains that lie through conversation with law enforcement. She maintains that lie through conversations with her parents and her family, which you saw through all of July and into August. But during that period of time, a problem comes up, and that is that her claim of where she dropped Kaylee off has been conclusively disproven. There's just no way that's true. Her claim that she was looking for Kaylee has also been conclusively disproven. There's no way it's true.
This is who.
Realizing that, when she is briefly released from jail on bond and stays with her family, she comes up with the new story. The kidnapping story, the forceful kidnapping story, the Blanchard Park story. Remember the testimony where she told her brother Lee when she was out in that later part of August that, in fact, yes, Zanny
Rita
did kidnap
Isbell.
Kaylee, but it was by force.
Errol Lindsay. I was right.
We met at Blanchard Park on the 16th, that they held my arms, they held me down, they took Kaylee away from me because I was a bad mother. Again, faced with overwhelming evidence that the story is a lie. Casey comes up with a new one. Call it Casey 3.0, a new version.
She's a funny broad too.
The problem with that version comes up on December the 11th of 2008. Can I have State's Exhibit 208, please? Kaylee's remains are found. Kaylee's remains are found within a quarter mile of the Anthony home. With her remains are found a number of items, a number of very important items. Could I have 222, please? Could I have State's Exhibits 302 and 284? 302, if you find 284 for me. The first, that should be the gas can and the first problem is tape. The tape that is found on Kaylee Anthony's remains, which is contained in this bag, and you can look at 3 pieces of duct tape. Photograph we see here with a distinctive brand on it. Henkel brand duct tape. Found on Kaylee's body.
You should really.
The difficulty for Kaylee 3.0 is that the same tape that was found on Kaylee's body is also found on a gas can taken from her home. And you'll see from the sales exhibit you have that was put in by the defense that this tape is a fairly rare kind of tape. Hasn't been sold since 2007. And even then, it was only a couple, like 100,000 rolls of it sold. It's very unusual tape. And it's on Kaylee's body, and it's on that exhibit. And in fact, in what has got to be the most bizarre part of this case, that very tape was used unknowingly by her own father to display a photograph of Kaylee, that missing person poster. The tape that was used to kill Kaylee Anthony was used to implore people to look for her. Could I have photograph in evidence 224?
Oh, Cindy's not
This is the
sitting by
bag
him.
that Kaylee was found in. This is what, I guess you could say this was her coffin. This bag, could I have photograph 227? This is the tag from that very same bag. 293. This should be the laundry bag. This is the laundry bag taken from the Anthony house during a search warrant on, I believe, December the 11th of 2008. This is the mate of the bag that served as Kaylee's coffin. Remember, we saw a photograph of an ad. They're sold in sets. There's a square one. There's a cylindrical one. This is the square one. The cylindrical one is in this bag. State's Exhibit 264. I'd rather not take it out because it's not in very good condition. Because that bag is Kaylee's coffin. Could I have State's Exhibit 233? This is the photograph of the shorts that were found with the remains of Kaylee Anthony. You'll recall it from the medical examiner's testimony. It's very, very tattered from decomposition. State's Exhibit 314. This is a photograph of Kaylee Anthony wearing those very same shorts. Could I have State's Exhibit 237? This is a photograph of the lettering that was found in the bag with the remains of Kaylee Anthony. The last remnant of a shirt. Remember, the testimony was all that was left of the shirt was the stitching around the collar and these letters. Could I have State's Exhibit 13, please?
I think it's great that
And there's a photograph.
Cindy's not.
Kaylee Marie Anthony wearing the shirt in which she died. With not a stranger, Casey Anthony. Could I have 255, please, photo and evidence? And I'll need Exhibit 288. This is a photograph of the blanket that was with the remains of Kaylee that was found on December the 11th of 2008. You'll notice in the middle of the photograph, you see a particular character, Winnie the Pooh with Piglet on his shoulders. Exhibit 288 is the bedding that was on Kaylee's bed, maintained by the grandparents for all those months it was supposed to live in it. You'll see the Winnie the Pooh theme, but also you'll see the exact same figure on the bumper from Kaylee Anthony's bed. This blanket was not taken from the home of some stranger, but was taken from the home George and Cindy Anthony, where Cindy and Kaylee lived. The claim that some stranger abducted Kaylee Anthony was no longer tenable. Just as the claim that Kaylee was at Zanny sleeping, just like the claim that she worked at Universal Studios, just like the claim that she left Kaylee at Zanny's house. One by one, those claims died. And by the time Kaylee's body was found, any suggestion that Kaylee was kidnapped and murdered by a stranger was gone. There's no question left that Kaylee Anthony died at the hands of someone in that house. When we started this trial, the defense in opening statement made some statements. I want to first, of course, remind you that what the attorneys say, what I say, what defense counsel says is not evidence in this case. The evidence that you must decide this case on is what comes from the witness stand or from these exhibits and evidence. In opening statement, defense counsel gave you a very, very detailed explanation, story of how Kaylee Anthony died. With dramatic flair, he told you about Casey Anthony being awakened in the morning by her father, screaming at her, "Where's Kaylee? Where's Kaylee?" About a frantic search for the child, about the grandfather bringing her up, wet from having pulled her from the pool, and laying her at Casey's feet and screaming, "This is your fault. This is your fault." The judge will instruct you on the definition of reasonable doubt. He will tell you that a reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. The defense's opening statement has not been established by any evidence in this case.
Burden shifting. Move to strike.
Overruled.
In fact, the only evidence presented in this case is that it did not happen. George Anthony, the first witness you heard in this case, told you that it did not happen. You may not speculate, you may not imagine, and there is simply no evidence in this case to support that contention. And you must reject it. The defense's opening was not simply to create one villain. The defense was not satisfied with one. They suggested a second. They suggested someone that counsel referred to as morally bankrupt, Roy Kronk. The defense in opening suggested to you somehow, and perhaps counsel will clarify this in his closing argument, that somehow George Anthony disposed of Kaylee's body and that George Anthony was somehow, well, actually we'll concede George Anthony is connected to the tape, tapes from the house, that George Anthony's connection to the tape somehow connects him to placing the tape on Kaylee's body. Remember, the defense counsel said, follow the tape. But then in the same opening statement, he suggested to you that Roy Kronk somehow took the body, kept it in another location, and then returned it. And in fact, one of their witnesses, Dr. Spitz, suggested what I would submit to you is, based upon the evidence, the nonsensical proposition that someone came along, took the skull, took it home, and put tape on it. Well, ladies and gentlemen, you can't have it both ways. Either George Anthony is the person that put the tape on, which we know is not true, or Roy Kronk is the one who put the tape on. You can't do both. It's one or the other. Either somebody put the tape on that child before the child decomposed, or they didn't.
Trouble with maybe it's for a reason.
The arguments made by the defense in this case, I would submit, require you to suspend your common sense, to leave in Pinellas County everything you know about how people think and act and why they do what they do. It is a trip down the rabbit hole into a bizarre world where men who love their granddaughters find them drowned and do nothing. Where men who love their granddaughters take an accident, a completely innocent act, and make it look like a murder for no reason. A world where a man who buries his pets will take the granddaughter who was the love of his life and throw her in a swamp. This is the world that the defense invites you to occupy. And a world where a guy who runs across a skull and reports it 3 times to the police and is blown off by them, takes the skull and the mandible, which is worth a lot of reward money, takes it home for 4 months, puts tape on it somehow, and then brings it back and sets it back where it was and calls the police. In any world, even the most morally bankrupt, greedy, reprehensible reprobate, if they're motivated by money and they want to report finding a child skull that everybody in the country is looking for, and if all they're motivated by is money and the police are not listening, you walk down the street, you turn the corner, you find any one of dozens of reporters and say, come with me, I got a story for you. And every single one of those reporters would be in that scene right then and there, if that's what Roy Kronk had wanted.
At me?
Roy Kronk, that's all we saw. It's on tape. Nobody wanted to listen to him, so he gave up. 4 months later, he came back, it was still there, he reported it, it's there. You can look at the photographs of that body, and without any assistance from expert testimony, can tell that that body has been there for a very, very long time. Didn't just get set there. And that tape didn't just get put on that skull. And you know how you know that?
Maybe.
Because the tape is decomposed just like everything else is. You've seen photographs of the tape. You've got it in evidence. That tape has been out there for a very long time. You heard testimony from the Ms. Lowe, the fiber analyst, who told you that that tape didn't even have any cotton in it. And we know it's the same tape. It's a tape in the garbage. But that tape had been out there for so long, it didn't even have cotton in it anymore. So she couldn't even tell scientifically they were the same. Everyone concedes they are the same, but that's how long it had been there. The tape did not just get out there a few days before.
I don't know what you're talking about.
All the evidence says
it's been great.
that that's impossible. Look at the facts of this case, and you will see that there is absolutely no possibility, reasonable or otherwise, that George Anthony had anything to do with disposing of his body. He is a doting grandfather who loved that child literally more than life itself. You watched him on those hours and hours of videotapes and conversations with Casey Anthony. You saw the pain. You saw the anguish. You saw the questions that he wanted answers to because he didn't know. And you have his suicide note. January 22nd, 2009. George Anthony was ready to end his life, to be with Kaylee. And that note, when you read that note, it's going to go back with you. You can read it as many times as you want. There is absolutely no way that the man that wrote that note knew anything about what really happened to his granddaughter, and that's what was killing him. He didn't know. He had nothing to do with this crime. But the evidence that Casey did is overwhelming. Casey's car, when it was retrieved from the tow yard on July 15th of 2008, reeked of death. The first witness you heard talk about it, Simon Birch, gentleman with the English accent, manager of a tow yard, not a police officer, but a guy who for 30 years has been involved in towing cars. He also spent a year in waste management, which is 2 years in waste management, which is also, I think, important. He told you, he said, I have smelled everything that a human being can leave in a car when it gets towed. People leave their groceries in the car, park in towaway zone, their car gets towed. The groceries rot in the back. Dead bodies, 5 or 6 of them. I've had cars that had dead bodies in them. I've smelled it all. And yes, I would submit to you, he smelled rotten milk too. And he told you that when he approached that car the first time and leaned down to get the VIN number, he smelled something. And he knew what it was. And he told you that when he went back there with George Anthony and he smelled that car when the trunk was open, he said to himself, whoa, I know what that is. And Mr. Birch has no reason to lie about any of that. We could have stopped there. He was very, very persuasive, I submit to you. But we didn't. We went further. You heard from professional witnesses, crime scene technicians who smelled it, unfortunately, on many occasions. Unforgettable, unforgettable. It's exactly what I smelled. The defendant's own father, even at the time, said, I smelled that before, and I know what it smells like. But we didn't stop there. We got help from the one person who has studied the odor of human decomposition more extensively than anyone else, Dr. Arpad Vas. 20 years he's spent studying the biochemistry of human decomposition. The last 10 specifically studying the odor of human decomposition. And he told you that when he opened that can, he jumped back and said, I know exactly what it is. But we're not just relying on his nose, we're relying on science too. He examined the evidence. Examine the odor. Now, what's important about what he did with the odor is that he actually took a piece of the carpet, separated from the trunk, so that the odor that he was getting had to come from the carpet itself. In other words, not some ambient odor from something that had been in the car before, but from the carpet itself. And in fact, the defense's own expert, Dr. Furton, agreed that that process would render an odor from the carpet itself. Submitted it to instrumental examination. Now, both Dr. Voss and Dr. Furton agree that at this stage in the science, there is no signature set of chemicals that is indicative of only human decomposition. They both agree on that. All they can say, either one, is that it's consistent. And Dr. Voss, who has researched this more than anyone else, says to you, it's consistent. Could it be from other sources, other things that were not found in the trunk? Of course. But those things wouldn't smell like human decomposition. And you could put together a coincidental group of chemicals to account for everything. You could throw in some gasoline, maybe throw in some chloroform bleach, throw in some carbon. You could throw the chemicals together, but it wouldn't smell like human decomposition because the smell is unique. He tested the odor. He tested the carpet through 2 different instrumental examinations, one for inorganic, one for organic, and he tested the paper towels. And everything he tested came back to one specific cause, that there was a dead body in the back of Casey Anthony's car. Now, the defense presented you Dr. Furton, who is also experienced in this area, though I would submit to you not as experienced as Dr. Voss, because Dr. Furton's main area of interest is in individual human scent. In other words, the sense that you and I give off in life as individuals. Some of his students as a corollary do study human decomposition, but the thing was interesting is he agreed that the odor coming from the car is, in his opinion, from decomposition. He tried to propose some alternative sources of the decomposition, such as milk or cheese, but ultimately he had to admit that the items that were in the car, that is the garbage, wasn't sufficient. You know, I mean, I guess it was Dr. Huntington, the bug guy, who tried to talk about, you know, that there was maybe some salami in the salami package. And remember, I showed it to him and it wasn't salami, it was a piece of paper. And then Dr. Furton tried to talk about the cheese and the Velveeta packages. And I showed him the Velveeta packages and there was a tiny little bit of residue in it. And ultimately, even he agreed that what was in that garbage was not sufficient. We have exploded the myth of the garbage as the source of this odor. Even Dr. Furton admitted that no, this garbage just wasn't sufficient to give the odor that was found on these items. And in fact, the odor that was still present by the testimony of their own expert, Dr. Huntington, that he still smelled 2 years later. You all in your common life and experience have smelled common household garbage.
No, we're
Y'all
not.
have walked past, I'm sure y'all have walked past dumpsters. You've got your husbands or wives, somebody take out the garbage, it took a little too long. What garbage smells like is not beyond your experience. And ladies and gentlemen, when you remove a bag of garbage from a trunk, the smell goes with it. It doesn't stay in the trunk.
Thank you, Stacy.
It was there because Kaylee's body had been there. But that's not the only evidence you have. You have the hair. A single hair was found in the trunk of Casey Anthony's car with an artifact that you heard, I'm sure, more than you ever wanted to about. But an artifact which is only found in hairs attached to decomposing human bodies. And that particular expert testimony has not been rebutted by any other testimony you've heard in this case. You heard a lengthy testimony from Stephen Shaw.
Shifting.
Overruled.
You heard lengthy testimony from Stephen Shaw about a test that he did, where he literally told you, I was trying to create this artifact in a hair taken from a living person. I tried to find every method I could think of, every decomposition situation I could think of, to try and recreate this particular artifact. And he couldn't do it. No matter how hard he tried, he could not replicate it. Now, defense counsel debated with him some photographs where there was some darkening and debated whether that was banding or wasn't banding. The important thing about all of that is that when you look at the hairs that actually came from a car, from the trunk of a car or from the inside of a car, the same circumstance as this particular hair, they didn't have any markings on them at all. Nothing. No decomposition of any kind. So regardless of whether you debate whether having a hair buried in the dirt for a month can create something that looks like, so what? This hair wasn't in dirt for a month. It was in the back of a car. The point is that that hair was from a dead body. Now, how do we know that that was Kaylee's body? Two ways. The first is by mitochondrial DNA. Mitochondrial DNA testing was done on the hair and also on Casey Anthony. That mitochondrial comparison proves that that hair came from some maternal relative of Casey Anthony, which means it had to be either from Kaylee, Casey, Cindy, Lee, or Cindy's mother. Okay? Well, we know it's not Casey's because it's too long and Casey's hair is treated. So we know it's not Casey's. We know it's not Cindy's because it's the wrong color, it's not treated, and it's too long. We know it's not Lee's because it's too long. Lee's hair is short. This hair is 9 inches long. And we know it's not Cindy's mother because Cindy's mother, well, let's see, Cindy's mother had been in the car once, but Cindy's mother's hair is treated. And this hair is not. This hair could only come from Kaylee Marie Anthony. And remember, the testimony is that the hairs actually taken from Kaylee's body also had the band, just like the hair from the trunk. The only difference was the hairs from the body, the roots had actually completely decomposed, where one in the trunk had not. As hard as it is to accept, when Casey Anthony was at Blockbuster on June 16th, walking arm in arm with her boyfriend, Tony, Kaylee was in the trunk of her car in the early stages of decomposition. When Casey returned to the house on the 17th or 18th, she backed her car into the garage with the intention of burying Kaylee in the backyard. She went to Brian Berner and borrowed a shovel.
That was
Based
the
upon
neighbor. We
the
didn't cover
dog
that, by the way. Sorry.
alerts in the backyard, she in all likelihood actually took Kaylee's body back to the backyard and set it down for a period of time. Was digging too much work, perhaps. And she decided instead to toss Kaylee's body in a swamp. The evidence in this case proves beyond any reasonable doubt that Casey Anthony decided on June 16th that something had to be sacrificed, that the conflict between the life that she wanted and the life that was thrust upon her was simply irreconcilable, and something had to give. She chose to sacrifice her child to live the life that she wanted. She took her child, she took her life, and she put her in the trunk and forgot about her. After a couple of days, she couldn't forget anymore, and she disposed of her body in a swamp. These are the facts that you have heard, and these are the facts that prove beyond a reasonable doubt that Casey Anthony is guilty of murder in the first degree, and that murder is premeditated. The defense says and will say that we can't prove how Kaylee Anthony died. Let me echo the words of Dr. Jan Garavaglia, the medical examiner in this case, when she said, there is no good reason to put duct tape over the face of a child. Why would you put duct tape over the face of a child? Well, there's two reasons. One is perhaps to silence them. But then why do you need three? Remember, in this case, there wasn't one piece of duct tape placed over Kaylee's face. There were three, overlapping at angles, placed over her face. Why do you need three? What does three do that one does not? One would certainly silence her if for some reason that's what you wanted to do, as brutal as that would be. Why do you need three? You need three because your purpose is not to simply silence the child. Your purpose is to make sure the child cannot breathe. The first piece goes over the mouth, but that doesn't secure the nose. The second piece goes over the nose, but you could still have some gaps. So you have to be thorough. You have to have three. 1, 2, 3. And then the child dies. There is simply no other reason. There is no other justification. There is no common sense. There's just no reason to put duct tape over the face of a child, living or dead. And that, ladies and gentlemen, is proof beyond a reasonable doubt of how Kaylee died. Because there simply is no other explanation for why you put duct tape over the nose and mouth of a child. And based upon the photographs you have seen, it is crystal clear that that's where the tape was. That the medical examiner told you, the forensic anthropologist told you that there's no question that that tape was on Kaylee's face before her body decomposed, because otherwise the mandible wouldn't have been in place, and it was. You can see the photographs of the tape. I don't want to show them to you again. You can look at them in deliberation, but you can see the photographs. The duct tape is curved slightly under the jaw. There are even strands of the duct tape that go under the jaw. That tape was placed there with one singular purpose. Now, we can only hope that the chloroform was used before the tape was applied so that Kaylee went peacefully, without fear. But go she did. And she died because she could not breathe. She died because she had 3 pieces of duct tape over her nose and mouth, and she died because her mother decided that the life that she wanted was more important. This murder was premeditated, and the defendant is guilty. Thank you.
We are going to start.
Okay, ladies and gentlemen of the jury, we're going to take a 15-minute recess at this time. I'm going to ask you not to discuss
the defense.
this matter among yourselves nor with anyone else. We'll take a 15-minute recess at this time.
This is always recorded if you have somewhere else that you need to be. Although I greatly appreciate you guys sticking in here with me, the whole goal has been for me to move forward with another case. And I think that with what I've been doing over the last couple of days, I have been taking time stamps of the current case that I would like to cover. And I believe that I will be able to get us up to date by the end of the week, because there's so much bullshit, there's so many breaks. And that's why I don't like to do current trials. I prefer to go in a little late. But that's just been my plan that I've been keeping to myself. With that being said, there's a lot that the defense puts forward here, and then the rebuttal. And so I'm not going to be able to get through all of it tonight, but we are going to start it. And in doing so, I am going to start it. I need to use the restroom. I will be right back.
Two objections.
Okay.
To exhibits.
Oh, wait.
What do I need to come down and see something?
Do I need to come down there and kick your ass?
Excerpts from a deposition is not an evidence, so I object to it.
I will say that these excerpts were read into the record in testimony, and I can qualify them by saying such, Your Honor.
This is actually, there's also a page here that's not an evidence, so
oh my God, go get your tampon. Stop it.
I've instructed that the exhibits are for demonstrative purposes only, and they should rely on their own recollection of the evidence. In fact, I would even be more than happy to say so.
It has portions that are not discussed at all.
We have
I
entered.
don't even think they could read
Just
that.
a second.
Yes, sir. I'm sorry.
One at a time, Mr. Ashton.
I can read it. I think anyone else would. I actually thought that great, but that's an argument. This elevates it to a level above just a question being asked. This is an actual part.
But there's 93 of you, so we're doing pretty okay.
You don't have any problem with the excerpts.
It's because you said I'm pretty.
Well, yeah, I do. For the same reason I have problems with the other quotations, because clearly this isn't clearly this is not counsel's memory of what was said. This is an actual photograph of the deposition itself. So I mean, the other ones we can say, well, he can say, well, this is my memory of what they said, but clearly this is the actual deposition itself. And counsel necessarily didn't say it that way, it wouldn't be the same. So they have to rely on what he said, not what that was said.
I don't think the standard is someone's memory. If I wanted to write down exactly word for word what a witness said on the witness stand, I could do so and regurgitate that in argument. This is argument to the jury. This was actually admitted in trial and testified about, and that's what I would like to do. I, of course, agree that it should be noted that they should rely on their own recollection as to what I'm telling them. Like, same for Mr. Ashton. He made numerous statements that
he did good or bad.
Okay. Anything else, folks?
I think so.
He thinks
What I
that
would do
he is.
the portion of the page, Mr. Ashton is exactly right. Put some white paper on that. Yeah.
Even if you're not.
I don't think it's out of order.
Okay, I'll be right back.
Here is a sideways. There, the photograph in the middle is not one that's been introduced as evidence. It shouldn't be used in any way, shape, or form during the argument. Certainly, as argued as it relates to the previous exhibit, counsel can make reference to what he apparently is going to term imaginary friends.
Who's the
However,
photograph in the middle?
well, we don't know, but we can assume from the looks of it. that
Looks
it's
like
a
Miss Anthony at some
young-
stage. Well, probably wasn't the best photograph to choose, but how is the state prejudiced?
Well, because it makes her look young and that it's some sort of childlike invention that she has come up with these individuals as opposed to a picture of her at age 22. One of the photographs of Ms. Anthony that was objected to was a smiling photograph taken at the Orange County Sheriff's Office because it had no relevance to the case. If they want to substitute that photograph of a smiling Casey Anthony on July 15th or 16th of 2008, that might be more appropriate than having a picture of a child with an argument that her lying is childlike and that she creates these individuals. It's not even a comment on the evidence because I'm going to guess she's in 8th grade in that picture.
What is the date of the photograph, folks?
I don't have the exact date of the photograph, Judge, but it is Miss Anthony is a young woman.
That doesn't answer my question. How old is she in the photograph? What is the date of the photograph?
Find out and see if I can get the approximate date.
Representations obviously aren't accurate either, even though they're caricatures. There's no testimony about Eric Baker, as I recall.
There was. Again, Judge, this is our case. This is.
I just need to know when the photograph was taken, folks.
Was taken.
It's a school picture. Somebody knows what grade it is.
Mrs. Anthony here. There you go.
Like 11th grade.
No, I'm sure she's wearing makeup.
Is it a school picture or is it when she was age 22? If it was age 22, then fine. But if
Can Mrs. Anthony come forward?
just take it back there to her.
One,
Yeah, I
Judge.
got- here. Yeah, I had to take that out.
It was 2001. The events happened in 2008. And I won't be it's just a photograph of Miss Anthony. And I would note that these imaginary friends were testified that they were at least 2 years in existence.
I don't care about the imaginary friends, but what troubles me is you got a photograph from 2001 as opposed to something at age
Love to be 22.
22.
You fucking kidding me?
Or even 21. But how old was she in 2000?
Are we still
I would say
deliberating?
it's 17, something along that.
Nah.
16, 17, I have no idea.
Well,
I don't think she's 14.
well, I don't care about the imaginary friends, but that they're just distorts reality.
May we have a moment to replace it with another photograph?
You may. Anything else?
What did they put up there that was so offensive to the sensibility?
He had a book of photographs, other things I think that he was going to have through a PowerPoint. Have y'all had a chance to look at those?
Meeting
the one
of
that I came up and looked
minds
at that he flipped through? Okay.
We're not showing any other.
And the one thing that we did agree was that for some of the printed matter in
100%
there
will cover
that there are his statements.
for myself and for my friend.
Okay, right. Okay, just a reminder to everyone, once we start giving the jury the final instructions,
I love
no one will be permitted to leave or enter. So if you don't want to stay during the entire time, you will have an opportunity to leave. But once I start reading the charge to the jury, no one will be permitted to leave or enter or move or about.
Which one? This or that? One or 3, 2, 1. No, remove.
And both sides saw how much attention you paid to the presentation of evidence in this case, and it hasn't gone lost on us. We all have recognized that. And I want to thank you both individually
This
and
or that.
collectively for that great sacrifice that
Green
you've all
or
made.
black.
Thank you. Here we are at the end of our journey, and I have to tell you that I probably think you have more questions than you have answers. And if you recall at opening statements, the final thing that I told you at the end of the day, when everything is said and done, the one question will never be answered. The key question in this case will never be answered. It can never be proven. And that is, how did Kaylee die? That's why we're all here. Really. There's no dispute that Kaylee is passed on. There's no dispute whatsoever about that. So really, the key question, as it relates to all manslaughter, child abuse, and murder charges that you're going to be presented with,
4 to
is
1.
how did she die? What happened to her? What is proven beyond and to the exclusion of every reasonable doubt? Not just some, but every single one. And those questions were never answered. That evidence was never presented to you. In fact, there was a great deal of things that you were probably looking for and never received. Now, I'd like to explain to you that this is my last opportunity to speak with you individually.
Yes, sir.
After I am done, Mr. Mason will then stand up and cover the jury instructions and the law. And then I will have one last opportunity to speak with you. But generally, this is our moment. This is our opportunity to show you and explain to you what we think the evidence showed in this case. The state, after we're done, will then be able to get up and have what's called a rebuttal argument. This is the hardest point for a defense lawyer because I can never come back up and respond. And the reason it's done that way is because the state has the burden of proof here. So they get that last opportunity. They have the burden of beyond and to the exclusion of every reasonable doubt, which is the highest standard in American jurisprudence. It is the highest standard that must be met. So that is why they're afforded that opportunity to have the last word. It wasn't because we tossed a coin and they won. It's because it is their burden. And you'll recall when I told you in the very beginning, when we did the jury selection, I had the unique opportunity to speak to each and every one of you individually. I told you, it's not a two-sided affair. The state has the only burden here. And while the defense did put on a case and did put on evidence and testimony, it was never required to do so. We could have sat back, not questioned anything, not one single witness, and did absolutely nothing throughout the course of this trial. And it still would have been the burden of the state of Florida to prove every element in every charge. And you'll recall when we talked at jury selection, we talked about elements and what they mean. And Mr. Mason is going to come up and give you a little more detail as to that. But that's the same burden, beyond and to the exclusion of every reasonable doubt. And it's done that for obvious reasons. We're here for a serious matter. You all left your homes to come and resolve a serious question of fact. And if you were not given the facts you need, your guidance will be the law. The law will guide you as to what your decision and what is a legal and just decision. Judge Perry will tell you that what is important is that you follow the law. We all have laws. We all have lived by these laws for many years, and no one has the right when deliberating to base their decision on emotion. Now, what I'd like to talk to you about and how I've broken down my final remarks to you are, I'm going to start with my biggest fear. I'm going to tell you right up front what I fear may happen in this case. I want to talk to you about it and explain why I feel that way. I want to then outline the state's case. I want to talk about it piece by piece. And my presentation will be a little bit longer than Mr. Ashton's because I want to actually show you what I think the evidence showed. Now, you're going to have to rely on your recollection of how the evidence was presented. It's true. What we say is not evidence, but it's a guide for you to look at the evidence from a certain angle and a certain perspective. There were lots of delays in this trial. There were times we went at sidebar. There were times objections were raised. What you have to look at the evidence by is by what actually was testified to. And sometimes it came out a little odd. Sometimes it didn't come out with as much cohesiveness. And the presentation wasn't as fine as both sides would have liked it to be. I certainly know that was the case with us. But the problem is this is the purpose of us coming up here and talking to you, to show you, we think this has a connection to this. We want you to pay attention to this fact because of this and what came on later on, and try and tie it and piece it together for you so you can look back and say, yes, I remember that happening, but when it happened, I wasn't so sure what it meant. But now that you explain it, I understand what you're trying to say and what your point is. So that's the purpose of what I'm going to do when I talk about the state's case. And then I want to talk about the defense case, the presentation that we put on, even though we weren't required to do anything, even though the law says that the defense has no burden and does not have to prove anything.
This is important because, oh God, I'm almost tempted to show you guys the juror interview first so you can listen to what Baez says and try to get the perspective of a juror that was there for almost 2 months. They came to a verdict on July 5th. They started like what was it, the first week of May? Because they were there for Memorial Day. So I don't know.
Then after that, as I mentioned, Mr. Mason will get up and explain what the charges are and explain what must be proven, and also explain the judge's instructions to you and how they apply to the defense's case, how they apply to the state's case, to try and give you an understanding. We realize while you're all very educated people, you're not skilled in the area of the law. So this is something that we want to use to assist you in that regard. And then finally, I will have my last remarks that I think are something that are points that I think you should also consider before we sit down. And as I mentioned, it is going to be the toughest time when midstream verdict goes up, but you have to understand the reason why.
I'm sorry.
Now, let me start with my biggest fear. And that is that this case deals with so much emotion. I know that there were times where every single person in here felt something deep down inside. The law gives us a guidance as to what we should do when it comes to emotion. And that is your rules of deliberation. What the law is that this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And that's because, obviously, we want you to base your verdict on the evidence, not on emotion. And while there were times where emotion was directly pointed at you, where things were done to draw into your emotion, to get you angry at someone, to get you to discriminate against someone because they didn't act the way they should have acted. They should have acted. They didn't conform with what we think is right or normal. They're different. And that is not what the law is. The law says you must base your verdict on the evidence, not on emotion. And it's my biggest fear because it's such a difficult thing for you to push aside. Kaylee Anthony was a beautiful, sweet, innocent child who died far too soon. There's no doubt about it, and that is not disputed by anyone. But to parade her up here, to invoke your emotion, would be improper. It's improper under the law, and it's improper as to the rules of your deliberation. And I submit to you that that is the strategy and the way the state presented this case. They started with, well, let me just start with Mr. Ashton's remarks to you today because they're the most recent in your mind. Mr. Ashton started out showing you a video of little Kaylee, started talking to you about parenting, started talking to you about what a mother should and should not do. He went on for a great length of time talking about this beautiful child, not on his evidence, not on the evidence that was presented before you. It was to set up the emotion for what was to come. And that is exactly how this case was presented. They didn't come right out the gate and show you the evidence. They gave you 2 weeks of testimony that was completely irrelevant and served only one purpose. And that was to paint Casey Anthony as a slut, as a party girl, as a girl who lies, and has absolutely nothing to do with how Kaylee died. And you would dishonor the law and even Kaylee's memory if you were to base your decision on anything but the evidence. And to use emotion to get you angry is improper. And here's the proof. And Judge Perry will read that to you. It is rule number 3, but I ask that you make this rule number 1.
He's not wrong.
The state came out and paraded all of these people. But what was unique is throughout that process, everyone kept coming back with the same thing. Casey was a good mother. Kaylee loved Casey. And what was funny is I wanted you all to see something, and you may have wondered why I asked certain questions. I asked many of the questions as to how did Kaylee react to Casey? Because I thought it was important that you understand that, of course, a child cannot fake this. A child cannot fake love. A child knows when it loves someone, it behaves a certain way. And I brought those questions out, and I asked them from both angles. How did Casey treat Kaylee, and vice versa? And what this did was, it wasn't to appeal to your emotion. It was specifically directed at the child abuse charges. We were here for a couple of months, at least 6 weeks, as Mr. Ashton pointed out. But you didn't hear one single instance having anything to do with child abuse. Not one. And this prosecution was geared in such a manner that it was deliberate, it was methodical, it was thorough, and it was detailed. You saw during those 30 days, every movement of where Casey went and every single thing she did. And if there was one instance of child abuse, you would have heard it. You would have seen it. You would have been able to, it would have become clear. So if you look at these child abuse charges, ask yourself, when did someone get on this stand and tell me or demonstrate in any way that Kaylee was abused. Child abuse cases are sad.
Wir
and they're
haben
one of the most horrible
Media.
crimes imaginable. But one thing's for certain, if there's an abused child, people know it. People see bruises. People see different things about that child. They will see there will be broken bones at times. There will be different instances. But there was nothing other than the fact that this child was loved and well taken care of. And from one moment to the next, something happened. Something changed. Something changed that will forever change the life of Casey Anthony. And something forever changed that ended the life of Kaylee Anthony. It was sudden and immediate, not deliberate, not repeated, not premeditated, but something from one moment to the next. You have to rely on the evidence. What came forward? What was put before you? I agree with one statement that Mr. Ashton said, is you can't speculate. Don't speculate. Don't guess. It has to be proven to you beyond and to the exclusion of every reasonable doubt. If you don't know what happened, it wasn't proven.
Yes.
We don't want you to tell us what you think happened. We want you to tell us what was proven happened. And that's the difference here. Because you know what? We can go on and speculate all day long as to the different theories that were posed before you, as to the different possibilities. But the truth of the matter is it must be what was proven. There are no mysteries to solve here. There should be no mystery before you right now. If you have questions, then it was not proven. And that's as simple as it goes. It's as simple as it gets, because that is exactly what is done. Now, you have seen this checkbook prosecution where they spared no expense, utilized the finest crime labs in the country, the FBI laboratory, but yet with all of the resources, and used not only established areas of forensic science, but created new ones that were never testified before in front of a jury. You are the first jury to ever hear some of the evidence in this case, this type of evidence, air evidence, the very first. You're the first ones in the state of Florida to ever hear hairbanding evidence. You're the first ones in the state of Florida to ever hear a trainer testify about his dog. You're the first one to ever hear any of these types of evidence. And that's what I told you from the very beginning, that this prosecution would raise to the level of desperation to make up for their lack of evidence. Now, back to what I was saying with their initial setup, the way the case was presented the first couple of weeks. You see, the strategy behind that is if you hate her, if you think she's a lying, no good slut, then you'll start to look at this evidence in a different light. You'll start to, oh, wait a minute. Maybe I'm seeing something that's not there, and start to actually discriminate against her rather than give her the standard that is afforded to each and every citizen in our country. And that is that the government come in here and prove their case beyond and to the exclusion of every reasonable doubt. But you can get away with that if we can get a jury to hate her. We can get away with that if we paint her in a certain light that has nothing to do with the evidence and more to do with who she is. I told you at the very beginning of this case that this was an accident that snowballed out of control. And while it was a very common accident, what made it unique, what made it different, is not what happened, but who it happened to. And you all sat here and saw some bizarre things throughout the course of this trial. Bizarre things that have been going on long before Kaylee was ever born and throughout her early life.
Oh, yeah.
You saw all of these things. This is not stuff that is new. There's something wrong here, something not right. And that's what makes this post-death behavior relevant. It explains it. But at the end of the day, it is irrelevant to the number one question that you all came here to answer. How did she die? And I will jump and piggyback off of what Mr. Ashton said and ask you not to speculate as to that fact.
I've never seen a more confident man in my life. Swear to God.
Now, I want to start with the car. Okay. And what's unique about the car is, again, what I told you at the very beginning. The car does not shed any light on how Kaylee died. Period. And I told you all, it will double the length of this trial, if not triple. And I think I showed you that ended up being true. All of the discussion that came around with being irrelevant evidence ended up being posed as to the car. Now, and I say that for this, because what the car does is it tells you how Kaylee may or may not have been transported. It doesn't explain how she died in any way, shape, or form. And you may be asking, well, why did you spend so much time fighting it? Well, we weren't about to allow the state to put a square peg through a round hole. And that's that. Because there are just as many questions as there are answers relating to the car. Who had possession of it all the time? Did George Anthony have access to it? And there was testimony that came out. And was there, in fact, actually a body in the back of the car? But at the end of the day, we come back to, does it tell us how she died? No. We all know Casey acted inappropriately and did it and made some mistakes and bad decisions. She should have called the police. She should have not attempted to block this out. She should have reported her death. There's no doubt about that. And that question was never contested. That issue was never debated.
First thing is the car.
But if there are crimes associated with those acts, the state of Florida has the ability to charge her with whatever crimes they feel those acts warrant. They don't have the right to overcharge or inflate a case, to make it something that it's not, just because it's entertainment, just because everybody wants to know, just because there's some mystery. You heard tons and tons of evidence of how this case, the media, and the way it was portrayed, and the way it.
So wait, what he said, just to make sure I'm correct, and we heard the same things. He said the state couldn't prove that Kaylee was dead in the car, correct?
All came about, how it influenced people's actions, decisions, for both sides. But we can't lose focus of what actually occurred, and that's the answers that you're supposed to answer here for us during your deliberations.
PSA program campaign about crazy bitches.
I want to start off with the issue of the car. Now, you'll recall, I used these boards during my opening statement when I explained certain things. And I think going back to them will kind of help you with the timeline of things. You'll recall that on the 27th, actually, you'll recall that Kaylee was last seen on June 16th, according to George Anthony, the testimony of George Anthony. Now, I will remind you that the indictment reads from June 15th, not June 16th. And that is very important for you to consider. And that raises the question is, does even the state of Florida believe that she was last seen?
The indictment itself is not evidence. It's charged in a way that says between.
Sustained, let's move on.
I know it's an old trial.
Look at the indictment. Look at all of the instructions. Sir. You'll recall Tony Lazaro testified that, and he was the young man that was dating Casey. And you'll recall that on the 20th of June, Casey ran out of gas. And Tony went to the apartment Tony went to help her get gas. They went to the Anthony home, and in the back of in the backyard, there is the shed where they got the gas cans from. You'll recall his testimony, and his testimony was clear that when they went to pour the gas, Casey did not try to block him away. Casey did not say, "Hey, don't get near my trunk." In fact, they poured the gas in the car. They opened the trunk, and they put the gas, and she put the gas cans in the trunk of the car. She could have easily put them in the front seat. She could have done whatever she wanted. She could have told him, "Go away, I've got this." She could have never gotten assistance from Tony Lazaro at all. If she had a body, as suggested by the state, in the trunk of the car, or if the smell had been there, this young man would have smelled it. Remember, he put up with his hand and he went like that and he said, "It's right here." You've seen pictures of the car. The gas gauge, the place where you put gas in the gas tank, is right next to the back of the car. Why didn't he smell it? What happened there? Well, there's a reason for that, and that's because the car didn't smell at that time. That's the only logical conclusion. You'll also remember a young lady by the name of Maria Kish. She was a very attractive girl with glasses, one of Tony Lazaro's roommate's girlfriend. You may not have noticed the bombshell that hit when Mr. George asked her about ever getting in that car. He got an answer he didn't expect, and that was, "Yeah, I was in Casey's car." And was it during the time that she was living with Tony? And she answered yes. Remember, they all went to McDonald's. All four of them got in that car, and Maria and her boyfriend sat in the back seat, and they didn't smell anything. But yet, 2 years later, it still smells, and all of these people are smelling the smell. Why wouldn't it smell that bad when it was most recent? Why is it not smelling to these people? And we're going to get into who smelled what, but take that into consideration when you look at this. Then you'll recall the incident with the gas cans.
Oh, I like that they're doing the calendar.
That was reported missing to the police on June 24th.
Okay, so that was
I labored over these gas cans throughout this trial because I think the issue is obvious. Who in the world reports gas cans missing?
Right?
Not even in the state of Florida. How many times in the United States has someone called the police and said, "Someone stole my gas cans"?
Actually, that's a
And
very
why
Ohio thing
is
to
that
do.
duct tape on there? And why are there so many lies surrounding that gas can and that duct tape? It's not a coincidence. If so, it would be an incredible
Do you
coincidence.
guys do that with your gas cans?
You couldn't have
For real?
odds
We
worse
don't.
than the lottery. That's how bad it is. Then the car is towed on the 30th.
I need a big calendar.
You recall Mr. Simon Birch testifying that after 4 days, they sent out their notice. So what happened this entire week? Why did Mr. Anthony wait until the 15th to pick up the car? Why? Remember this fact. Mr. Birch said when George Anthony went to pick up the car, he showed up with a gas can. He knew the car was out of gas. And an important and even more important fact that you should remember is not only did he know it was out of gas, he knew that the car had been at the Amscot for 3 days. Remember that? He said, Mr. Anthony told me that it had been there for 3 days. And I asked him, would you have known it was there for 3 days? No, as tow people, we just go pick up the tow yard. We would have no idea how long a car's been at a certain place. But he told us it was there for 3 days. Well, even though Mr. Anthony heard.
Hold on, I look really fake. No. All right, I just wanted to see if the big filter thing was on, because I hate that shit.
That testimony, he got up here on the stand and he said, I called when I got to work. I found out that it was there 3 days when I got to work. And I asked him, did you call Mr. Birch to let him know that it had been there for 3 days? He said, no. So how in the world did Mr. Birch know that the car was at the Amscot for 3 days? He knew because George Anthony told him. George Anthony knew that that car was at the Amscot. He knew that that car was out of gas. And he showed up to pick up the car with his key. And when he got there, you all remember, he smelled the smell of death. He smelled the smell that you never forget. And of course, he did what every responsible parent would do, and that is nothing. Just go home and go to work.
Woof.
Nothing. Don't call to find out if my daughter is alive, who I have not seen since the 24th of June. I don't call to find out if my granddaughter's alive, since I haven't seen her since the 16th. He didn't do any of those things. And that's because he wanted to distance himself from this situation. And he knew. There's evidence of that. That was all presented to you. He knew something. He knew she was dead. This evidence doesn't make sense. And if the state of Florida had done as much work trying to track the comings and goings of George Anthony as they did Casey, you probably would have seen more. You probably have more answers, but you don't. Now, July 15th comes around. Let's take these out.
These guys just look like such tools, like not having a woman up there to do such, like a woman thought
July
of this.
15th comes
Sorry,
around.
guys.
And as Mr. Ashton points out, all hell breaks loose. Now we take a look at who actually smelled what in the car. You have CSI Bloisey, who testified, depending on who was asking the questions, you may recall. If Mr. Burdick was asking him, oh, it was human decomposition. When I was questioning him, oh, it was decomposition. So he went back and forth. You may recall that time. You have Deputy Forgy and his dog, who was advised that this is the suspect's vehicle. And you may recall we did this small thing where I had each and every person who witnessed this dog inspection, and they all said there was only one car. But yet Deputy Forgy lied to you, and he told you there were two cars. If you believe him, you have to believe that Yuri Melich, Michael Vincent, and Gerardo Bloisey were lying to you. Michael Vincent, the other CSI person who says he smelled a dead body. Mr. Arpad Bas, and we'll get into him a little later. Cindy Anthony, who said that during her 911 call, but yet said so because this was her third call and she wanted the police to get there quicker. Simon Birch, who runs the police tow yard. Now, you may recall that Mr. Birch didn't make his statement until 9 days later after it was broadcasted all over the news and in fact referenced news reports during his statements to the police. You have George Anthony, who did an incredible job of pointing out to Yuri Melich the first night upon arriving, as soon as he arrived. And of course, you have Dr. Neil Haskell, the $40,000 man, the entomologist, who explained several theories. Now let's take a look at who didn't smell what. Karen Sanchez, the manager at the Amscot tow yard, the Amscot check cashing place where the car was. You may recall she said she smelled garbage. Tony Lazaro,
Sandwich.
who went and got Casey, got the gas cans for Casey, and was actually right near the trunk on the 20th. Charity Beasley, the police officer who picked up the car and took it to the tow yard. Maria Kish, the girl I spoke about earlier, who sat in the back seat with her boyfriend, Clint House. He didn't smell it either. Sergeant Hosey. Now, he said he smelled something. He's a sergeant. There's a missing child. He's at the home. He's hearing lies. But yet, he didn't think it was sufficient to call the crime scene investigators. Why? Because the trash seemed like a plausible alternative. It was understandable if trash is in the trunk of the car for 3 weeks, that is probably the source of the odor.
Ow, ow.
Deputy Ryan Eberlin, this was the young man who handcuffed Casey. He said he didn't smell a thing. Yuri Melich, the lead detective, who, again, like Hosey, was advised by George Anthony and still did nothing. His name is escaping me. Fletcher, yes. Rendon Fletcher, a corporal who said he did not smell anything and came in and out of that garage and that the trunk was open. Adriana Acevedo, another police officer who was there, that said she did not smell anything. Now, I know you heard a lot of evidence about the smell of this car. And if you look at, once Casey is arrested, how many people you have to eliminate.
How many people were there?
You didn't do anything. Cindy's explanation of the reason why she said that, at least one person. And even if you look at all of these people and give them the credibility that they deserve, you still have an abundance of people who did not smell something. This is a reasonable doubt. When you have this many people who are telling you a certain thing, you have to have some doubt. This is not one individual, like her boyfriend, who's trying to protect her. These are a significant amount of people from various backgrounds who have no interest in helping Casey Anthony. And that's why you need to consider this. And that's why you may have a reasonable doubt as to who smelled what. Now, the state of Florida talked to you and presented to you a neighbor by the name of Brian Berner. You may recall, this is the individual. He was a heavyset guy. He came up here and he testified about Casey borrowing a shovel. Now, if you think about Mr. Berner's testimony, you may recall that the police told him to close his eyes and try and remember the day that this all occurred. You'll recall that Mr. Berner didn't see what was done with the shovel. You'll recall that the shovel was borrowed for 45 minutes. And you'll also recall that Casey came back and she wasn't sweaty. And what the state wants you to believe is that Casey Anthony, in broad daylight, was going to go borrow a neighbor's shovel, even though you all saw that they have 4 or 5 of them in their shed, and bury her child in the backyard. Is that reasonable? How does that even pass muster at all?
Oh.
Now, I think what maybe my colleague's response was, well, look at all of her actions. They're not rational.
Isn't that supposed to be a no-no?
And I would agree with that.
On both sides?
And Mr. Ashton said something very interesting. Bury her like
Very
she
important.
buried their pets. Okay. Well, I will get back to that in a minute, but I'd like you to remember that. But
If you
okay,
don't, you're a
let's
sick
speculate now.
criminal.
That's what they're doing. They're saying, come, let's go speculate as to what happened with this shovel. You can easily speculate that Casey took that shovel and tried to open up the shed lock to get the gas cans. You can easily speculate that she was doing whatever with that shovel. But that shovel was tested. That shovel was inspected by the FBI. And we brought you the evidence forward, not the state of Florida. We had the people from the FBI who inspected the shovel. And there's absolutely no evidence, no DNA, no hairs, no soils that match the actual scene. There's no evidence of that. So let's just speculate, shall we? That's not proper. That's not the law. And that's not your job. But yet that's what they want you to do. That's what they're asking you to do. Now, you saw tons of testimony about the trash and the garbage. And I can't count how many times I brought this up to you and showed it to you and said, take a look at this. And I brought it to you because I think what's important here for you to remember is that this evidence was changed. This evidence was altered. Whatever evidence could be used to exculpate Casey was destroyed, put intentionally into a dry room. You don't know what food is in there. All you know is they want to dry it out. They want to, and you were passed a Velveeta cheese with fingerprint dust on it. You remember that? That black powder? Fingerprint dust. They want you to know who cut the cheese. But they don't want any other evidence to come out as to what was actually in the trash of that car. And Mr. Ashton can do his little show all he wants and show them the garbage and say, where's the spit in here? Well, we could see there was spit there. Where's this? Could this create any smell? Well, of course you can't find anything because it was altered. It was destroyed. And that's not what a police officer's job is to do. That's not what crime scene investigator Vincent and Bloisy should be doing. They should be preserving evidence, photographing evidence, documenting evidence so that you can make an intelligent and just decision, so that you can have the evidence you need to carry out and answer any question as to what was in this garbage, what chemical compounds could come out of it. And they went out and did the air test 6 weeks later from this. How absurd, how outrageous, how unjust could that be? Now, one of the things that I will point out to you in much more detail is the issue with the computers.
Computers.
And I will get into the detail of the state's, the very heart of their premeditation, as they like to call it, having to do with what you heard and how you were misled in a certain direction. But I'm going to get back to this when we cover that evidence. But this evidence will so infect the quality of their case, like a cancer, that you will have no alternative than to render a verdict of not guilty. Actually, Judge,
The confidence, like I said, it's
Okay, ladies and gentlemen of the jury,
wild.
we're going to recess for lunch at this time. Please remember, do
You know
not
what?
discuss
That's
this
a
case
good
among
time.
yourselves nor with anyone else. Any additional instructions on behalf of the state or the defense?
No, sir.
Okay, we'll be in recess.
All right, wait. The first three. Yeah. It's a good time. It's a good time. Okay, guys. Actually, and don't think more about this. I just need to do something on my end. So I'm going to hit play so I don't have to talk to myself.
Okay, you may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys. Both sides are ready to proceed.
Yes, Your Honor.
We miss you, Mr. Baez.
I wish I could say the same. I do have one issue that I'd like to bring up.
Yes, sir.
I apologize, but I continue to see Mr. Ashton's facial expressions as I'm doing my closing arguments. And I would ask that he refrain from
That's
showing
what I
gestures
kept
or
saying.
something, whether he approves or disapproves of what I'm saying. I think the court's been clear about its order, and I would just ask that
Well,
that
with the signages, I can't see Mr. Ashton, but as I made it quite plain and clear, we don't need any facial expressions.
Exactly.
Approving, disapproving.
Either side. I
anything
want
else?
that
Anything
to be
else?
the case for both sides.
Okay, for those of you who may wonder why we took so long, remember we had to finish our charge conference, and unfortunately, the court reporter, while we were talking and munching on sandwiches during the charge conference, she was operating her steno machine, so we had to give her some time and some of the other court personnel some time to get a little something to eat. All right, both sides ready to proceed?
Yes.
Yes, sir.
And you've only used 38 minutes and 20.4 seconds of your 4 hours. So you have a long time to go, Mr. Baez.
Thank you, sir.
All right, let's return to jury. State recognized present of jury.
Yes, Your Honor.
Defense?
Yes, sir, we do.
Okay, members of the jury, did you heed all of my previous admonitions during your lengthy lunch hour? Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court, my colleagues in the prosecution. Good afternoon, ladies and gentlemen. I'd like to pick up where we left off, and we were talking about the actual physical evidence, whether it is or whether it isn't. I'd like to call this next phase the state's fantasy of forensics. And I want to begin with the trunk of the car and this phantom stain that the state has alleged is on or in the trunk of that car. I'm looking. We've all seen the photograph, and I don't see anything that would remotely resemble a stain of human decomposition in the trunk of this car. Now, again, this goes back to grabbing your emotions early on and hoping you'll see something that's not there. We heard evidence that there's no blood in the trunk of that car. We heard numerous tests. We heard Gerardo Bloisy talk about how thorough he was in examining the trunk of this car. You may recall he said he hasn't had a car in his entire 30 years of experience where he has processed it more than he did this car. And you heard Heather Siebert from the FBI talk about when tissue decomposes, it still has cell material. And they could have gotten DNA if there was DNA in the trunk of this car. And they certainly took swabs. They certainly tried. They certainly did everything they possibly could to generate something to let you know and to prove to you.
Okay, never mind. Too difficult. Thank you for watching with me tonight. Tomorrow, we'll be back here to finish Casey Anthony trial, finally. And we will begin a new trial. So 3:30 p.m. Eastern, right back here. I will create the live stream on my phone either later this evening or first thing tomorrow, so you can get a notification as long as you press the bell on my channel. When you go to subscribe, you have the option to get notifications, and it'll say like personalized. You got to do all. And it's not like I blow you up with notifications all the time. It's just my live streams. So make sure to hit all for the notifications. And what else? Yeah. If you are watching on replay, make sure to let me know. I appreciate it. And it was quite an afternoon. We don't normally go this long, like ever, but I really want to finish this up with time to spare tomorrow to begin our next trial. So I appreciate everyone in attendance tonight. Thank you, mods. Thank you for your support. If you donated or gave memberships, that's so greatly appreciated, or jewels. And before I forget anything else, I'm just going to hit the off button. Okay, guys, I'll see you tomorrow at 3:30 p.m. Eastern. See you later.